Tabling of documents. Dépôt de documents. Introduction of government bills. Déclaration des ministres. Reports from interparliamentary delegations. Présentation de rapport du comité. Introduction of private members' bills. Mr. Albus, seconded by Mr. Steinley, moves for leave to introduce a bill entitled An Act to Amend the Canada Post Corporation Act. This motion is deemed adopted. The honourable member for Central Okanagan, Similkameen Nicola.
Thank you, Mr. Speaker. I'm certainly pleased to rise today to table my private member's bill, Bill C-260, entitled An Act to Amend the Canada Post Act. Now, the title of the bill may sound simple, and that is intentional. That's because it is simple. This bill intends to amend the Canada Post Act to allow Canadians to order and enjoy their favorite wine, spirit, or craft beer from any province or territory from sea to sea to sea, without restriction, delivered to their doorstep by the fine employees of Canada Post. As it currently stands, many Canadians cannot find their preferred wine, spirit, or craft beer on the shelf of their local stores, and Canadian producers are unable to ship their product. Now, because of these archaic and outdated interprovincial restrictions that continue to vex this country, this not only stands in the way of the enjoyment of these products, Mr. Speaker, by all Canadians, it also hurts these small and medium-sized business by limiting who they can sell and ship to. Mr. Speaker, the COVID-19 pandemic has made it clear that Canadians feel more comfortable and safe shopping online or over the phone. This simple amendment would not only increase the happiness of Canadians, allow them to shop safely, but also help those small businesses that are seeing a sharp decrease in their local foot traffic due to the pandemic. Mr. Speaker, I am confident that all members in this place will join me in supporting this bill, enacting a simple amendment and open the taps to all Canadians. Cheers.
Mr. Albus, seconded by Mr. Steinley, moves that the bill be now read a first time and be printed. This motion is deemed adopted.
Reading of this bill, première lecture de ce projet de loi.
When shall the bill be read a second time? At the next sitting of the House. Introduction of private members' bills. First reading of Senate public bills. Motion. Présentation de pétition. Is she online? Okay. We'll first go by video conference. The honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker. Rising today in Parliament to present a petition dealing with an issue that is of grave concern to many constituents, and that's the issue of neonicotinoid insecticides and particularly their impact on pollinators. The petitioners call on the government to take action to follow the lead of the European Union, adhere to the precautionary principle, and ban the use of neonicotinoid pesticides in Canada.
Presenting petitions. Présentation de pétition. L'honorable député de Charlebourg.
The Honourable Member for Charlebourg-Haute-Saint-Charles. Thank you, Mr. Speaker. This morning, I am proud to rise to present a petition signed by Canadians to remind the government of the crimes of the Chinese Communist Party towards the Falun Gong community, and that sanctions be applied to those who have participated in those offences in one way or another. For more than 21 years, the leaders of the Chinese Communist Party have been orchestrating the torture and detention of many members of the Falun Gong movement, which preaches truth, compassion, and tolerance, including the murder of many participants in the Falun Gong movement for their organs in order to traffic them. For many years, Falun Gong members have been making representations, and members of all parties have supported those claims, and it's an honor for me to table this petition.
Member for South Okanagan, West Kootenay.
Thank you, Mr. Speaker, and I rise here once again to present a petition from young people from across my riding of South Okanagan, West Kootenay, and my neighboring riding of Kootenay-Columbia. These young people are concerned about the increasing impacts of climate change. They point out that the government's targets and actions are woefully inadequate, and they want jobs that are sustainable, not for short-term gain at the expense of future generations. So they ask the government to support their future with a detailed climate strategy based on science. They want to eliminate fossil fuel subsidies and redirect those funds to renewable energy, energy efficiency, low-carbon transportation, and job training. Thank you.
Presenting petitions, présentation de pétitions. We'll now go to questions on the order paper. The Honourable Parliamentary Secretary to the Government House Leader.
Thank you, Mr. Speaker. I would ask that all questions be allowed to stand at this time, please.
Any opposition to all questions being allowed to stand? Seeing and hearing none, agreed and so ordered. Orders of the day, ordre du jour.
Ordre du jour, ordre émanant du gouvernement, projet de loi émanant du gouvernement commune. Resuming debate at the third reading of Bill C7, an act to amend the Criminal Code, medical assistance in dying.
Resuming debate, the Honourable Leader of the Opposition.
Thank you very much, Mr. Speaker. It's my pleasure to rise on behalf of the Conservative Party today on probably the most important bill before this Parliament. And I can say that without knowing how long this Parliament will run, because this is a decision with respect to the state interacting with one of its citizens at end of life. Probably one of the most important debates this Parliament will have. And if there's commentary coming from the government or from some pundits on why we're late and why we're approaching a time limit, that was entirely in the hands of the government for three reasons, Madam Speaker. First, this government decided with no reason, no grounds to prorogue Parliament. We lost several months that could have been having substantive and compassionate debate on C7 and a range of other things. Further, this results from a Superior Court judgment in Quebec. Normally, something so fundamental would have been appealed likely to two higher courts, the Court of Appeal in Quebec and the Supreme Court of Canada. That was not done. It should have been. Most legal observers believe that should have been the case. And finally, Madam Speaker, and we may hear this from the government and the Attorney General today, they could have asked for more time, given the prorogation, given their own delays, given the pandemic. And I think they will end up doing that today, and that's appropriate. Nous sommes ici, nous sommes proches.
We are here today approaching a deadline on this legislation because of this government's inaction. The government was very slow when it came to an appeal in a Quebec court, and it also prorogued Parliament. And that is why we are approaching the deadline today.
I spoke on this bill 5 years ago, Madam Speaker. C7, when we debate the role of the state with respect to the end of life to one of its citizens, there is compassion on both sides of this debate. There are people that don't want to see suffering of someone near the end of life. We remember, and I'll speak to the Sue Rodriguez case when the Supreme Court was first charged with this, someone with ALS, Lou Gehrig's disease, losing their physical abilities, being confined in a horrible way and approaching end of life, and are they able to consent in the same way that someone would to make their own decisions about end of life? There's compassion on people that want the well-being of their loved one to be provided for. There's also compassion with people concerned about the state making determinations about the quality of life, Madam Speaker. In fact, the justice in Quebec quoted many speeches from the last Parliament on that bill following the Carter decision, including my speech, Madam Speaker, where I talked about the concerns about a slippery slope and that we would be back in a few years and more vulnerable people might be swept into a law. I'm sad to say that is exactly where we are, Madam Speaker. And as a parliamentarian, as a lawyer, as a father, As a son of a brave woman who fought cancer, and my profound memories of her at the age of 9 were from the palliative stage of that disease, I am here to make sure this is debated properly and that safeguards are provided for. So anyone that suggests we should be rushing this debate does not understand how profound this debate is. Le débat qui nous anime aujourd'hui.
This debate today deserves to be addressed with respect and compassion. This is not a normal debate on normal policies. We're talking about the state's power to take the life of a citizen after a request. That's an action of immense seriousness. And it's very important to debate this legislation in detail. What we're talking about here is human dignity and the value of a human life. I know that people on both sides of this debate are well-intentioned, but I fear that this legislation will become a first attack on our values. This is a path that we must not start down with this vague legislation that doesn't have enough safeguards, Madam Speaker.
This decision, where Justice Sapinka represented the court of the Supreme Court at the time in the 1990s, talked about the distinction of a passive role of the state and an active role in the state at the end of life. Passive, Madam Speaker, refers to palliative care, removal of and assistance with pain, and potentially non-intervention. Do not resuscitate. But the active role, when the state takes that role, attaches to Section 7 of the Charter, which is based on human dignity. In fact, Madam Speaker, the Attorney General who clerked under Peter Corey of the same court, even the McLaughlin dissent and the Corey dissent, both focused on human dignity with respect to Section 7 of the Charter, Madam Speaker. And all of them talked about the role of the state in protecting the decisionally vulnerable, as they were called, people that could be pushed into end-of-life treatment, where the state, these people feel like they're a burden, Madam Speaker. This has been talked about since the 1990s, and this Attorney General is removing the safeguards from our regime, Madam Speaker. Every ounce of case law on the issue of assisted dying, euthanasia, assisted suicide talks about protecting those vulnerable. That went on in the Carter decision, Madam Speaker, which reinterpreted and changed the stare decisis, the precedent of Rodriguez decision, because of societal norms. But the one thing that didn't change was the need for safeguards, Madam Speaker. In fact, the Carter court said, quote, carefully designed system of safeguards, end quote, was required, and that they would be scrupulously monitored, Madam Speaker. That is the only way the Carter decision changed the Rodriguez decision and allowed there to be assisted dying in Canada. But what this bill provides, Madam Speaker, is not assisted dying. This is assisted suicide, where the end of life, the reasonable foreseeable death is removed entirely, and they remove the safeguards, Madam Speaker, that every decision of the court on this subject has said are fundamental to the state having a role at end of life. Now, the Attorney General seems to be out of touch with the entire body of case law with respect to assisted death. And I think it's shameful that he is not allowing reasonable amendments to reinsert a scrupulous approach to the vulnerable, Madam Speaker. He's removing the 10-day waiting period. There is no coming back from this decision. And when the state plays an active role in the death of its citizen, the two-witness requirement is also removed. So this Attorney General, who is entirely out of touch with the case law in Canada, out of touch with the decision of Mr. Corey, who he clerked for, is rushing something, suggesting we're being unreasonable when all we want to do is safeguard the decisionally vulnerable. Something both Supreme Court decisions in Rodriguez and Carter said were critical to human dignity. Section 7 of the Charter, Madam Speaker. And what do all disability groups? All of them are opposed to this bill the way the government is presenting it because of the removal of safeguards and because of the redefinition. Inclusion Canada, Krista Carr, her quote, Madam Speaker, equating assisted suicide with an equality right is a moral affront. Having a disability should not become an acceptable reason for state-provided suicide. MAID should remain restricted to the end of life. In fact, one of the leading scholars that I would invite the Attorney General to review, Professor Grant from the University of British Columbia, said this: disability organizations hear almost daily from individuals who are considering MAID because of the appalling lack of state supports to make life tolerable. It may be because they are institutionalized, because they cannot afford treatment, because they are socially isolated. We have seen the social inequality of illness with COVID-19, end quote. So the government is a little upset that the Conservative caucus is demanding what two decisions of the Supreme Court have demanded, are asking for reasonably what Section 7 of the Charter is built upon, dignity of life, Madam Speaker, to make sure that we don't change the regime in a manner that I spoke about 5 years ago. A slippery slope where the decisionally vulnerable, elderly, isolated in a home, we heard testimony of some people feeling like they were pushed or pressured because of the cost, the lack of institutional care. Some of the professors and some of the Indigenous witnesses, Madam Speaker, who've raised concern, also raised concern about generational trauma, residential schools, people that are facing that trauma, that pain in their life. Is the state then going to provide assisted suicide as a tool, or should we help these people, Madam Speaker? This is about compassion. This is about an appropriate role for the state. And this is not about fundamentally changing a regime that has only been in place for a few years. So I said at the outset, Madam Speaker, there's compassion on both sides, but there is an entirely out-of-step approach from the Attorney General. In fact, the Attorney General, now the member for Vancouver-Granville, has also criticized the reckless approach of this Attorney General with respect to the post-Carter decision regime, because he's removing the safeguards that both courts have said need to be scrupulously monitored. 10 days, a few witnesses. All major disability groups in Canada agree with the compassionate and reasonable position being presented by my Conservative colleagues. I'm very proud of the advocacy we've shown. We've also been joined by legal scholars, Indigenous leaders, people working with people with mental health. I've worked on mental health and suicide prevention for many years, Madam Speaker, since my time in the military. We are also not providing enough palliative care support, Madam Speaker, going back to the original Rodriguez framework, where Justice Sapinka talked about the passive role of the state, allowing someone's life to end without pain and to be present, allow that family gathering at palliative. We're not doing that well enough. And this government has actually violated the spirit of the Carter decision by removing the safeguards. I remember, Madam Speaker, that the safeguards, the carefully designed safeguards, were fundamental to the Supreme Court Carter decision change from Rodriguez. Why, after a few years, would this government remove those, Madam Speaker? Particularly when some of the vulnerable Canadians, seniors and disability rights advocates, have said they feel under attack. In fact, Ms. Carr, another comment she made is C7 is their worst nightmare, Madam Speaker. So, what is the job of Parliament? we are not just delegates here to be polled. We're here to bring our perspective in the Burkean tradition of being passionate representatives for our community, for our family, for our values, for our point of view. And I can't think of a more important debate for us to bring those values. As the Supreme Court said back in Rodriguez and throughout, human dignity with respect to access to Section 7. And the early debate, both in Carter and Rodriguez, was always about we can't have an unfairness for someone who can't physically make a decision about end-of-life suicide. So we had to have an approach. That was McLaughlin's approach in the dissent in Rodriguez, Madam Speaker. She thought that choice was cruel with respect to Sue Rodriguez. It was never about just having widespread an approach to assisted suicide with no irremediable or reasonable foreseeable death being a part of it. Now this is opening up to a state-run regime with respect to suicide with vague terms about grievous condition or just disability writ large. And the same concerns I raised reasonably a few years ago, Madam Speaker. People with mental health issues that could get help if we're there for them. People that are vulnerable, decisionally vulnerable, as the court said for now a generation, Madam Speaker. This is why the safeguards are there. So what the government should do is not lecture us about timelines when they prorogued Parliament, when they didn't appeal a Superior Court decision on a fundamental issue just a few years after the Supreme Court ruled in Carter, and now they're ignoring disability advocates. They're ignoring Indigenous leaders. They're ignoring physicians, legal scholars, the opposition. And what are we demanding, Madam Speaker? We're not saying eliminate the system that was established in the last Parliament. We're saying maintain the safeguards. There would be no Supreme Court right under Section 7 of the Charter were it not for the safeguards. So, Madam Speaker, I'm proud that the Conservative opposition is not going to step away and allow our vulnerable to be forgotten. We are going to scrupulously maintain the safeguards that the state should have when we're making profound decisions about the end of life of our citizens. We are here for the people without a voice, Madam Speaker. We are here for the people who might feel coerced in isolation, in a pandemic, into an end-of-life regime without full capacity and consent. I actually think, Madam Speaker, if you step outside the bubble, I don't care what political party you belong to or associate with, I think all Canadians want to make sure the vulnerable are provided for. That is all we're asking. And so if we have to stay here for 24 hours a day, 7 days a week to stand up for those Canadians, we will do that, Madam Speaker. Who is being unreasonable? The Attorney General, who does not understand the entire body of jurisprudence with respect to assisted death? I'm actually very disappointed. Someone that was a law professor at McGill seems to have not read the Rodriguez and Carter decisions. He's removing safeguards that are fundamental to protecting the decisionally vulnerable as per Sapinka, McLaughlin, Corey, and the McLaughlin Court in Carter, Madam Speaker. Every single indication from the Supreme Court of Canada says that we cannot have an end-of-life assisted dying, assisted suicide, euthanasia, whatever words you use. That Section 7 Charter right cannot be accessed without a very carefully crafted and scrupulously governed system of safeguards. 10-day review period to make sure somebody wasn't at their lowest point and then the state moves in, Madam Speaker. 2 witnesses to make sure that there isn't someone vulnerable being forced or coerced into it, Madam Speaker. These are very reasonable amendments that not just Conservative MPs are asking for, Canadians are asking for. On a une approche raisonnable.
We have a reasonable approach on amendments to MAID. This is a crucial issue for our society. And that's why the official opposition is here for the most vulnerable members of our society. That's why we put forth reasonable amendments to help them, for seniors, for people with disabilities, for Canadians with mental injuries, facing health issues, their mental health issues, Madam Speaker. This debate is extremely important for the well-being of Canadians, and that's why I'm proud of my caucus, Madam Speaker, for having put forth an approach to C7 based on compassion and for the most vulnerable members of our society.
The government. Today, they may be asking for a delay from the court, something they should have done months ago. They should have appealed the decision or not prorogued. So the fact that we feel there's a deadline, we should not lose sight of who we're safeguarding. And Madam Speaker, when we come to the bar there and we bow to you, Madam Speaker, that is because Parliament is a court. In fact, we are the highest court, and we have a dialogue with the Supreme Court on decisions related to the Charter. But Parliament is supreme, Madam Speaker. And so when the government tries to suggest we're being unreasonable because we want to actually keep with the spirit of the Carter decision, Madam Speaker, this court should be respected as well. And I've not seen that from the government yet. So we will continue, Madam Speaker. If the government just reviewed the Carter and Rodriguez decisions, provided those safeguards, held up to the dignity required under Section 7 of the Charter, we could make sure that the right guaranteed in Carter was respected with the rigorous and scrupulous approach to protecting the decisionally vulnerable and the most vulnerable in our society. So as I said, Madam Speaker, the Conservatives are here to provide these reasonable amendments for the well-being of our country, and I appreciate the opportunity today to allow Canadians to realize this is not the Conservative Party holding up legislation or not respecting a court. This is the Conservative Party asking for the will of the Supreme Court through two decisions for our most vulnerable in society to be protected. Thank you, Madam Speaker.
Questions and comments? The Honourable Parliamentary Secretary to the Minister responsible for seniors. Thank you, Madam Speaker, and I'd like to thank the Leader of the Opposition for his remarks. We are accountable to Quebec, to Quebecers, to Canada, and to the Quebec Court. I'd like to know why the Leader of the Opposition thinks that it's appropriate to ignore a decision from the Quebec Superior Court.
Honourable Leader of the Opposition.
Merci, Madame la
Thank you, Madam Speaker. It's appropriate to protect the most vulnerable members of our society. And that was the decision of the Supreme Court. In the case with Rodriguez and in the Carter decision. Unfortunately, that wasn't the approach of the Liberal government. We are here facing a deadline because of prorogation, because of a lack of action by the government, Madam Speaker. And that's why we put forth reasonable amendments. And that's why we will continue to protect the most vulnerable people, seniors in long-term care facilities, like the one in Heron, for example, who are very isolated. We are here for Canadians, for people with disabilities. That's why the amendments regarding safeguards are so important, Madam Speaker.
Questions and comments? The Honourable Member for Winnipeg Centre. Yes, thank you so much, Madam Speaker, and I'd like to thank my honourable colleague for his comments. I just wanted to make a correction. I know he spoke a lot about mental health, but the bill very explicitly states in 2.1 the purposes of the paragraph 2A, a mental illness is not considered to be an illness, disease, or disability. And then if you go to Safeguards 3.1, it says that one of the criteria is that it meets all of the criteria set out in the subsection. I say that because I think this is a critical, debate in the House, and I think it's responsible that we provide the Canadian public with accurate information. I wanted to ask him a question. He spoke a lot about dignity. I know that certainly from advocates that I've worked with in the disability community, one of the things that they're fighting for is a guaranteed livable basic income so they can live in dignity. Does the member opposite support implementing a guaranteed livable basic income as been requested from the disability community?
The Honourable Leader of the Opposition.
Thank you, Madam Speaker. I'd like to thank the member from Winnipeg Centre for raising what she perceives as a carve-out for mental health. The challenge is, Madam Speaker, is mental health can be approached with the psychiatry handbook and a recognized condition. Mental health can also be someone who's in depression, in a grievous harm situation, isolated in a pandemic, a senior who feels he or she is a burden on their family. And that is why, going back to the Rodriguez decision, the Carter decision, and I invite all members, including the Attorney General, to read those decisions, consent and capacity and the review, the 10 days, is to make sure that there is no state of mind issue for someone feeling coerced or vulnerable. So mental health is part of end-of-life decision, Madam Speaker. The stress, the pain, all of those considerations. And that's why the Carter decision said a carefully designed system of safeguards is critical. The government does not have that. We are asking for reasonable safeguards to protect our most vulnerable.
Questions and comments? Questions et commentaires. The Honourable Parliamentary Secretary to the Minister of Justice and Attorney General.
Thank you, Madam Speaker, and I appreciate the Leader of the Official Opposition's contributions. I would point out that safeguards have been, in fact, increased in this legislation, particularly in Track 2 with respect to the 90-day requirement for an assessment and the expertise being required as part of that assessment panel. And when we consider why Track 2 is appropriate, the member opposite went to great lengths to cite extensive jurisprudence. The jurisprudence in the Truchon decision indicated that not making medical assistance in dying available to persons who were not at the end of life, including persons with disability like Madame Gladue and Monsieur Truchon, was itself unconstitutional. My question to the member opposite is that given we have dealt with extensive consultations, given that Canadians are needlessly suffering, and before us we have a straightforward piece of legislation, will the member opposite use his leadership with respect to his caucus to ensure we can have a vote on this legislation to address and no longer prolong the needless suffering of Canadians? Thank you.
The Honourable Leader of the Opposition.
Thank you, Madam Speaker. I'd like to thank the Parliamentary Secretary for his intervention. When the government removed the irremediable, they changed this from an assisted dying regime into an assisted suicide regime. He's recognizing that in his own comments, Madam Speaker. And they are removing some of the safeguards. So they're making it easier to access, making more decisionally vulnerable people vulnerable, and removing two of the safeguards in the process, Madam Speaker. It actually flies directly in the face of Rodriguez and Carter clarity on dignity, on the decisionally vulnerable. And so I'd ask him to use his leadership. Our amendments are really just asking them to stop eroding protections, Madam Speaker. And this government is running roughshod over what the court has said. When you take out that approaching, that reasonable, foreseeable death, that's gone, Madam Speaker. And that should concern Canadians, particularly as we've seen the isolation in this pandemic for some of our seniors. That fear, they are the decisionally vulnerable. That is who the courts have been asking us to look after. So I'd like him to use his leadership, perhaps drop a copy of those judgments off with the Attorney General, the Attorney General who passed the regime following the Carter decision, a former Liberal until she was pushed out by this Prime Minister. She has concerns with the approach. Disability groups, a lot of Indigenous leaders, mental health, physicians, the opposition. All we're asking for is a few reasonable safeguards, Madam Speaker. It's up to the Parliamentary Secretary to put down the talking points. When they decided to prorogue, they put the time pressure on. Right. We will continue to stand up for our most vulnerable.
Absolutely. Comments? The honourable member for Calgary-Nose Hill.
In some of the questions, Madam Speaker, we've heard the Leader of the Opposition outline how this bill does shift towards an assisted suicide regime. And then we heard the Parliamentary Secretary talk about Canadians who are needlessly suffering. I'm concerned about the intersection of those 2 points without the state looking at doing everything possible to preserve the ability of Canadians to live with dignity. I was wondering if the Leader of the Opposition could talk about the need for the government to move on issues like support for persons with disability, housing, palliative care, the atrocities that we're seeing in long-term care centres across the country right now. Can the Leader of the Opposition talk about how it's not just about this legislation, but there needs to be a framework in which people aren't needlessly suffering because they see hope and a choice through other services and programs?
Hear, hear.
The Honourable Leader of the Opposition.
Thank you, Madam Speaker. I'd like to thank my colleague from Calgary-Nose Hill for her intervention and for her advocacy for some of the folks we're talking about. As was said by some legal scholars, by Professor Grant, UBC, and others, when we don't even have an efficient palliative end of life, when we have some challenges with long-term care, those holes and gaps have been exposed through the pressures of COVID, when we know that there's rising mental health, there's trauma experienced by those who've suffered childhood abuse, other things, when our society is scrambling to get supports for the vulnerable to address those issues, but on the other hand is actually eroding safeguards to keep those people out of a state-run system with respect to end of life, we are failing our citizens. That's why our approach here is to just make sure that the vulnerable are protected. As I said myself, Madam Speaker, to the Attorney General, the former Liberal Attorney General who brought in the Carter regime, post-Carter regime, I was becoming comfortable with the other regime, knowing safeguards were there and knowing it was to be irremediable, reasonable, foreseeable end of life. The government is fundamentally changing this and taking out the safeguards at a time we know there are more vulnerable as a result of the pandemic. So it is reckless public policy on the most important debate our Parliament will have. That's why I hope the government see the light, a few reasonable amendments, and I think a lot of Canadians will be protected. Thank you, Madam Speaker.
Resuming debate, the honourable member for Kildonan, St. Paul.
Thank you, Madam Speaker. I am very grateful for the opportunity to put a few words on the record concerning Bill C-7, an act to amend the Criminal Code, Medical Assistance in Dying, which I will refer to as MAID throughout my remarks. This bill from the Liberal government amends the original MAID legislation that achieved royal assent only 4.5 years ago. This new bill was initiated in response to the Truchon case, where a federal court in Quebec struck down the clause in the original legislation that said MAID could only be applied if natural death was reasonably foreseeable. The Quebec Superior Court judge ruled on September 11, 2019, just over a year ago, that this clause violated Section 7 of the Charter of Rights and Freedoms, which guarantees the right to life, liberty, and security of the person, making this clause of the original legislation unconstitutional. The court's ruling will come into effect on December 18th of this year. Conservatives have held firm to the position that this ruling by the Quebec Superior Court should have been appealed by the federal government to the Supreme Court of Canada. Given that it is a ruling that affects life and death, I sincerely agree with our position. Had the Liberal government appealed, it would have given Canadians significantly more time to discuss this very critical issue. And had the Liberal government not prorogued Parliament for 6 weeks in August and September, Parliament would have had more time to study and debate this bill. But this position was resoundingly ignored by the Liberal government. Now we are voting on a radical expansion of MAID, and I have many concerns and will not be supporting this bill. But what I'd first like to say is that I do understand the desire for legalizing MAID in Canada. I witnessed my grandmother suffer terribly at the end of her life. MAID was not made available to her, and frankly, I don't know if she would have chosen it. She was a very strong and resilient woman with a gift of the gab and an incredible ability to write, which I think I have inherited those gifts, which is why I'm able to be here today as a member of Parliament, which she really would have been so proud to see. And she had these abilities despite not even having a great education, and she would have achieved, I believe, amazing things had she not been born into a very poor family in rural Manitoba. And she tragically suffered a stroke, and after that she couldn't speak or write her favorite things, and then her diabetes wreaked havoc on her body, and her leg had to be amputated as a result. And then a short while later, the doctors told us that they would have to amputate her other leg. It was really horrible and really the worst thing in my life to see her go through this. And I wonder if MAID would have been a kinder option for her. And for that reason, I understand and deeply appreciate why MAID was legalized in Canada. However, Conservatives have flagged a number of critical issues with this new expansion of MAID, and we worked hard to bring forward amendments to ensure safeguards remained in place for Canada's most vulnerable people. Unfortunately, the Liberals voted against every single one of our proposed amendments. Yeah. And I really don't understand why, Madam Speaker. We presented many strong, sound arguments from stakeholders across the country, most of which had no partisan connection whatsoever to the Conservative Party. And in fact, I believe this is not a partisan issue, and yet is being treated like one by this Liberal government, which I find, frankly, deeply upsetting. And when I was researching this bill to determine my position, I was startled to discover that over 1,000 physicians had written to the Attorney General in opposition to this bill. And I'd like to read into the record some of what their letter said because I found it extremely compelling. They said, "This bill expanding medical assistance in dying MAID to virtually everyone who is sick and suffering in Canada will, if passed in its current form, make our country the world leader in administering death. As medical doctors, we feel compelled to voice our dismay. The shock of a sudden illness or an accident resulting in disability can lead patients into feelings of anger, depression, and guilt for requiring care, emotions that, with support, proper support and attention, can resolve over time." They went on to say the care and encouragement shown by physicians may be the most powerful force in overcoming despair and providing hope. Unfortunately, patients can no longer unconditionally trust their medical professionals to advocate for their life. When they are at their weakest and most vulnerable. Suddenly, a lethal injection becomes part of a repertoire of interventions offered to end their pain and suffering. And finally, they went on to say, Bill C-7 would allow those who are not dying to end their lives by a lethal injection at the hands of a doctor or nurse practitioner. Shockingly, most of the safeguards that Parliament deemed necessary in 2016 to protect the lives of vulnerable individuals from a wrongful death are being removed. Under the new bill, an individual whose natural death is considered to be reasonably foreseeable could be diagnosed, assessed, and euthanized all in one day. We are very concerned, they wrote, that removing the 10-day reflection period and other safeguards will lead to an increase in coerced or tragically unconsidered deaths. The reckless removal of safeguards previously deemed essential will place desperately vulnerable people directly in harm's way and may cost them their lives, end quote. And these comments tie in very well with what we've heard from the disability community at the Justice Committee and the like. When we were studying this legislation, in fact, 72 national disability advocacy groups opposed this legislation, and I personally fielded many calls from my constituents who, frankly, were the first to tell me that they usually vote NDP, and yet they felt very compelled to reach out to me to express their fear of what this bill meant for them. There is a genuine terror in the disability community of this bill that I have heard firsthand, and yet those fears are being completely discounted by this Liberal government. And I really don't understand why, frankly, Madam Speaker. And more than that, the Liberals are even ignoring the United Nations with this legislation. A UN Special Rapporteur on the Rights of Persons with Disabilities responded to the expansion of MAID with clear dismay. She said, quote, "I am extremely concerned about the implementation of the legislation of medical assistance in dying from a disability perspective. I have been informed that there is no protocol in place to demonstrate that persons with disabilities have been provided with viable alternatives for eligible for assisted assistive dying, and have further received worrisome claims about persons with disabilities in institutions being pressured to seek medical assistance in dying, and practitioners not formally reporting cases involving persons with disabilities. And she went on to finally say, I urge the federal government to investigate these complaints and put into place adequate safeguards to ensure that persons with disabilities do not request assistive dying simply because of the absence of community-based alternatives and palliative care. End quote. I think that's a pretty powerful quote, in my opinion. And we know that there's considerable issues with palliative care. We know that 70%, which 7 out of 10 Canadians, I find this a shocking number really, I had no idea until I did the research for this bill, 70% of Canadians do not have access to palliative end-of-life care in Canada. And I do believe that without access to good quality palliative care, we have failed to offer Canadians a real choice. If you can't peacefully live out your final years with moments with safe, reliable care that's supportive, that's catered to your needs, then I can understand why MAID would be so appealing. And more than that, the COVID-19 pandemic has really lifted the veil on the terrible state of elderly care in Canada. In Winnipeg, our residents of elderly care homes have suffered tremendously. And while we have many care homes that are doing phenomenal, outstanding work, others not so much. A few weeks ago, Manitobans were horrified at revelations of an elderly care home just outside of my riding that was understaffed and overwhelmed by COVID-19 cases. And when paramedics arrived, they found some residents had been dead for hours and no one knew. Others were severely dehydrated and literally starving to death. Mr. Speaker, if we are to provide, Madam Speaker, pardon me, if we are to provide dignity in dying, we must also ensure dignity in living. This is paramount to the discussion and has been completely ignored by this Liberal government. And in fact, their 2015 election platform, they promised billions of dollars for palliative care, and this was never delivered. Further to that, I found it alarming that the 10-day reflection period in the original MAID legislation will be eliminated with the passage of this bill. It is important to note that the existing MAID legislation allowed the 10-day reflection period to be waived under special circumstances. So flexibility already exists in the existing MAID framework on this 10-day reflection period. That being said, I'm really not married to the 10 days specifically. It could be a bit shorter, it could be a bit longer. I would need to hear from professionals in psychology to truly understand how many days are best to ensure end-of-life decisions are not emotionally made or in the heat of the moment, so to speak. But I do firmly believe, at the very least, very, very least, someone who requests MAID should have to sleep on it. Given that there is no going back from it, and given tough days, whether someone had a poor interaction with a healthcare worker, or they don't like their new room or facility, or their family hasn't visited in a while, or it's just been a tough physically or emotionally painful day, there are so many reasons why someone who, when in their most vulnerable state, should have the safeguards in place when making life-ending, game-over decisions that would get, with this legislation, if it's passed, that could get administered only hours later. And you know what really solidified my thoughts on the removal of this safeguard, Madam Speaker, is the former Liberal Minister of Justice, the member from Vancouver Granville, who was responsible for the original MAID legislation only 4.5 years ago. She questioned the current Justice Minister on removing the reflection period, given removing the safeguard was not called for in the Truchon decision. So the person who brought forward this legislation 4.5 years ago is saying, whoa, 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 why are we removing this? And yet we received no firm answer from this Liberal government of why that is. So I just found that pretty compelling. And so the Liberals, for really reasons unknown, went far and beyond what was required in the case when they created Bill C-7. And I believe these concerns are valid. In fact, we learned in the first annual report on medical assistance in dying in Canada 2019, it stated that 3.6% of patients who made written requests for MAID subsequently withdrew those requests. Now, 3.6% may not sound like a lot, but of the 7,336 people who applied for MAID, 263 of them changed their minds. And keep in mind, MAID is new in Canada and not easily accessible everywhere. Imagine how many people will be applying for this after Bill C-7 passes. And as MAID becomes increasingly normalized, we know that the 263 lives that we're allowed to continue to live on because of that reflection period, that is so important that we maintain that, in my opinion. But it won't exist moving forward because of this Liberal government's refusal to listen. Conservatives also proposed an amendment that would extend the new 90-day reflection period for those seeking MAID whose deaths are not reasonably foreseeable. We proposed to extend it to 120 days. And the arguments for this are solid. as the 1,000 plus doctors that I quoted earlier said, they said, quote, "We live in a country where the wait times to see a psychiatrist in certain areas is 4 to 8 times longer than the 90-day waiting period proposed in this bill for those whose natural death is not considered reasonably foreseeable," end quote. Further, we know that after catastrophic accidents causing life-altering injury, for example, we know that suicidal ideation is very common, but with the proper support, it goes away and a happy and purposeful life can resume. Moreover, it takes much longer in many cases to get a wheelchair or quality specialized rehabilitation care than 90 days. So really, what good is 90 days if you're not able to access alternatives in that time period? I don't know. Additionally, Conservatives believe we can better protect vulnerable patients by requiring the patients to be the one who first requests information on medical assistance in dying and not have it openly or flippantly offered to a patient as a standard everyday option like pain medication or various therapies. Conservatives believe MAID is an extremely serious matter and should not be something pushed on patients in their most vulnerable state, so to speak. And now, whenever members on this side of the House state the potential for pressure to be put on patients concerning MAID, I do find during these debates that Liberal members essentially roll their eyes, they scoff and say that never happens. And while the Justice Committee heard something very different, they heard firsthand from witness accounts that pressure does in fact happen and has been happening over the past 4.5 years. Roger Foley is an infamous example of this pressure. He was offered MAID on 4 separate occasions to date and never once indicated that he was interested, in fact, quite the opposite. But when he was having a bad day, it was offered to him, and almost as if they were tempting him with saying, hey, there's an easier way, just end it all. And I just find that terrifying. And I find Roger's case further very alarming, and safeguards must be put in place to ensure that when people are at their weakest and most vulnerable moments, they're not offered something that would end their lives forever, but rather are provided various options for better care and support if they want it. Another issue I have with this bill, Madam Speaker, is that it moves to expand MAID so quickly. Really, this MAID legislation, the original framework, was just legalized 4.5 years ago, which is really a blink of an eye in relative terms. And the original legislation was thoroughly researched and vetted, and numerous safeguards were put in place to ensure our most vulnerable were protected, and those safeguards were considered critical at the time. But now, less than 5 years later, the Liberal government is massively expanding MAID and doing away with many of those safeguards it itself deemed critical in the first legislation not even 5 years ago. And at this pace, I very much believe and I fear that we may be debating expanding MAID for children or those with mental health issues within my lifetime, and I find that absolutely terrifying. And more than that, this legislation comes before the mandatory 5-year review. I feel that without it, we're flying blind without the proper data that could have been revealed in a comprehensive review. There are simple questions I would have hoped would have been assessed in that review, such as who is taking MAID? Is it mostly the elderly or the poor? Is it racialized communities, wealthy or white people? Is MAID impacting certain demographics, and why those demographics? Are there reoccurring themes for choosing MAID that could be addressed by providing better care during suffering at end of life, rather than death? We should be doing everything we can as legislators to provide alternatives to MAID that are reliable and easily accessible to everyone. And yet this government is not doing that at all. What I find interesting on this, Madam Speaker, is that the current Liberal Justice Minister is responsible for this aggressive expansion of MAID, but he in fact voted against his own government's Liberal legislation on MAID, the original one 4.5 years ago, because he believed it didn't go far enough. So we have known for a long time what his position was. And for me, that leads me to question whether the Liberal consultations on this bill were really impartial, and may explain why this legislation goes far beyond the Quebec Superior Court judge, what she had called for in the Truchon ruling. And there are so many questions with this new freedoms Canadians have with MAID. I firmly believe we have the responsibility as legislators to proceed on ending life of Canadians with extreme caution. There is a profound shift happening in our society concerning MAID, and we must proceed thoughtfully and with thorough, exhaustive research, which has not happened with this expansion of MAID. And for me, this expansion, really to put it plainly, is too much, too fast, too soon. Bill C-7 removes other critical safeguards as well, Madam Speaker, such as removing the requirement to have 2 independent witnesses sign off on MAID for a patient. This safeguard helped to prevent abuse and coercion of MAID and provided much-needed oversight on those discussions with patients. And to think really a person needs 2 independent witnesses to sign off on a will, but not to end their actual life, which I feel like we're living in the twilight zone on that one. Further, Conservatives have advocated for amendments that would ensure physicians who sign off on the MAID application have expertise in a patient's condition. And now you would think that a life-ending decision like MAID, that this safeguard would really be a given, but nope, the Liberals would disagree, and again, for reasons largely unknown. Additionally, I have heard a number of constituents reach out to me with significant concerns, that healthcare professionals who don't agree with the morality of MAID would be forced to help administer it. Now, the Liberals have insisted that this will not be the case and that conscious rights of healthcare professionals will be protected. However, communication on that has been dismal, to say the least, and otherwise I would not be receiving so many calls about it, and I urge this Liberal government to invest more time and energy into communicating on this specific issue. And just to conclude, Madam Speaker, from the 1,000 doctors, or over 1,000 doctors that I've been quoting throughout my remarks, I will end with one of their quotes. They said, quote, "Our profession has been coerced into facilitating suicide rather than preventing it for ever-increasing number of citizens. We watch in utter dismay and horror at how the nature of our medical profession has so quickly been destroyed by the creation of misguided laws. We, the undersigned, declare that the passage of Bill C-7, if left unchecked, will contribute to the destruction of much more than our medical profession, but fundamentally of a Canadian society that genuinely values and cares for its most vulnerable Canadians. Canadians deserve better." End quote. Thank you, Madam Speaker.
Questions and comments. The honourable member for Lac Saint Louis.
Intently to the member's speech, I myself am a strong advocate for palliative care. I was a founding member of the All-Party Committee on Palliative and Compassionate Care, and I have the largest palliative care hospice in the country in my riding, the Teresa Deller Palliative Care Residence. The member mentioned that the Minister of Justice voted against the original bill, but the reason he did was because he knew from the start that it was unconstitutional, precisely because he did understand the jurisprudence, which makes me think that the Leader of the Opposition was being rather glib when he suggested that the Minister of Justice didn't understand the jurisprudence. But the member mentioned that people should be allowed to sleep on it. But prior to the 10-day waiting period, there's an assessment period when people are obviously reflecting on the matter. So I just don't understand how it is that she feels by taking away the 10-day waiting period that people aren't allowed to or are not being given the chance to sleep on it.
Member for Kildonan St. Paul.
Thank you, Madam Speaker. I appreciate the member's remarks, and I appreciate that he has phenomenal palliative care in his riding, and I wish the rest of the members of Parliament in this House could say the same. And had the members' Liberal government delivered on their 2015 promise to invest billions in palliative care, that may be the case in more ridings than his own. And to his question concerning the 10-day reflection period, again, I still believe it's very important that when that final decision is made, you still have to sleep on it. Thank you, Madam Speaker.
Questions and comments? Questions et commentaires? The honourable member for Abbotsford.
Well, thank you, Madam Speaker. And I want to thank the member for Kildonan St. Paul for articulating so well the risks to Canadians that this legislation represents. I want to reference the palliative care that her speech also referenced. And she is correct. In 2015, the Liberal government announced that it was going to deliver support for palliative care. Never did. 2017, re-announced that. Never delivered. 2019, never delivered. And then more recently announced somewhere in the order of $6 billion. Over 10 years across the whole country. So it's a drop in the bucket to try to get the palliative care across the country improved. So I would ask the member to comment on the state of palliative care and perhaps reference her grandmother again. It was a poignant reference she made earlier about her grandmother's end-of-life care and how palliative care played into that situation and how it could be improved going forward.
The honourable member for Kildonan St. Paul.
I'd like to thank the member for his thoughtful question. And palliative care, I have many facilities in my riding that are absolutely phenomenal, doing incredible work, particularly during this pandemic. But as I remarked in my speech, there are a number of other elderly care homes in Winnipeg that aren't doing so well. And as I mentioned, at one point, the situation got so dire. There were so many COVID cases and such a staff shortage that paramedics were called. And when they arrived, they were completely dumbfounded of what they found. There were numerous people who had been dead for hours and no one knew that they had been dead. There were people that were starving and starving to death was how they described it. And in terms of my grandmother, she had decent palliative care, I have to say, but I found that there more could have been done to perhaps support her in her final days. And going back, I would change so much, and I think we all say that and think that about our grandparents and parents when they pass on. But I do find this a very important discussion, and if we're going to expand MAID, we have to expand palliative care.
Questions and comments? The Honourable Parliamentary Secretary of the Government House Leader.
Yes, thank you, Madam Speaker. I've been here through the 5 years listening to a great deal of discussion and debate on this very important issue. All lives are of equal value. I genuinely believe that. Yes, we do need to emphasize how important personal care, home care, palliative care are. I've enjoyed that discussions. There's been money that's been flowing in that area. But my question to the member is, will the Conservative Party be transparent and honest with Canadians by making the statement as to the real reason why they're not prepared to see this bill go forward? They do not support the legislation, and they would rather have it appealed to a superior court. And if they were in government, they would not be passing this legislation at this point because they would have referred it to a superior court.
The honourable member for Kildonan St. Paul.
The member opposite is correct. We would have appealed it to the Supreme Court. When we're talking about life and death, something at this magnitude that's going to be this change, this much change for society should absolutely go to the highest court in the land. End of story.
Exactly.
Questions and comments? The honourable member for Vancouver Kingsway.
I'd like to thank my honourable colleague for a very thoughtful speech. I know that this issue is one that engages the most profound issues of conscience, and I think it requires great care as legislators. I remember the Carter decision when it came out, and I read it carefully, and I'm a lawyer as well by training. I was concerned when the government put in a requirement that death be reasonably foreseeable, because that was not called for in the Carter decision. And of course, that led to the plaintiffs in the Truchon decision, Nicole Gladue and Jean Truchon, to appeal. And I think it's worthwhile mentioning why they did so. Ms. Gladue was 74. She used a wheelchair. She had post-polio syndrome, a condition that weakened her muscles and reactivated her childhood scoliosis. She had difficulty breathing and was in constant pain. Mr. Truchon was born with cerebral palsy. He no longer had the use of his 4 limbs. He lost the use of his only working limb in 2012, his left arm, due to severe spinal stenosis, which left him almost completely paralyzed and caused painful spasms. He had given up most of his activities and went into assisted living since there was little left he could do by himself. Each of those people had been refused MAID under the Quebec legislation regarding end-of-life care, and they didn't meet the requirements of the federal legislation because their lives were not reasonably foreseeable. To my honourable colleague, does she agree with the Truchon decision insofar as it has found the requirement that death be reasonably foreseeable to be a violation of Canadians' constitutional rights?
The honourable member for Kildonan St. Paul.
I appreciate the member's thoughtful comments, and I would say that I would have loved to have heard what the Supreme Court would have said about the Truchon decision. That would have given me more confidence in that decision. But ultimately, the reasonably foreseeable, removing that does give me some fear, and I was very frank about that in my speech. I wonder very much that in my lifetime, are we going to see this expanded to children who don't have reasonably foreseeable deaths, or those suffering from mental health? And that mental health piece, and I know the government's been very clear that this legislation excludes it, but at the rapid pace we're expanding it, I'm not convinced that within my lifetime we're not going to see this extend to mental health, and that I find to be the most terrifying of this new legislation.
Questions and comments? The honourable member for Sherwood Park, Fort Saskatchewan.
Thank you, Madam Speaker. And I think you said this is questions and comments, not resuming debate, right? So question for my colleague, if she can just following the question from the Parliamentary Secretary about the difference between the assessment period and the reflection period. And some members of the government have said, oh, it couldn't happen the same day because there's an assessment period before the reflection period. But there's no timing set on the assessment period. There's no reason that assessment period couldn't happen very, very quickly. So we are still left with a situation in which all of this could happen really all at once because there's no time parameters on the assessment period. And the government could have, if they wanted to, at least propose time parameters around the assessment period, which they didn't do.
The honourable member for Kildonan St. Paul.
Yeah, I appreciate the member's question, and I would just refer to the quotes that I included in my remarks from the over 1,000+ doctors who wrote in response to this issue and said that it was a real concern to them. So I would agree.
We have time for a very brief question. Questions et commentaires? Questions and comments? The honourable member for Sherwood Park for Saskatchewan, a very brief question.
Well, thank you, Madam Speaker. I wonder if the member could just speak as well about the issue of contemporaneous consent, the fact that this legislation doesn't even require people to be asked on the day they're receiving MAID, and we had a Conservative amendment that would have at least required people to be asked on the day. Isn't that sort of the minimum of what would be reasonable?
The honourable member for Kildonan St. Paul.
I thank the member for the question, and I would say I do have concerns with not having to sign off right before, and I do recognize, and I have heard many of the stories of why that was removed, that you can give prior consent and then have MAID administered when you have lost essentially the ability to give consent. But I have concerns on that. So again, this is one of those issues that had we had more time, had this Liberal government not prorogued Parliament, we could have studied in further detail.
Resuming debate, the honourable member for Sherwood Park, Fort Saskatchewan.
Thank you, Madam Speaker. We are now at the third reading stage of Bill C-7. This means that all of the amendments that will be considered by the House have now been considered, and we must now pronounce on the final version of the bill and its effects. Before I speak about this bill in final form, though, I want to speak and respond directly to what I see as this government's principal argument for this legislation and other similar legislation. They tell us that this is all about choice, the choice of an individual to live as they choose and to die as they choose. The idea that moral judgments about good living and good dying ought to be made by the person doing the living and dying as opposed to by someone else, because the individual is uniquely qualified to make judgments about their own happiness, and someone outside their skin simply cannot make those judgments as well. This is the one, I think, serious argument that people use to advance this bill and others like it. We should, of course, appreciate the existence of other unserious arguments, such as the assertion that courts told us to, or this is what people who we have consulted told us to do. We have a small part of this bill that responds to a lower court decision, but most of it has been invented out of thin air by the government. And whoever they consulted or did not consult, over 1,000 physicians have signed a letter opposing this bill, and every single disability rights organization who has spoken out on this bill has spoken out in opposition. So these are unserious arguments stemming from unserious readings of court decisions and unserious consultation. The serious argument made in support of this bill, as I've stated, is that people ought to have the choice to make decisions about their living and dying because they know what will lead to their happiness better than anyone else. This is the argument. But we should also notice how those who use this argument ultimately choose to apply it selectively. Even while suggesting that it's all about choice, they insist on changing the words that we use to describe the choice in order to make us feel better about it. The phrase medical assistance in dying was invented at the time Bill C-14 was proposed, and it is not a phrase used in other countries to describe this phenomenon of doctors killing their patients. If this is really about choice, then why do we have to invent new pseudo-terms to make ourselves feel better about that choice? If I ask members point blank, do they think that a person should be able to commit suicide? I'm sure many would respond, it's not suicide, it's completely different. It's medical assistance in dying. Formally, though, what is meant by medical assistance in dying is facilitated suicide or killing in a medical context. So we claim to be focused on choice, but we still are uncomfortable enough with the choice that we have to invent new words to describe it. Now, some members don't like the use of the word euthanasia to describe the phenomenon of doctors and nurses killing their patients after being asked to do so. The Minister of Health told the Justice Committee, quote, referring to this bill as euthanasia legislation, which I have heard in the House of Commons, are incredibly demeaning to the dignity of people, end quote. The Health Minister may be interested to know that the word euthanasia actually comes from two Greek words, eu, meaning well, and thanatos, meaning death. The term euthanasia means good death. That term is itself a sanitization of the concept of killing. If the term is misleading, it's not because it is too harsh, but because it is too gentle. As we've heard, not all of the cases of assisted suicide can reasonably be called good death by any definition. Notice then that the word euthanasia is never used to describe the administration of the death penalty. The term was invented in order to sanitize the idea of the medicalized killing of a consenting person. So it's instructive that a sanitized term for this practice, once it has achieved a full social awareness in terms of its meaning and reality, has to be replaced by a new sanitized term to further obscure the true nature of what is taking place. No doubt in 20 or 30 years, the term MAID itself will be thought gauche and replaced with another more up-to-date sanitization of a term which no longer does the job of making us feel better about something that we naturally feel uncomfortable about. The point is, Madam Speaker, that if this is all about choice, and if we are comfortable with this choice, then why aren't we comfortable speaking plainly of sick people committing suicide and of doctors killing their patients when asked to do so? Would that not be a more plain and accurate description of the choice that many wish to defend? If there is a practice or activity which people are uncomfortable about, either seeing depicted or hearing described accurately, then perhaps we should ask ourselves why we feel uncomfortable, instead of demanding that the images and the descriptions be put aside. Members should observe as well that the idea of a choice to die or a right to die is being advocated selectively. Some people have a right to die, and some people don't, apparently. So we have to ask why this principle is being selectively applied. Suppose that I, as an able-bodied, healthy white male, experience some great personal tragedy, such as the death of the child or the breakup of my marriage. It is possible that following such an event, I might start experiencing extreme existential pain and suicidal ideation. If I then went to a doctor to share the feelings I was experiencing, I would not be presented with MAID as a way out of the challenges I was facing. The way I look, my health status, and other characteristics that I have would signal to the doctor that my life is worth living. We know this to be true, that when a young, able-bodied person chooses to die, those around them will say, "What a tragedy, he had so much to live for." The argument for a choice to die does not apply to those who society believes should not choose to die, even if such people are sincere in their expression of pain, in their sense that their pain is irremediable, and in their desire not to continue living. But what if a person who is older, who is disabled, who does not fit the stereotypical social mold of someone who has a lot to live for, presents themselves to the healthcare system experiencing existential pain and suicidal ideation? We know from testimony from the Justice Committee that people in this situation are offered and even pressured to opt for MAID. People who are elderly or living with disabilities are often offered and pushed to take MAID without asking for it. This is the testimony given over and over again at the Justice Committee and confirmed by the Minister responsible for disability inclusion, who acknowledged how concerned she is about people with disabilities being regularly and proactively offered MAID that they do not want. So, Madam Speaker, we see therein an important and revealing contradiction in the application of the principle of choice. For some in society, death is seen as an unreasonable choice and is actively discouraged. For others, death is seen as a desirable choice and is actively encouraged. This is not just a debate about choice, therefore. Rather, it is a debate about how the architecture of choice is set up differently for different people based on whether others assess their lives as being worth living. And this is what leaders in the disability community are deeply concerned about, how this legislation includes them and only them in the additional category of those for whom we think death is a reasonable course of action. Suppose that, of my 4 children, one had a disability. And suppose that I taught 3 of my children to always press on because life is beautiful, but I told the 4th child that they should consider death if they ever face circumstances that they cannot handle. Do you think that situation would make my 4th child feel privileged by the special offer of choice? Or do you think she would feel devalued by the fact that I thought death was uniquely an option for her based on the presumption that her life was not worth living? Madam Speaker, choices do not exist in a social vacuum. When we speak about choice, we recognize that people are making choices between available options, and the nature of those available options are constructed by the society in which they live. I used to think that people are always better off with more options, that just like a menu at a restaurant, we are always better off with more options available to us. The longer the menu, the better. If I don't like any of the new options available, then no problem. I don't have to choose them. But I shouldn't begrudge other people the opportunity to have more choices available to them, even if I don't like those choices. Nobody is made worse off by the lengthening of the menu. But then I realized that it wasn't that simple. If I'm in a restaurant and the only options available are chicken or beef, then arguably, yes, I'm better off with the addition of more items on the menu, a fish option, a vegetarian dish, etc. But there is also a case in which the existence of certain options on the menu fundamentally changes the nature of the experience. Suppose that, while traveling, I encounter a restaurant that offers a human flesh sandwich in addition to the usual fare. It is fairly safe bet that I would not stay and order in that restaurant, even if I had no intention of ordering the human flesh sandwich. It is unlikely that any members of this House would feel comfortable eating in such a restaurant, even if all they planned to eat was the filet mignon. This example illustrates the way that the offer of an additional option can actually change one's entire experience of a place or environment. A person with a disability who is offered death has a very different experience of healthcare than a person who is consistently offered life-affirming care. The fact that people are offered or encouraged towards certain choices, and that some people are offered those choices and others are not, changes the entire experience of healthcare for many people. And so part of the response to this brave new world of so-called medical assistance in dying is that people are seeking safe spaces where they can receive care that is life-affirming. There are still many people in this country who have about as much interest in receiving care in an environment where death is being offered as they do in eating at a restaurant where cannibalism is offered. Such people should be free to receive care in a hospice where life is the only choice and where they feel safe from the possibility of pressure, from momentary weakness, or from the sense that they are an unnecessary burden. Some are still looking for care that is animated by the conviction that all lives are always worth living. But perversely, those who claim to champion choice are actually attacking these safe spaces. With the absence of conscience protection in this or any other legislation like it, doctors are being forced out of their profession and life-affirming hospice care is being shut down. And we wonder why we have a crisis in long-term care in this country. Maybe it has something to do with the fact that so many of the people and organizations that have historically operated in this space are being pushed out because of a lack of conscience protection. Protecting the conscience rights of physicians and of institutions is not just about the rights of providers. It's about the right, indeed the choice, of patients to receive care in a certain kind of environment if that is their desire. Madam Speaker, I know from the many conversations that I've had with constituents, including those who are very supportive of the expansion of MAID, that the present realities of the social architecture of choice are top of mind for them during their advocacy. In other words, they want more euthanasia because they find the alternative intolerable. An absence of good care, an absence of effective pain management, an absence of support to live in a way that accords with their sense of dignity, a sense of resignation about these realities, leads them to want to be able to end it all rather than endure under undesirable conditions. But those conditions could themselves be changed, and the expansion of euthanasia, along with continuing pressure on all healthcare institutions to offer it, will further erode the life-affirming nature of care that people receive. I remember once having a long conversation with a constituent who explained to me her reasons for advocating for expanded euthanasia. She emphasized the classic arguments about choice and control, and then shared with me a story of being in a care situation and struggling to have a bowel movement unaided. She went to the nursing station for help and unfortunately was met with a gruff and unempathetic response. Her memory of the sense of indignity she felt, struggling for a long time on her own, and then seeking the help of a person who seemed uncaring and disgusted, was clearly a part of her thought process about the circumstances under which she would want to die. While I can identify with her feelings in the moment, I think the solution is to give people the choice of compassionate care. It is a tragedy that people are considering death because of moments of perceived indignity that can be quite directly resolved. Many older people who are considering death say that they do not want to be a burden on others. This is expressed as a matter of choice, but it is also revealing about the architecture of choice. It is, I think, generally unheard of for children to insist on paying their parents' rent or living independently because they don't want to be a burden. Certainly, I have never heard such sentiments from my children. So why are elderly people made to feel like they might be a burden while children are not? Again, this is an issue of social context. If children were constantly told from a young age that they were a great burden to their parents, that they were costing them money and that they could be spent on other things and they were interrupting their social lives, then children would likely start to worry about being a burden. So then conversely, if seniors and people with disabilities were constantly affirmed for their value and for their ability to contribute to society, constantly told that they hold the key to our future rather than constantly being told about the burden they impose, then of course they would be more likely to choose life instead of choosing death. So this is not just a question of choice. It is a question of the social architecture of choice that leads people to make different choices in different kinds of situations based on the limited options in front of them and based on the way that different options impact each other. To underline this with one further point, it shouldn't escape the notice of members that the government's Bill C6, the proposed ban on conversion therapy, is built on the premise that people cannot consent to something that is contrary to their human dignity. Although I have concerns about the text of C6 as written, I agree with the principle that conversion therapy is wrong and should not be allowed. But in light of both C6 and C7, it remains unclear to me about what the government's view is on the ability of a person to consent to harm. Is it the view of the government that people should be able to voluntarily consent to things which harm themselves? Looking at these bills together, we might conclude that the government finds it okay for people to consent to death, but not okay for people to consent to certain things which are deemed worse than death. But this subjective categorization of certain harms as being worse than others clearly may contradict an individual's own subjective sense of what things are more harmful than others. I think it's time for us as parliamentarians to talk about the choices that elderly people and people living with disabilities have in front of them, and to give them choices and options besides death. To move from a narrow focus on questions of choice to a discussion of the architecture of choice, which puts people in impossible and painful situations. A good society is not just one that gives people the formal right to make choices between different alternatives. It is one that ensures that those alternatives are sufficiently robust so that individuals are able to make choices which truly lead to happiness. Of course, not all choices lead to happiness. People can make choices which they think will lead to happiness, which do not. This is especially serious when a decision is final and irreversible, and so the wider community has a reasonable interest in ensuring that a person making that choice has at least all of the information in front of them, taking into consideration the fact that people can and often do adapt to new circumstances over time. A belief in the pursuit of happiness entails a belief in freedom, but also a belief in the value of encouraging the considered use of freedom through due reflection. Now, Madam Speaker, having reflected on the application of the concept of choice in this context, I would now like to make a few additional comments about the provisions of this bill and the timing of it. This bill proposes to eliminate the requirement that death be reasonably foreseeable for those seeking euthanasia, and put those for whom death is not reasonably foreseeable on a second track with some distinct requirements. The reconsideration of the question of reasonable foreseeability was provoked by a court decision in Quebec, the Truchon decision, which the government could have chosen to appeal but did not. But this bill deals with more than this question. It also arbitrarily eliminates a number of safeguards which have nothing to do with the Truchon decision. It eliminates a 10-day reflection period, reduces the required number of witnesses, and eliminates the requirement for contemporaneous consent. The removal of the 10-day reflection period in particular has led experts to point out that this opens the door to same-day death, to a situation where a patient could request and receive euthanasia on the same day. Some members of this House have strenuously objected to the use of this term. Same-day death is a jarring idea that someone's worst day could be their last, and that temporary suicidal ideation could lead to immediate death. But those who find this term uncomfortable must face up to the fact that the legislation as written contains no parameters for those for whom death is deemed reasonably foreseeable. If members believe that time parameters exist, then they should point to where they exist in law. And if members believe that time parameters should exist, then they should have supported their reintroduction into the bill. As the law stands before us now, there are no legislated requirements around timelines for those for whom death is reasonably foreseeable. And so at third reading, members must choose whether or not they will vote for same-day death in Canada. As Wilberforce said, you may choose to look away, but you may never again say that you did not know. Conservatives have proposed reasonable amendments to reintroduce the reflection period, to introduce a shorter reflection period, to reintroduce requirements around contemporaneous consent and independent witnesses. And in particular, recognizing the different experiences that people with disabilities have reported with the healthcare system, we introduced a requirement that healthcare practitioners only discuss euthanasia if it is brought up by the patient first. These safeguards matter and would protect vulnerable people, reducing the risk of people being rushed and pressured into vulnerable situations. In response to our call for safeguards, we hear from the government that they trust healthcare practitioners and therefore these rules are not required. As I've said before, the purpose of a safeguard is not to respond to what may be the average case, but to establish a minimum standard. We are talking about 100,000 people in this country whose professional qualifications would allow them to administer euthanasia, about 100,000. Are those 100,000 uniquely virtuous or uniquely trustworthy that they do not need laws to regulate their behavior while the rest of us do? I believe that most people in medicine are doing their best to selflessly serve others. But one needs only listen to the testimony at the Justice Committee to realize that some of those providing healthcare have fallen short of that call. All of us need laws to regulate our behavior to some extent. And if you and I need regulation, then how can we expect those 100,000 people to be different? Are there no bad apples? I'm not arguing that they should be subject to unique suspicion, of course, simply that they need rules and laws to guide their actions just as the rest of us do. Anyone charged with taking another person's life should do so within strictly defined parameters for their own good as well as for the good of everyone else. I trust doctors just as I trust police officers, but we still need regulation and oversight. We recognize that in police forces there are some bad apples, and if we need safeguards for police officers in light of their power to take life, then we also need safeguards for those in power to take life in a medical context. Now, finally, the government has been working very hard to push the narrative about timing, claiming that Conservatives are responsible for delaying this bill. Mr. Speaker, it should stand to reason that if the government wants us to be invested in rapidly passing their bill, they must first seek to persuade us that it is a good bill, which they haven't done. The Truchon decision requires a response, of course, but matters would be much simpler if this bill only focused on a response to Truchon instead of a variety of other changes. As it is, we are forced to consider all of the elements together, not just the narrow part that responds to Truchon, and this is their choice, not ours. But let's also take stock of how we have gotten so close to the court deadline. This legislation was presented in February. In May and June, Conservatives wanted the House to sit in modified form, but the government refused to allow it. Then they killed their own bill by proroguing in August. All of these moves pushed us into the mid-fall before this bill was considered. It then received a mere 4 meetings of witness testimony at the Justice Committee. 4 meetings, Madam Speaker. The government's approach to this legislation has been to delay until the last minute and then demand urgency instead of consider review. Let us be clear that this is a political tactic designed to subject these radical changes to as little debate as possible. Madam Speaker, as a high school student, I had the honor of participating in a special MLA for a Day program at the Alberta Legislature. At one of our meetings, a seasoned progressive conservative minister explained to us how legislation was passed. Students were surprised by the length and complexity of the process and asked why it takes so long. Couldn't they shorten the process a little bit? The minister told us that he was glad it took so long because one of the fastest pieces of legislation to ever pass the Alberta Legislature was the Sexual Sterilization Act of 1928, which allowed the government to sterilize people with disabilities against their will based on the analysis that they imposed an undue burden on society. If only legislators at that time had taken more time to listen to people with disabilities and to consider the implications of what they were doing. That point has stuck with me to this day, that when we are in too much of a hurry to make decisions, we risk undermining the fundamental rights of our fellow human beings, in particular, in both cases, of those living with disabilities. Those of us on this side of the House who are raising concerns, who are demanding that time be taken to consider this bill, that appropriate safeguards be put in place, we are on the right side of history. And just like with the Sexual Sterilization Act of 1928, when this bill is repealed, in 5 years or in 50 years, I will proudly tell my grandchildren that I took my stand for the universal, immutable dignity of every human person. Thank you.
Questions and comments? The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Madam Speaker. Let me start by saying that I believe that the whole issue of process is a false argument that's being advocated from the Conservative Party. The opportunity for debate was and still is there, Madam Speaker, if that's truly the only interest of the Conservative Party. I believe the Conservative Party needs to be more transparent with Canadians. They do not support the legislation. It is their intention to prevent this legislation from going forward. That is the honest truth regarding the legislation, Madam Speaker. I'm asked the member, would he be straightforward with Canadians and tell them just that the Conservative Party of Canada does not support the legislation, and that is the reason why we are at the stage we are at currently.
The Honourable Member for Sherwood Park, Fort Saskatchewan.
Thank you, Madam Speaker. Well, the Parliamentary Secretary is conflating 2 issues. Do I think this is a bad bill? Yes. Did I vote against it at second reading, and will I vote against it at third reading? Yes. Did I vote in favor of reasonable amendments from my friend for St. Albert Edmonton that would have improved the bill? Yes. Does the government control the legislative calendar? Yes. Could they have not prorogued? Could they have scheduled debate on this bill in May and June? Yes. So the fact that we're in this situation of created urgency is manufactured by decisions the government has made. This is their own manufactured urgency designed to limit considered debate on this bill. Yes, I think it's a bad bill, but I also think we could have been debating it in May and June. We could have been considering it earlier if they hadn't prorogued, and we could have allowed the Justice Committee to take the time that was necessary. Again, 4 meetings of witness testimony. Conservatives put forward motion and asked, can we have 5? Can we have 1 more meeting, given the overwhelming concern and opposition? We had many, many briefs submitted by medical practitioners that were initially rejected because of some arbitrary timeline that wasn't even published. And it was only after a motion from the member for St. Albert Edmonton that those briefs were allowed to be translated and presented. But even at that point, they were distributed long after the consideration of amendments has started. This was an unreasonable process manufactured by the government that wanted this debate to not have to undergo this bill, to not have to undergo serious debate.
Questions and comments? The Honourable Member for Vancouver Kingsway.
Speaker, well, the original criteria under the C14 that I believe remains under C7 are these. In order to pursue a medically assisted death, a person must satisfy the following eligibility criteria. They must be, of course, of majority age. They must be able to make healthcare decisions for themselves. They must make a voluntary request for MAID that is not the result of external pressure, for example, from a healthcare professional or a family member. They must give informed consent after they have received all of the information they need to make their decision, including their medical diagnosis, available forms of treatment, and available options to relieve suffering, including palliative care. and they must have a grievous and irremediable medical condition, meaning that a person has a serious and incurable illness, disease, or disability, is in an advanced state of decline in capabilities that cannot be reversed, and experiences unbearable physical or physiological suffering from an illness, disease, disability, or state of decline that cannot be relieved under conditions that the person considers acceptable. Does my honourable colleague support the ability of medical assistance in dying to people who fill those criteria?
Member for Sherwood Park for Saskatchewan.
Thank you, Madam Speaker. So again, I think there's a little bit of a conflation of a few issues here. So the member spoke about eligibility criteria. There's eligibility criteria. There's safeguards that ensure that those eligibility criteria are actually being met in a considered way. And there's also a question of context. Do people have those alternatives? For instance, if a person is suffering in a grievous and irremediable way because they haven't had access to care that would address their suffering, they may meet the eligibility criteria, but there's a problem there in terms of context. The fact that they're making a decision that's based on limited options because the system hasn't provided them with the care that they want. Now, in terms of the safeguards, we've heard so much at committee, at the Justice Committee, and I encourage the member to look at the testimony from people with disabilities who talked about situations of being pressured, of being told that they were selfish for not wanting to pursue this path. So we have cases of pressure. Clearly, those are problems. And I think in principle, members would say, obviously, that shouldn't happen. But the fact is, it's happening right now, and the people that are involved in that pressure have not been prosecuted, have not been disciplined. The government has held up, oh, nobody's been prosecuted under this law. That means it's working well. Well, given that we have testimony saying it isn't working well, and yet there's been no consequences for those that are involved in abuses, this suggests that the safeguards as they exist are failing, and the government wants to take away more safeguards without addressing some of the context issues. So my focus is on addressing the issues of context and the issues of safeguards in order to protect people who are vulnerable.
Comments? The honourable member for Simcoe Gray.
Thank you very much, Madam Speaker, and I want to thank the member for his excellent speech this morning, my colleague. My question, I guess, relates more to the hospice and hospice discussion as part of this. I'm very blessed in my riding to have two hospices. I have Hospice Georgian Triangle as well as Matthews House Hospice, both having a tough time these days because of COVID, fundraisers, not getting their money. They're reaching out to the community. They do such amazing work. It's dignity in dying, not just for the individual, but for the family members. So my question to my colleague is the government obviously isn't investing enough money into these type of operations, number one, and number two is how important that is to this bill and other options for people that are suffering at the last end of life. Thank you.
The honourable member for Sherwood Park, Fort Saskatchewan.
Well, thank you, Madam Speaker. I appreciate the comments from my colleague, and it's been wonderful to hear members at different points in this debate speak about the excellent work being done in their ridings by those who are accompanying people in their last days and seeking to provide good quality palliative care. It is a tragedy that most Canadians do not have access to that many Canadians are offered death long before they are offered or able to receive those things which will allow them to effectively manage their pain. And this is a choice that we have to make as legislators. We have to look at the architecture of the choice in front of people. It's not just about, as I said, it's not just about giving people choices. It's about saying, what are the options that people have? And saying if we pull everything out of that life option, if we don't have proper palliative care, if we don't have effective end-of-life supports for people, if we don't have effective pain management, and then we say your only option is or death or pain, well, that's obviously not a desirable choice. But what we can do is help people get out of that choice by offering an alternative. If your only options are pain or death, that's not a good place to be. That's not a place we want people to be. And the technology exists for better pain management than the vast majority of Canadians are receiving right now. And if we don't pay attention to this, we have multiple bills in the last 5 years on expediting the death side of it, but not on dealing with the life side of it. That sends a clear message about the priorities of this government, unfortunately, when it comes to seniors and people living with disabilities.
Questions and comments? The honourable member for South Okanagan, West Kootenay.
Thank you, Madam Speaker. My colleague talks about the context, talks about options. What I'm hearing from the disability community in my riding is exactly that. These are people who, before COVID, were getting about $1,000 a month in disability pension. Then we gave everybody $2,000 a month in CERB because that was felt what was needed for people to live in dignity. And he talks about long-term care homes, you know, the tragedy there. So I'm just wondering, considering those options, C7 aside, would he support the NDP proposal to move long-term care into the Canada Health Act so those people, our seniors, get the care that they deserve? And would he support raising disability pensions to $2,000 a month so those people can live in the dignity that they deserve?
The honourable member for Sherwood Park, Fort Saskatchewan, has just a little over a minute to respond.
Thank you, Madam Speaker. And we're going to agree with the NDP on the principle that we need to do more and do better to support seniors and people living with disabilities. There may be some cases where we disagree on the mechanism because Conservatives value the partnerships that can exist in the delivery of, for instance, hospice and long-term care. And we believe that by respecting conscience, by respecting the what may be the unique and particular mandate of some of those private, not-for-profit facilities, that through partnerships like this that we can do more and offer more collectively. That solidarity isn't just about what the government does, that solidarity is about what all of us do together, politicians as well as not-for-profit organizations, faith groups, community groups. So we may disagree on some of those mechanics, but hopefully we can work together based on a common framework that says we need to do better in terms of ensuring people have access to a dignified life option.
Resuming debate, the honourable member for Cloverdale Langley City.
Thank you, Madam Speaker, for the opportunity to address the House to speak once again on this very important issue and continue to act as a voice for those who continue to be ignored. The government is acting as if rushing this legislation through in order to meet the Truchon deadline is its #1 priority. Canadians are suffering because of the pandemic, and while people and businesses continue to fall through the cracks, this government is prioritizing expanding access to euthanasia over providing Canadians with the support they need. Shockingly, they are rushing this bill before the mandated 5-year review of the euthanasia regime in Canada has even taken place. This is being reckless, and this recklessness will cost people their lives. The Truchon decision is not a binding legal decision for the House of Commons, but the government's choosing to act as though it is, despite calls from this side of the House to appeal it. When we're dealing with something this serious, with stakes as high as life and death, it's imperative that the process isn't rushed by a lower provincial court decision. Our vulnerable citizens deserve better. In all honesty, this deadline is nothing more than smoke and mirrors. Amazingly, Bill C7 not only expands access to euthanasia to those for whom death is not reasonably foreseeable, but it goes beyond Truchon by eliminating necessary safeguards that are in place to protect the vulnerable. By removing the 10-day reflection period, a person nearing the end of their life can receive medical assistance in dying on the very same day they request it. That means, in essence, for many Canadians, their worst day will be their last day. I would like to point out an important statistic from the first annual report on medical assistance in dying in Canada, presented in 2019. In this report, it states that as of the date of its release, 263 Canadians who had requested MAID ended up withdrawing their request. 263 Canadians. Because of the current day waiting period, 10-day waiting period, 263 Canadians' lives were saved. It's clear that these people felt like they wanted to die on the day the request was made, but decided days later that they wanted to keep on living. Had the 10-day reflection period not been in place, 263 Canadians would have had their lives ended prematurely. Maybe it was a phone call from an old friend, or meeting with a family member, or good news from their physician that caused them to change their mind. It doesn't matter. The point is they did. Why does the government want to rob Canadians of the opportunity to make that decision? They justify the need for Bill C7 by the Truchon decision, but where in Truchon does it say that? Another important safeguard that this bill seeks to eliminate is the requirement for final consent. This is one that truly frightens me. The reasoning behind the removal of this safeguard is the fact that a person may lose the capacity to be able to consent to euthanasia before it's carried out if a person's illness advances, causing significant cognitive decline. So therefore, a person can give advance consent to have their lives ended should they lose that capacity to make such a difficult decision. It fascinates me that we all agree that a person is unable to provide advance consent to sexual activity, and that if that person is taken advantage of when they do not have capacity to say no, a crime has been committed. And yet the government believes a person can provide advance consent to have their life ended, even if they lose the capacity to say no when the procedure takes place. The problem with the principle of advance consent is that it's impossible to know what a person's desires are if they're unable to communicate them. We cannot know if a person in that state truly wants to die. Maybe they've had a change of heart and wish to keep on living at the time MAID is administered, but they just can't tell you that. That is horrifying. The risks associated with the removal of the 10-day reflection period and the requirement for final consent are too serious for me to accept. And remember, the stakes are as high as life and death. The government needs to protect vulnerable Canadians. They need to ensure safeguards are in place. The removal of these safeguards puts their lives in danger. Now, I would like to remind the government of the voices they ignored in their rush to meet this unnecessary deadline. The voices of disabled Canadians, their doctors, and their advocates. I remind members of the words of Krista Carr, the Executive Director of Inclusion Canada, who said that this bill is disabled Canadians' worst nightmare. And the words of Catherine Frazee, who said that this bill tells people like her that their lives are not worth living. Or how about Dr. Heidi Jans, who told the Justice Committee that this bill will result in people with disabilities seeking MAID as an ultimate capitulation to a lifetime of ableist oppression. And Roger Foley, who bravely told the committee from his hospital bed that if this bill passes, he will not survive and the Parliament of Canada will have his blood on its hands. I'm here in this House again, reminding the government of the words they refuse to listen to. The stream of euthanasia access for those who are not dying is ableist and dangerous. These are not my words. These are their words. Doctors who work with disabled Canadians made it very clear at committee that a 90-day waiting period is simply not enough time. They explained that suicidal ideations are very common when someone experiences a catastrophic medical episode. But with good care and support, they're almost always overcome. In my last speech on this bill, I introduced the House to Christine Crowley's story. Since her spinal cord injury 33 years ago, Christine has lived the kind of life that most able-bodied people just dream of. But it took her years after her injury to feel great again. And she worries that people like her will decide to end their lives when they're at their lowest point. Now let me share the story of David Shannon. David suffered a spinal cord injury in a rugby scrum when he was 18 years old. He shared that after his accident, he lay in bed, close to death, more times than he wishes to contemplate. David has gone on to have a career in non-governmental organization leadership and a law practice focused on human rights and health law. Let me share a quote from David. I have accomplished a lot in my life. I've crossed our great country by the power of my wheelchair, coast to coast. I've jumped out of an airplane at over 25,000 feet. I've made it to the North Pole and planted an accessible parking sign. I've written a book, performed in plays and on TV. I've received my law degree and even been a human rights commissioner. I'm an Order of Ontario and an Order of Canada recipient. I've loved and been loved, and my proudest accomplishment is that I lived. End quote. Several times during this debate, members on this side of the House have asked how many stories like this will never be told if Bill C-7 passes. I urge my honourable colleagues to truly understand what is being asked here. Much like the removal of safeguards, knowing that lives like those of David Shannon and Christine Crowley will be cut short if this legislation passes is far too great a risk for me to accept. Now, those who support this bill continue to fall back on the idea of autonomy to justify their willingness to ignore these risks. But let me read another quote from David Shannon addressing this. He says, "What offends me most about Bill C-7 is that there is an implicit license to promote death. And I ask, why is there not the promotion to pursue one's autonomy? When someone is first injured, they are compromised. They need to know there are supports available and that life can be fantastic, not coerced to leave their life and loved ones behind." End quote. When someone is first injured, they are compromised. When you are compromised, your autonomy is impaired. It's in this compromised state that the government wishes to offer death to Canadians. Let me also remind the House of this government's absolute failure to provide disabled Canadians with the care that they need. Let me remind the House that it often takes much longer than 90 days to even see a specialist. Let me remind the House what the Minister of Disability Inclusion told the Justice Committee, that it is easier to receive MAID in this country than it is to receive a wheelchair. Not only are we offering death when a patient's autonomy is most compromised, we are coercing patients to die by failing to offer them care. I've asked this before, and I must ask it again. Do we really want our legacy as members of Parliament to be the Parliament that offered patients death before we offered them care? That is where we're headed with this legislation. One last time, on behalf of disabled Canadians, their doctors and their advocates, I'm begging the members of this House to stop this attack on Canada's disabled community. They have been crystal clear about the ultimate abuse that their community will be subject to if this bill passes, and I'm begging you to hear their pleas. We know the abuse we can expect in the future. The government will not be able to say they didn't know, just that they didn't listen. We have been warned in no uncertain terms about what will come. But now I would like to speak about the abuse that is already happening. Gabrielle Peters, a journalist who lives with a spinal cord injury, wrote this in a recent open letter to Canadian senators, and I quote, "I know that Bill C-7 must be stopped because I know passage of this bill will result in preventable deaths of disabled people. I know this because I know those already happen. I know they already happen because I was almost one of them." End quote. The government is rushing to eliminate safeguards for euthanasia when the current safeguards aren't even being adhered to. According to bioethicist Dr. Yaro Kotelik, it is evident that provincial and territorial authorities are not fully engaged in their role of monitoring, enforcing, and reporting on the performance of the MAID program, which they are expected to do according to the federal laws and regulations. This is clear from Roger Foley's testimony to the Justice Committee. His caregivers, who he depends on for every comfort and necessity of life, have suggested that he opt for MAID 4 times. Roger's death is not reasonably foreseeable, so this is completely illegal. I think it's incredible that on the International Day of Persons with Disabilities, every Liberal MP voted against protections for persons with disabilities being added to Bill C-7. Even the Minister of Disability Inclusion, who expressed in the Senate pre-study that she shares some of the concerns of disabled Canadians, voted against our amendment. Let me remind the House what the UN Special Rapporteur on the Rights of Persons with Disabilities said on her visit to Canada. She said, "I am extremely concerned about the implementation of the legislation on medical assistance in dying from a disability perspective. I have been informed that there is no protocol in place to demonstrate that persons with disabilities have been provided with viable alternatives when eligible for assisted dying." End quote. The opposition tried to address that concern by moving an amendment in committee requiring that patients have meaningful access to care before MAID can be administered. I remind the House that the Liberal members voted that down. Let me share another concern raised by the rapporteur. I have further received worrisome claims about persons with disabilities in institutions being pressured to seek medical assistants in dying, and practitioners not formally reporting cases involving persons with disabilities, end quote. Earlier, I referenced the 2019 Health Canada report on MAID. While some of the statistics therein were helpful, there were clearly some issues with the report, namely the lack of any mention of abuse. The information collected was self-reported by MAID providers, so uncovering abuses is unlikely. We know there has been abuse. That much is clear. Cases like Roger Foley's, as well as many others, make it undeniable. Archie Rowland, 18 months before his death by MAID, was transferred against his will from a residence that provided highly specialized care to a geriatric long-term care facility that could not meet his needs. He said, and I quote, "It wasn't the illness that was killing me. I was tired of fighting for compassionate care," end quote. Sean Taggart, a father with ALS, exhausted from battling for the care he needed to live at home, was told he would have to be placed in a long-term care center hours away from his home community and family. He was unable to live the remainder of his days at home with his young son and felt the only option was MAID. There are also stories of Alan Nichols, Yvonne Tremblay, Gabrielle Bouchard, Tommy Seck, Jonathan Marchand, Raymond Bourbonnais, Candice Lewis, and far too many more. Some of these people are still fighting for their lives, and some of them already gave in to the pressure to die. Why are there so many horror stories? Why is there such a lack of compliance? Well, that's simple. There's a lack of oversight. Many doctors and family members of patients have told me that their complaints lie dead in the water. There also exists a culture of severe bullying in medicine, so doctors are scared to speak up out of fear of losing their jobs. A press release from back in March written by Physicians Alliance Against Euthanasia said this: "The pressure has been intense for many physicians, especially amongst palliative specialists, some leaving the profession even before this latest development, Bill C-7. Descriptions were made of toxic practice environments and fear of discipline by medical regulators," end quote. When I last spoke on this bill, the Parliamentary Secretary to the Minister of Justice asked me if I knew of any cases of pressure that led to prosecution. Well, there are plenty of cases of pressure, just no prosecution. When complaints are made about abuse, there's virtually no avenue for recourse. If you complain to the police, they're blocked from investigating by doctor-patient confidentiality. When complaints are made to the College of Physicians and Surgeons, they're not followed up on. Many doctors feel cowed into submission before complaints are ever made in the first place. I attempted to find out from the BC Ledge Library how many complaints were lodged against doctors with the BC College of Physicians and Surgeons regarding MAID. The response I got was as follows, and I quote, "The College of Physicians and Surgeons of BC cannot disclose the existence of a patient complaint against a physician unless the complaint leads to formal discipline. Therefore, the exact number of complaints to the college, whether related to MAID or not, is not possible to ascertain using public sources," end quote. The response went on to offer me a media scan of newspaper stories related to MAID complaints in the hopes it would be helpful. Imagine that. The only place where any information is publicly available on MAID complaints is in the media. Shame on us. Imagine the cases of elder abuse that are happening under this easy-to-cheat scheme. We have millions of elderly Canadians with no protection from this regime because there is absolutely no way of monitoring it. Imagine the cases like that of my constituent who attended a town hall I held when the MAID survey was open for submissions. Together with almost 100 people, we went through each question, attempting to understand and respond in a thoughtful way. The more questions we answered, the more we all realized the issue was far too complicated and nuanced for a survey to be of any good. Then a young father stood up and told his own story of how he was diagnosed with terminal brain cancer. In the town hall, he explained how he had become depressed following his diagnosis and so sought counseling to help him cope with his new reality. Instead, his counselor offered him MAID. He was so shocked that in his darkest hour, a professional counselor would suggest the very thing which for him was extremely tempting, but not in alignment with his ultimate goal, to live his best life to its natural conclusion. The medical professional on our panel was shocked. This was completely illegal under the current laws and should have been reported, to which the young man replied, "How do you even report it?" Imagine that. This man, whose life was put in jeopardy, was completely unaware of even how to report the incident. So the doctor said, "You can go online and write a complaint to the College of Physicians and Surgeons. You should do it right away." To which the young man replied, "I just don't have the energy. I'm going through chemo and I'm absolutely exhausted. I can't wrap my mind around anything extra right now." How many people are out there right now who either don't know who to file a complaint with or just don't have the energy or strength in them to fight? They're already fighting a battle with death. Now we want them to go online and file a complaint they may not live to see to its conclusion? Let me close with a quote from a constitutional lawyer, Derek Ross. In face of ongoing evidence that the current procedural safeguards are not being followed, it is alarming that the government is seeking to remove many of those safeguards rather than strengthen and upholding them. Who is investigating these findings of non-compliance? And who is collecting and consolidating this data? The Carter decision was premised on the assumption that procedural safeguards would be scrupulously monitored and enforced. Federal government bears a responsibility for reviewing reported cases of noncompliance and ensuring that data regarding noncompliance is gathered and used to inform future policy. The horrible abuses of the current regime, which anyone who is engaged with will know is taking place. This bill is a nightmare to disabled Canadians and to physicians across Canada. The risks associated with it are too serious to accept, and the stakes are as high as life and death. We cannot get this wrong.
Thank you, Mr. Speaker. Madam Speaker. Questions and comments? Questions et commentaires? The Honourable Parliamentary Secretary of the Government House Leader.
Yes, thank you, Madam Speaker. And, you know, one gets the sense in listening to the member that she is very passionate on the issue. I don't question that at all. I do substantially differ with her in regards to the amount of attention that is given by, in particular, our healthcare professionals, family members, dear friends that are out there. That I don't think the type of abuse that the member seems to be convinced exists is in fact there. I have never heard a complaint. I've never had a constituent complain to me personally in regards to abuse in the area. And it's not to say that it's not there, but I don't think the member supports the idea of MAID legislation. And that's the question that I have for her. Does she even support the need for legislation of this nature, even in an amended form?
Honourable Member for Cloverdale Langley City.
Thank you very much, Madam Speaker. What I support are these two very important principles. One, patient initiated. That is very, very important. Number two, meaningful access to care before MAID is carried out. If we can't even manage to offer palliative care, to offer psychiatric care, how can we honestly do what we're doing? It says in the palliative care bill that we passed a number of years ago that MAID cannot be considered voluntary if there's no meaningful access to care. So I am begging you, this is a bad bill. We need to focus on offering good medical care. Let me tell you a few statistics that come from the from the Canadian Association for Long-Term Care. The 2017 federal budget included a historic $6 billion over 10 years for home and community care. Long-term care was not included in this investment. National Housing Strategy does not include long-term care. Home support work pilot for foreign caregivers does not include employment in long-term care. The 2019 federal budget did not include investments in long-term care. The federal government flowed $343.2 billion in COVID-19 related spending in the first quarter of this year. Not $1 was committed to supporting long-term care. How are we going to support our seniors, our vulnerable, if we don't invest in long-term care?
The honourable member for Sherwood Park, Fort Saskatchewan.
Thank you, Madam Speaker, and the member gave an excellent speech. It's interesting to observe the discussion between some of our colleagues and members of the government. We're pointing out the fact that at testimony, especially the Justice Committee, and the member read some additional stories, that people are reporting significant problems, people with disabilities being pushed toward euthanasia even when they haven't expressed any interest in this. On the other hand, the government is saying, well, the system must be working because nobody has been charged, the official channels for complaint, are not being made. Nobody's called the member for Winnipeg North's office to report this issue, which I'm not sure would be the appropriate reporting mechanism anyways. But there's this disconnect, but at the same time, they're both true. I mean, it's true that there are problems. We know this. And it's also true that people aren't being disciplined or held accountable when abuses take place. And so I think, the member has spoken about this, but I would love to hear more about how we can actually address this disconnect, ensure that when there are abuses, well, first of all, that they're not taking place, and secondly, that we have safeguards that are there to come along and support and protect people, and give them avenues or have others advocate for them when there are these kinds of situations of pressure towards death. And the reality is we'll just never know most of these cases. With the problems in reporting and support that are there, we're just never going to hear about the vast majority of times where this happens.
Honourable member for Cloverdale, Langley City.
Yes, thank you for that question. I have to say, because I have been an advocate on this issue for many years now, I worked together with Mark Warawa, an amazing member of parliament who's no longer with us. I have had many people come to me with their concerns about issues of non-compliance. So perhaps other members haven't been paying attention, but had they been advocating on behalf of the disabled and the elderly, they would know that this is happening, and there is absolutely zero way of monitoring it. We absolutely need to ensure, before anything, we need to ensure that vulnerable Canadians are protected. And the idea of focusing on this Bill C7 rather than focusing on ensuring that there is some sort of protocol in place, as the UN rapporteur even talked about, that there's some kind of protocol in place where we can monitor what is going on rather than just MAID providers. Here we are, we're opening it up more and more, and we have no way of knowing how much abuse is happening. So again, I'm speaking out on behalf of those who are not able to speak for themselves and saying it's happening. We need to watch out. We need to take care, not push this forward.
The honourable member for Flamborough-Glenbrook.
Thank you very much, Madam Speaker. I appreciate the opportunity to ask my colleague a question. Earlier, the Leader of the Opposition referred to a legal term called decisionally vulnerable. And I want to ask my colleague, she was just talking about long-term care, but the promise that the government made a full 5 years ago in regards to an investment into hospice and palliative care of $3 billion has never come to pass. And I'm just wondering how she feels in regards to whether that would exacerbate the feeling of being vulnerable for those people who are decisionally vulnerable presently.
Honourable member for Cloverdale, Langley City.
Thank you so much for that question. What we are hearing is those who are vulnerable are not able to access meaningful care. Without access to meaningful care, many of them have some no choices. They're in our hands, and we are not offering them care. We are offering them euthanasia. So I would even like to point out the situation that happened with MP Mark Warawa. He was diagnosed with cancer And it took him 9 days to see a palliative care specialist. There were only 2 of them in the hospital there. The fact that it took him 9 days to be able to see a palliative care specialist just shines a light on the fact that our system needs more support. We need to ensure that these sorts of cares are in place for those who are in need of them. And to ignore them like this, to rush this legislation the way we have been doing, is, to me, it's absolutely shocking. To see the vulnerable advocates that came forward at Justice who were ignored is really quite something shocking in my mind. And I would love to see that the government stops, takes a look, and actually listens to those who are begging them to ensure there's care, not a rush to death.
And comments, questions et commentaires? Resuming. Oh, sorry, you have a question. The Honourable Member for Lanark, Frontenac, Kingston.
Thank you, Madam Speaker. I have my mask on, and I can see why that was confusing. I wanted to ask my colleague, I know she's been following the debate. I actually saw her on the screen earlier, and so she would have heard everything. One of the arguments that has come up in the course of the debate was a suggestion from the government benches that this bill is being introduced in order to comply with court-ordered rules regarding maintaining the constitutionality of our law, and moreover that the Justice Minister and Attorney General was opposed to the previous made legislation because it failed to do this. So my question is, with regard to the various amendments that were put forward by the opposition, by the Conservative Party, is it the case, in the opinion of the honourable member, that any of these suggested amendments would have had the effect of causing the new legislation to not be compliant with the Constitution, or is it her view that the legislation would nevertheless have been fully compliant if amended as suggested by the Conservatives?
The Honourable Member for Cloverdale, Langley City, 20 seconds.
Thank you so much. I think that it's very important to understand that we looked very closely at what our amendments were to ensure that they would be allowed. And unfortunately, the Liberals voted all of our amendments down.
Debate, the Honourable Member for New Brunswick Southwest.
Thank you. Madam Speaker, I'll be splitting my time today with the Honourable Member for Battle River Crowfoot. Madam Speaker, I rise today to participate. Pardon me, let's start that over. Madam Speaker, I rise today to participate in this important debate on Bill C-7, which seeks to expand medical assistance in dying or MAID. While the Liberal government has summarily dismissed the role of Parliament with respect to the all-party committee study and evaluation of this law, I believe it is still important to ensure my remarks appear on the record, since Bill C-7 is literally a matter of life and death. Let me begin by quoting my honourable colleague, the member for Lanark, Frontenac, Kingston. He posed to this government during the earlier days of our hybrid sitting. In the context of advocating for defibrillators to be placed in community halls, hockey rinks, and other places Canadians gather across the nation, he asked, "It will cost approximately $1 billion to renovate Centre Block." I believe that's accurate. "It will cost $5 million to put these defibrillators in all police cruisers. That would save 300 lives per annum. Is the cost of saving 300 lives per annum 1/2 of 1% of $500 million more or less important than renovating Centre Block?" End quote. Now, my colleagues on both sides of this House know I'm a strong supporter of our institutions, our history, and protecting them for future generations to appreciate and learn from, and in some cases even revere. This is true of Parliament, historic sites across Canada, and even statues of our founding leaders, for their vision and even at times for their faults, and sometimes many faults. But here my honourable colleague from Lanark, Frontenac, Kingston was posing a simple but profound question to Parliament, which is, what is the value of life and how can it be measured? It is a question all members of Parliament have been consumed with since the start of the coronavirus pandemic.
How can we protect and save lives? I believe it's a question that will form the basis of debate in the House of Commons for the remainder of our natural lives, and I believe well beyond. In just over 8 months, all levels of government have spent a combined $500 billion in their respective struggle against the pandemic. Rich, poor, old, young, married or singled, with kids or grandparents. It doesn't matter what families look like or households look like. Everyone is impacted by COVID-19, and governments have acted. The measures brought forward were, in one way or another, based on one simple, profound truth: that elected officials at every level of government across the country support life, want our nation to fight for it and protect it. Now, I stand today as someone who will be voting against this piece of legislation, C7. Medically assisted death is a practice that, if left unchecked, could, in some dark corners of society, turn the right to die into an obligation to die. How is it that a government that advocated overwhelmingly to accept closures and even economic lockdowns in its response to the coronavirus be the same government that has unmoored us from protecting Canadians by vastly expanding the legal parameters of medically assisted death? It is grisly. I would like to quote the member opposite from Vancouver Granville, the former Minister of Justice, who stated the following about this legislation C7. Quote, "Why is Bill C7, medical assistance in dying, abolishing the safeguard of a 10-day reflection period and reconfiguration of consent, thereby introducing advance request for MAID? Nothing in the Truchon decision of the Quebec Court of Appeal, which the government chose not to appeal, requires this. And the Supreme Court of Canada, in Carter, insisted on the requirement of clear consent. The palliative care physicians, disability advocates, and other experts insist that this is an important safeguard, and like other legislated MAID reports on mature minors and mental disorder, advance requests also raise significant challenges." End quote. Madam Speaker, it's very troubling that this is the direction the Liberals have chosen. A single decision in a single province by a single lower court has upended the law as it stands today, passed by a previous parliament. And so a culture of life is abandoned, because even the most basic safeguards are deemed by its current Justice Minister, the Cabinet, and caucus to be overly restrictive. We have a fragile consensus established in the last Parliament, and with Bill C7 we will undo that important consensus. Now, I hope we can rediscover that consensus again in a future Parliament, when its leaders are more reflective on matters of life and death, and perhaps will express some humility when we face these questions. I believe we must, as parliamentarians, even those who sit across the aisle, reject the unwise extension of medical assistance in dying in our society. But I am dismayed this will not happen. C7 today is medical assistance in dying in name only. Its sponsors cling to that description to give it a fig leaf of respectability and to make it palatable to the public. For C7 stripes away both safeguards to protect vulnerable Canadians and even the belief that one's death should be near, imminent, or even reasonably foreseeable. Whereas medical assistance in dying built in safeguards, today's bill does not, and we are left simply with medically assisted death. Thank you, Madam Speaker.
Comments, questions et commentaires. The honourable member for Timmins, James Bay.
Thank you, Madam Speaker. I think one of the issues here that's really important is the fact that we have to deal with the courts and court decisions, to me, really lays out questions that government has to look at in terms of legislation. What I find concerning about the last court decision is that the federal government never appealed it. And I find that surprising. I don't think there's ever been a First Nation ruling in any court ever that the federal government hasn't appealed all the way to the Supreme Court and fought tooth and nail. And yet on this, on a fundamental question, on the issue of a foreseeable death. This is something that is difficult for all of us, I think, to deal with, but we understand it. We understand why it was brought in. We understand why the Supreme Court made us come forward with legislation, but that this was ruled on by a provincial court, and the federal government did not appeal it before bringing it in for legislation, and then went beyond the decisions. I'd like to ask my honourable colleague if he thinks it would have been better if we'd actually appealed it, had a very clear ruling from the Supreme Court, and then responded to that.
Member for New Brunswick Southwest.
Thank you, and I appreciate the question from my honourable colleague. I do think that would have been the better approach, to examine the ruling and appeal it to the Supreme Court to get a broader interpretation of the law. I believe the last Parliament was right in its approach that it took in crafting this legislation to strike a all-party committee, and that committee came up with recommendations. Now, not everyone agreed with it, but we saw the bill coming out of Parliament did have broad consensus, I think, in this House, despite some of the flaws that even I see in the current legislation. But at least it had that democratic participation, and as well, of course, it went through the Senate as well, received royal assent, and became the law. So here we are left with today with a single court decision from, as my honourable colleague was saying, a lower court judge that was not appealed. I think that was done as a rush to judgment by the government to make changes. I'll note for this chamber, I'm sure it's been noted before, that the current Justice Minister voted against the current law. At the time, he felt it was not sufficiently robust or expansionary. So opportunities have allowed him to recraft that law, and I think in a way that ignores Parliament, ignores the input from the last Parliament that was sought from all parties. And today we're left with a much diminished bills that breaks that consensus, and I think because of that, we'll be debating this into the years ahead, into Parliaments ahead.
Questions and comments? Questions et commentaires? The Honourable Member for Battle River Crowfoot.
Thank you very much, Madam Speaker. And a lot of discussion has been had around the safeguards issue. I'm wondering if my friend and colleague would be able to comment on how this bill greatly diminishes the safeguards that he talked about, how were carefully crafted in a way that respected the democratic process in the last Parliament, how some of those safeguards have been reduced or completely eliminated in this bill that actually goes beyond the court decision that the government uses as justification for the bill that they've introduced.
Honourable Member for New Brunswick Southwest.
Well, that's exactly right. The crafters of this bill like to tell us, the Parliament, Canadians, they were forced to do it. A lower court forced their hand to come up with this legislation. But in many cases, as my honourable colleagues have pointed out, as the former Minister of Justice, who's now an independent member, has noted, this bill goes far, far beyond the court ruling, and it does remove. It doesn't just upend them. It removes safeguards. For example, the 10-day waiting reflective period is gone. Other important safeguards have been removed, and this will have an impact, I believe. It will have a grisly impact over time as medically assisted death becomes just a push to death in some corners, as people are forced to consider things they would not have otherwise considered. And I worry about this. I worry about for those Canadians who are in a vulnerable position or near their end of life, or just even people who are have given up for a brief time. But often we know with health care and with better care that people can rebound. Not always, and I know there are tough cases out there, but I think this legislation sends us in the wrong direction on these important questions.
Debate. The Honourable Member for Battle River Crowfoot.
Thank you very much, Madam Speaker, and it is an honour to once again enter into debate on such an important subject. You know, I think that the first thing that I'd like to address is the comments that the Minister of Justice and other members of the government have been making about how somehow Conservatives are holding up this bill, that we're somehow responsible for this delay. Well, there's really one word, and I'll of course expand upon that, but really one word that completely rejects that argument. Madam Speaker, that word is prorogation. The government came forward with this legislation before, and then wouldn't, it certainly won't surprise any of my constituents, but when the government used their excuse for the need for a legislative reset, and that just happened to coincide with the day regarding what very well could have been very revealing documents related to scandals that the Prime Minister and various members of this government were facing in an unprecedented scandal, they prorogued Parliament, resetting the legislative agenda. They reset it. Because of COVID, they claim. Yet now we see many of the bills that they had introduced in the previous Parliament being reintroduced in this Parliament, and then they make it about, well, Conservatives are somehow holding up the process. Now, I believe it's 24 days behind the legislative process. Madam Speaker, 24 days behind the legislative process that we could have dealt with this legislation and many of the other important things, COVID-related and otherwise. Yet, here we are. I think that it is absolutely, well, the words that come to mind aren't necessarily parliamentary, but it is a shame that we find ourselves in this position and that the members from the government side would suggest somehow that we're not doing our jobs by debating legislation that is literally about life and death. Madam Speaker, constituents will hold those members to account on this subject, because certainly I've heard often from those who are concerned on all sides of this issue. And I'll get to some of the comments that the Minister of Justice has made more recently, but on all sides of this issue, there is the need for dialogue, discussion, and careful consideration so that we can strike the right balance. That's why this Parliament exists, the hallowed chamber that we all have the honor and privilege of sitting in, so that we can have a discussion. Now, certainly, I would love to see the composition of this House changed a little bit in terms of the numbers of seats that particular parties have, and I'm certainly doing my best to ensure that that happens. And I think there's some encouraging news in that front. But it's interesting that the people that Canadians send to this place, regardless of what the composition is the importance of the dialogue associated with every aspect of our jobs here, whether that be COVID-related, whether that be related to medical assistance in dying, as we're debating today, or the many, many other issues that come before this chamber and its committees. So, Madam Speaker, we cannot diminish the requirement for us to do our due diligence in every aspect of the word, and certainly I am doing my part in this debate, and resoundingly reject the government when they say somehow we're delaying this. Well, Madam Speaker, the blame for that lies directly on the desk of the members of the Liberal government who are abusing, manufacturing urgency, when really the reason there is even urgency to begin with is carefully crafted political games by members of the government opposite. Now, Madam Speaker, I find it very interesting, because as I've listened to the Minister of Justice talk about Bill C-7 over the course of the last specifically number of weeks, there's been an evolution in his response. Now when I stood up, although the last time I participated in debate, it was from my constituency office, so I wasn't actually standing up at the time. But the last time I participated in debate, the Minister of Justice the day before had talked about how they had found the consensus on this issue, that they'd found this broad consensus, that they'd come together and done what the people had asked them to do. And he bragged about the 300,000 submissions to the consultations, when I know for a fact, and I mentioned this in my last speech, that the position the government came to was certainly different than many of the consults that my constituents sent in. Didn't seem to be acknowledged in that regard. But I find it very interesting, Madam Speaker, because when the minister answered yesterday, there was a change in his tone. The Minister of Justice referred to this as a sensitive subject, much more nuanced in his approach, that there's wide disagreement on, but the Conservatives should hurry it up. Now, I'm paraphrasing, Madam Speaker, but I think that the change in the minister's tone is a clear example that I think the Liberals' hands have been slapped. When they claim to have consensus on an issue when it is clear that they do not. When we have disability rights advocates. When we have medical professionals. When there certainly seems to be a wide consensus. Now, it's not universal. I won't go that far, because I think that's an inappropriate use of a term with such broad application. But there seems to be a tremendous amount of consensus, again, not universal, how this bill is flawed and deserves due consideration. So, Madam Speaker, I think that is exactly what this institution's role is. Whether it be us debating C7 or the other place, when I imagine it will pass, I know certainly at second reading and report stage we saw that it passed, so I anticipate that we'll see a similar result. Then the other place will also have that opportunity to go through that dialogue. So, Madam Speaker, I do, and I am carefully, I set a timer this time, so there's about 3 minutes left. So thank you, Madam Speaker. I do want to talk about how we face a tragic irony, I would suggest. The Government of Canada, like governments around the world, like provincial governments, like municipal governments, have poured trillions of dollars into COVID response programs. Now, it is without question that those who are most at risk for this virus that has gripped our world over the last number of months, coming up on close to a year, the most vulnerable among us are seniors. I find it tragically ironic that in the legislative reset prioritizing COVID, supposedly, we would be debating this bill where it puts some of our most vulnerable at risk. Madam Speaker, while governments have poured trillions of dollars, and in many cases, rightfully so, into COVID relief and response programs, here we are debating a bill that allows people to end their lives, reduce safeguards on a decision that I would suggest can be no more final than that. Madam Speaker, that tragic irony brings us to today. How the government will talk about the need and with great criticism often they talk about how they criticize Conservatives' debate on many aspects of the COVID response. Yet here they are pushing something that is the antithesis of what we are, I think all parliamentarians would certainly say when trying to do what's best for our constituents, doing what's best for Canadians. You know, and in my final minute here, I would simply say this. You know, I think that often the constitutionality of this place is forgotten. The reality that the highest elected office in this land is not that of the Prime Minister, but that of the Member of Parliament. And I think, Madam Speaker, often, and we could have, I'm sure, a lengthy discussion about why there's that misunderstanding, whether it be because of the prominence of American media in Canada or education, whatever the case is. But the primacy of Parliament in Canadian law, Canadian society, and the Member of Parliament being the pinnacle of what this institution is. 338 of us. And I find it, you know, when constituents talk about things like Western alienation, they say, how can you make a difference? And my response is, well, you know how I know I can make a difference is because I occupy the same number of seats as the Prime Minister does, as the member from Winnipeg North does, as any of my Conservative colleagues, Bloc, NDP, Green, etc. You know, I think that that's the strength of our institution and why free votes are a part of the reality of this place. And I would certainly encourage my colleague.
And I will let the member pursue and the Honourable Parliamentary Secretary to the Leader of the Government.
Yes,
Thank you, Madam Speaker. And as I've indicated, I do believe that it is a false argument from the Conservative opposition to try to give an impression that this is about process. It's not about process. It's more about the lack of confidence. And I guess I would ask the member, because the Conservatives, as official opposition, are saying, well, we don't trust the Quebec Superior Court. They're impugning the character and competency of, in fact, the Quebec Superior Court judge, I would suggest to you. They say that no to the legislation, it should have been appealed. So my question to the member is, will he come clean and be transparent with Canadians and just say, we don't like the legislation, and if we were in government, we would not respect that Superior Court. We would, in fact, go to the Supreme Court of Canada.
The honourable member for Battle River Crowfoot.
So thank you very much, Madam Speaker, and I appreciate the question posed by the member opposite, and I would respond in two ways. One, I would encourage the member, if he hasn't had a chance, to read our Constitution and understand the appeals process, lower courts, higher courts, and the Supreme Court, because that certainly, it has nothing to do with the confidence of the decision. It has to do with decisions that were made within what I assume is the hallways or the back rooms of how this government operates. So, to the member opposite, through you, I would encourage I would encourage the member to look into that process, because I'm sure he would find it enlightening. And then when it comes to open and transparent, well, I think that there's certainly a lot that I would say on that. But where are the documents regarding the We Charity scandal? Where are the documents regarding every aspect?
The honourable member for Winnipeg Centre.
Madam Speaker, and you know, I think we can all agree that the disability community has a history of human rights violations in this country. I know that it's been mentioned by my Conservative colleagues many times today. My question is, because of that, do they support call-outs from the disability community for a guaranteed livable basic income and more great investment in affordable, accessible social housing, and more support to ensure that people have what they need to ensure they can live in dignity? Yes or no?
The honourable member for Battle River Crowfoot.
Well, Madam Speaker, when it comes to ensuring that Canadians have the opportunity to live with dignity, absolutely yes. However, when the member talks about the need for supports and ensuring that there are programs to protect the most vulnerable among us, I would simply pose a counter question, quite frankly, to say, okay, well, how's that paid for? Well, it's paid for by the prosperity of Canadians, including, natural resources. And I certainly have heard from Indigenous communities that are troubled by the fact that there are political opponents in this place that would...
J'ai un point d'ordre, oui, l'honorable député de Laurentides-Labelle. L'interprétation ne semble pas...
The honourable member for Laurentides-Labelle.
To see, is it working now? Oui, ça fonctionne. Sorry, the honourable member.
Thank you very much, Madam Speaker. And do I get a few more seconds in the time? So thank you very much. And I would encourage the member, when it comes to ensuring that Canadians have the opportunity to live lives with dignity and ensure that we can have well-funded social programs and whatnot, we need to ensure that our economy grows so that there's the revenue for government to be able to pay for the world-class suite, and of which deserve continuous consideration and ways to ensure that they continue to serve the best interests of Canadians. I would ask that member to consider supporting some of these resource projects that are largely supported by Indigenous communities from certainly her region and others.
Questions and comments. Questions et commentaires. The honourable member for Regina Leeuwin.
Thank you very much, Madam Speaker, and what a privilege it was to listen to the member from Battle River Crowfoot today. I had the honour of working with this young man when he is in the Saskatchewan legislature, and to hear him represent his constituent views today on such an important bill is just inspiring and shows just the great parliamentarian this young man is going to be for a long time. But my question would be, could he expound on some of the reasonable amendments that our Conservative Party made to this bill, and really, if he could, maybe give an example or two of why he thinks this Liberal government would have voted against some reasonable amendments that put safeguards in place, like the 10-day reflection period, that really was championed by most people with disabilities across this country.
For Battle River Crowfoot.
Thank you very much, Madam Speaker. And it's a little bit hard to believe there was only a few years ago that I was a staffer serving this member when he was an MLA and others. And it is certainly an honor to be able to serve in this hallowed institution now with him as colleagues, and certainly look forward to working with him for many years to come. And I said, hopefully there will be a redistribution of seats within, reconfiguration, and look forward to hopefully that being from the other side. He mentioned the two very important amendments that were brought forward that ensure, the real crux of what we're talking about here, to ensure that the most vulnerable among us are protected. And two very simple aspects of that would be the reflection period and would be the reasonably foreseeable death and the time limit there. Because, Madam Speaker, to protect those most vulnerable among us should be of the utmost importance for each and every member of this House. So I would encourage, in my final few words, that all members would vote the way that they feel best represents their constituents, not the way their party leaders suggest they should.
Hear, hear. Reprise du débat. L'honorable député de Louis Saint Laurent.
Resuming debate, the honourable member for Louis Saint Laurent. Well, thank you very much. Madam Speaker, I rise today to speak with a great deal of emotion, to speak to this very delicate issue, medical assistance in dying. During my remarks today, I will be shedding light on the parliamentary reality, the legal reality. I have some comments to make, a great number of comments, in fact. Today we are debating this bill at third reading. I'll also be addressing the fundamental issues, what our position is, what colleagues' positions are on the matter. But before I begin, I'd like to clarify something for the House. This is an issue where partisanship has no role. There's nobody who's good, who's bad. There aren't good positions as opposed to bad positions. There aren't any good votes or bad votes. There are just positions that people are comfortable with and that they believe in and that they're prepared to defend personally as individuals. Because the issue can be horribly divisive, but it can also be a golden opportunity to have an intelligent discussion, but first and foremost, a respectful discussion.
You know that I love political battles, Madam Speaker. That's part of our jobs as politicians. But there are some issues that do not lend themselves well to this.
Talk about assisted dying situation. This issue is not a partisan one. There is no bad guys and good guys. There is no good vote or bad vote. There is only vote and position in which we are comfortable, where we stand firm on that, with being respectful to the counterpart. This is this issue, and this is why I want to address it with, well, sometimes, I like to be a little bit, I would say, aggressive in my comment. This case, I will try to do my best to be honest, and because I want to be respectful to each and every position. Donc, Madame la Présidente.
So, Madam Speaker, this bill, C7, follows a decision that was made by the Superior Court of Quebec. But this isn't the first time that this issue of MAID has been broached. It was the Quebec government, or province rather, that was the first to adopt legislation with respect to medical assistance in dying. And unfortunately, or fortunately, I know what I'm talking about because I was a provincial MPP at the time. I was at the National Assembly in Quebec when it was introduced. And as a provincial member of parliament, I worked 6 years under 3 different premiers, under 3 different governments on this very important issue. And I'd like to make my position clear. The proof that this issue can be treated in a nonpartisan fashion. There were 3 different premiers, Minister Charest, Prime Minister Charest and Couillard. They conducted parliamentary sittings to adopt legislation provincially on MAID. And I'd like to underscore that that happened under a premier who was a doctor as well, Mr. Philippe Couillard. I was there at the time. And then the Carter decision came down from the Supreme Court with respect to MAID. And then we had to decide, the federal government had to decide in terms of federal safeguards with respect to MAID. And in a very correct fashion, Stephen Harper, since we were on the verge of starting a campaign, did not approach this subject, and that was the right thing to do because
this issue is not a partisan one. So this is why Prime Minister Harper did the right things, put it aside during the campaign, the electoral campaign in 2015. Then the new government elected, could have been Conservative, could have been DP, it has been a Liberal. Well, the new government tabled a new bill. And I've been part of that discussion, I've been part of that committee.
Because, Madam Speaker, the government had been well informed to strike a non-partisan committee with different members from the Senate and the House of Commons, and I had the great privilege to sit on that committee under my leader at the time, Rona Ambrose, on that committee. And I also had the privilege of having very interesting and fascinating conversations with Canadians across the country of different opinions, what we called C14 at the time. We have to be careful, Madam Speaker, because democracy being what it is, and rightfully so, there were some who were in favor of the legislation and those who were against it. And when we had C14 at the time, 5 years ago, at the House of Commons, there was a sunset clause, and there would have been a review by parliamentarians after a certain period of time. And now where we are, well, there was a decision. And this issue was brought before the courts, and that was inevitable. And then there was a Truchon case, and the judgment came down on September 11th, 2019. The judge of the Superior Court of Quebec made a decision on this issue. Immediately, the federal government, under the Minister of Justice, seized this decision, decided to conduct online consultations, and tabled legislation in February of last year at the House of Commons. Already, Madam Speaker, in my opinion, this was an important error on behalf of the government. The judge's decision, and I have nothing against the justice in question or the Superior Court of Quebec. Every court has its own jurisdictions and decisions. Whether the judge was important in 2017 or recently, that's good, a good thing. But with all due respect, this issue is such a delicate one. Regardless of the legislation that will be adopted, there will be court challenges. And it is normal and even preferable and responsible on behalf of the government to bring this case to an appeal before the Supreme Court, like my colleague said so well earlier from Alberta. Because when you read the Constitution, you understand that there's the Superior Court in all provinces, the Appeals Court, and then there's the Supreme Court.
Madam Speaker, we need to have the highest degree of evaluation. And in that specific case, the Superior Court of Quebec is good, but it's not enough. We need to be sure of our judgment on that. So this is why the government should have appealed to this decision, and then let the Supreme Court judge decide what is good and what is right based on the law, based on our constitutions, based on our Canadian history that we are proud of. That's how it works. But not, Madam Speaker. This government decided to call the shot right now. I heard my colleague from Winnipeg, always articulate as usual and always passionate. But with all my respect, I don't agree with him. It's not because we are calling this decision to the appeal court, then to the Supreme Court, that we pay no respect to this Superior Court of Quebec. C'est simplement, Madame la Présidente.
It's quite simply a question of respecting the judicial process as it's described in the Constitution, particularly when it's such a delicate issue like MAID. And despite the legislation we're going to vote on here, we can expect it to be challenged before the courts. If we have legislation that is based on the Supreme Court decision, rather than one that is based on a Superior Court decision, that would have been preferable. And with all the respect I have for the justice from the appeals court and for the Superior Court of Quebec, that played an important and an essential role, a serious one, in our legal system. So, Madam Speaker, and now we're faced with the debate that we're holding here in the House of Commons now. Before we were dealing with COVID, before we knew what the focus really would be, rather than how we were holding our sittings now. So we learned a lot of new things in 2020. But this legislation, C7, was presented for the first time at the House of Commons on February 24th. There was a decision on September 11th from the courts, and then the government did consultations, and then they tabled C7 on February 24th, and they started debate at second reading on February 26th, 27th. There was a rigorous debate. Okay, great. Even though we would have liked to have had this case go before the Supreme Court. But, Madam Speaker, COVID happened. The government did what it had to do. It suspended the study of that bill. It asked the court for an extension of the deadline, and that was accepted. It did what it had to do. And we resumed parliamentary sittings in September. And that, Madam Speaker, is when the government made a fundamental mistake. Let's talk about the very basis of the issue with C7 now. As I said earlier, this bill can never be unanimously supported because our society isn't unanimous in this respect. Some people are for it, some people are against it, some people vote left, some people vote right, some are federalists, others aren't. Our society is not homogeneous. There are various different textures, and that is the type of discourse we have to preserve. And this is why, Madam Speaker, that throughout the analysis that was conducted, many amendments were put forward. They were very respectful and reasonable amendments. They were amendments that were intending to protect the most vulnerable members of our society. And these amendments said that they wanted to reestablish the 10-day waiting period when death is reasonably foreseeable, but when it's not, to extend the reflection period from 90 to 120 days. That could have allowed us to ensure that the person who is deciding is doing this with all the necessary time they need for reflection. And that is why, Madam Speaker, we've had prestigious organizations that have spoken out against C7. There's the Canadian Psychiatrists Association that says that it had very serious reservations with respect to this legislation. Also, the Disabilities Association of Canada that it was against it, and Inclusion Canada as well has spoken out against it. There are Indigenous and spiritual leaders that have also expressed their concerns. Our society has spoken, and that is what interesting debate involves. So things had to be done properly. Sometimes you're for or against something, but the debate had to unfold correctly. We would like to have had full debate without having had this heavy deadline that was imposed by the Superior Court of Quebec. And now I'd like to talk about our work as in parliamentarians, which is essential. C7 was tabled in February, and then it came back to the House. And then the government decided to prorogue the House. And when you do so, Madam Speaker, well, they prorogued it, we know, because the Prime Minister wasn't happy with the ethics and charity work that was happening at committees. So things were heating up for the Prime Minister, and then he prorogued the House. And when you prorogue the House, all the work that was happening before falls by the wayside, and we had to go back to C7. And we lost 24 days of parliamentary work. If the Parliament hadn't have been prorogued, we would have resumed our sittings on earlier, and all the work that would have been done on this legislation would have been applied, and we would have had 24 days of parliamentary sitting, extra days on this legislation. And now, if I accept the fact that the government has the right to prorogue the parliament, how come it did wait so long to present this legislation? And they're saying, yeah, we have to rush this too quick, the deadline's coming up, and we have to get this done by December 18th. But Madam Speaker, the government made its throne speech on September 23rd. And do you know when C7 was presented for the first time? It could have been presented on the 24th of September or the 25th, like C3 on the Judges Act. Do you know when they presented it? October 5th, Madam Speaker. 7 parliamentary days were lost because of that. The Conservatives, they say, keep on talking and they're wasting our time. No, that's not the case. It is them, Madam Speaker, that decided to prorogue the Parliament and waited all that time, and that dragged their heels and waited 7 parliamentary sitting days before tabling the legislation. And now there's a deadline for December 18th. So, Madam Speaker, I cannot be left held responsible for the decision by the Superior Court of Quebec that wants us to have a deadline by December 18th. The full responsibility lies with that government, and I will never tolerate them accusing us of anything, because never, Madam Speaker, whether it's at second reading or at parliamentary committees, when we studied the legislation, or at third reading, never did the Conservatives act meanly. They always brought forward their opinion. We've always brought forward our opinions. There are those who are for or against it, but in a respectful manner.
Any other rules to be sure that we will let it go and without any decision made. We were respectful, Madam Speaker, because this issue calls for being respectful. And we did it correctly. I am very proud, Madam Speaker, to be the parliamentary leader of the House of the official opposition, because my people, the people of this side of the House, the people of the official opposition, did a tremendous job at each and every stage. They were very serious. They were very parliamentarian. Never they used filibuster rules or whatever. They did it correctly, and I can tell you that I'm very proud to be the parliamentary House leader of this group, Madam Speaker. Contrairement au...
Unlike the Liberals, who at the Finance Committee filibustered for more than 16 hours to prevent the WE scandal from coming to light, without talking about the Ethics Committee, where they filibustered for more than 40 hours, well, that's what you call wasting people's time. No, we did serious and rigorous work here, and we're very proud of that. In terms of the deadline of December 18th, it's the government that feels it's being taken hostage by that deadline. And if legislation is not adopted by the Canadian Parliament before that time, because it also has to be adopted by the Senate, what will happen? C14 will continue to apply, and the Truchon decision will be applied in Quebec. So, of course, what was set out in C7 won't be in effect, but things will continue. Things will move forward like it has since the beginning. The Truchon decision will be applied in Quebec. And one last thing, Madam Speaker, and such an important point.
A vote. I'm very proud, Madam Speaker, to be the House leader of the Conservative Party, where on this issue, each and every member has the right to vote on his or her own belief. The best proof of that, Madam Speaker, my leader, the future Prime Minister of Canada, MP from Durham, vote against, and I did for. So this is what democracy is all about, Madam Speaker. In our own party, you have people who vote against, like my leader, and you have me, House Leader, who vote for. That's what democracy is all about, Madam Speaker. We should fight for that. Even if I disagree with some of my colleagues, and even if all my colleagues behind me are not against or are not pleased to see that I will vote in favor, so what, Madam Speaker? This is what democracy is all about. We should fight for that. We are the only party, Madam Speaker, to preserve that tool so important, that tool that can fight cynicism in politics. And yes, I'm proud to be part of that team. Au cours du vote, Madame la Présidente.
During the vote, Madam Speaker, on the amendments, there were Conservatives who voted against the amendments. And when we had to give our opinion on the report, 13 Conservative MPs voted with the government on this bill. And I was amongst them. 6 Quebecers, 6 MPs not from Quebec. There were Francophones and Anglophones from Western Canada. I voted for it, but my colleague from Portneuf-Jacques-Cartier, who was very close to me, voted against it. And that is what democracy is. And that is what full freedom of conscience is. We can vote on these issues, and we can preserve the work of parliamentarians properly. And I condemn the fact that this government dragged its heels, and now we are facing a stiff deadline. Thank you. Questions and comments. The Honourable Member for Ménigouska-Ristigouche. Thank you very much, Madam Speaker. When I hear my colleague, who I have great respect for, saying that the government was dragging its heels, everyone will remember that the Carter affair that was behind us, C-14, was kept in the closet by the Conservatives for months. And the Supreme Court of Canada ordered the government at the time, the Harper government, to produce legislation. And they dragged their heels for 10 months. And when we came to power in 2015 with only 2 months to create C-14. So I'd like to ask my colleague who says that either we're dragging our heels or we're going too fast. In terms of C7, this is a bill, is the logical next step after C14. Knowing that my colleague sat on the mixed committee with me, the joint committee, does he think that C7 is a natural next step from C14? Did we not conduct the necessary consultations to allow? Thank you very much, Madam Speaker. I'm always happy to hear from my colleague from New Brunswick. I'd like to pay tribute to his very serious work. I have a great amount of esteem for him. First, at the time when we were on the eve of a campaign, an election campaign, and that is the pinnacle of partisanship. So everyone's fighting for their seats, and there are debates that take place that are very partisan. But in terms of MAID, we really didn't have to be partisan, and that is why I think that the Harper government did the right thing. They said, let's let the next government deal with this situation. Let's ask for an extension from the court, and that's what happened, rightly so. So in terms of the C7's relationship to C14, well, my colleague should know full well that the Canadian Bar Association had very serious reservations with respect to some of the rules that are included in C7. And I'd like to remind everyone that none of them have voted in favor of it.
Thornhill. I think you're on mute. The Honourable Member for Thornhill.
Thank you, Madam Speaker, and I'd like to commend my honourable colleague for the powerful logic of his remarks today. And while we know the Liberals have blocked reasonable amendments to protect the most vulnerable in committee and here in the House, we also know that the Minister for Disability Inclusion testified before the Senate committee pre-studying Bill C-7 that she has grave concerns, that she regularly hears from people who are appalled to discover that a family member with a disability has been offered what she calls unprovoked medical assistance in dying. Now, we also know that the Liberal House Leader has questioned the acceptability of amendments to be made potentially in the Senate. So I wonder if my colleague could address the legitimacy of possible amendments when C7 does arrive in the Senate for better protection for the most vulnerable.
Honorable député de Louis-Saint-Laurent.
Thank you so much, Madam Speaker. I want to pay all my respect to my honourable colleague. For him, I have a lot of respect, and if I do remember quite well, he voted in favour of the amendment, but voted also in favour of the bill. So, Madam Speaker, the point is that we have always to think of the most vulnerable. This is what we have a job to do. Yes, but we respect also the process. So this is why my colleague from Edmonton St. Albert, or Edmonton St. Albert, as I should say, tabled 2 amendments. We were very reasonable to protect the most vulnerable of us. And so the House decided, and the House voted against those amendments. It's sad, but this is the reality. We shall respect the will of the House of Commons. But as Madam Speaker, we have to respect the will of the House of Commons. We shall respect the will of the Senate. And most of the senators there have been appointed by this Prime Minister. So let the Senate work. So this is why, Madam Speaker, when we will finish on the 3rd reading, and then we will have the final vote here in the House of Commons, the job will continue at the Senate. And yes, as the member from Thornhill said, they had some consultation before. Among them, the Minister for the Personnes Handicapées. Sorry for that, I don't know the right word in English. And she had some concern too. Why the Prime Minister pushed so hard, and especially a senior cabinet minister who is there to protect the most vulnerable.
Questions et commentaires, the Honourable Parliamentary Secretary.
Thank you, Madam Speaker. And I must say, you know, the member is a very much a distinguished parliamentarian, both from the provincial legislature and national legislature here in Ottawa. And he's very much aware of process. When we make reference to, for example, the Conservatives attempted to bring amendments in hopes that if they had those amendments passed in committee, then they would be in a position to support the legislation. But the member is also aware that we don't have a majority government. And that means that he couldn't get the support of opposition members to support the Conservative amendments. Just like today, the Conservative leadership support not passing this legislation. They've made it very clear, the Conservative leadership, that they would have taken it to the Supreme Court of Canada, that they didn't get their amendments, so the Conservative leadership doesn't support the legislation. My question to the member is, would he acknowledge, in the name of transparency, that it is the Conservative Party, it's not the process, because if they want to, even if we debated this for another month, they have the mechanisms, the tools, and so forth to ensure that it never comes to a vote. The mechanism is there. So it's the Conservative Party House leadership that doesn't want it to come to a vote.
Madam
Speaker, may I remind the honourable colleague from Winnipeg Centre North that I deeply appreciate that, as I said earlier in my speech, the leader of the official opposition voted against and the House leader voted for. This is the best democracy demonstration that the Conservative Party respects each and every one and each and every opinion. Even if all my colleagues around here who applaud me, or maybe there's a deception for them to see or to learn that I will vote in favor of that. But this is what democracy is all about, Madam Speaker. And yes, as I said earlier, we would have preferred to see the Supreme Court tabling a decision on that issue. Because whatever happened, Madam Speaker, and the member knows it quite well, it will be challenged in the court. So as far as I'm concerned, as far as we are concerned, it would have been preferable to have a bill based on the toughest jurisdiction, which is the Supreme Court decision to build a bill that we can oppose or support, but at least the foundation will be on the greatest and the toughest and the highest court of this country, the Supreme Court of Canada. Thank you, Madam Speaker.
Questions and comments. The honourable member for Flamborough-Glenbrook.
Speaker, and my colleague started out by saying that the problem with this debate often is that motives are being impugned. And unfortunately, I'm going to have to come to his defense because the member from Winnipeg North impugned his motives. I want to say, Madam Speaker, that my colleague from the NDP, the great musician, made an excellent point earlier. This government will take First Nations to court. They'll take veterans to court, but with a life and death situation, they won't deal with that in the Supreme Court of Canada. How does my colleague feel about that?
L'honorable député de Louis Saint-Laurent.
I feel very uncomfortable, Madam Speaker. And my colleague raised the issue of the First Nation, saying that this government is ready to put First Nation up to the Supreme Court. Madam Speaker, First Nation leaders said they are concerned with this bill, as the Psychiatric Association of Canada have some concern with that. There is no link with the Conservative Party of Canada. No. This is the Society of Canada who have some concern. And more than that, Madam Speaker, us as human beings, we can change our mind. A friend of mine, Madam Speaker, who was a strong supporter of assisted dying policy, changed his mind. Why? Because his father had suffered 2 years ago. And then he had to fight with him with that. And he said, well, you know, I was a strong supporter of assisted dying policy, but no more, because I live with that person, with my father. That's what he told me. So, Madam Speaker, as I said, there is no right, no wrong decision. There is no right, no wrong vote. There is just vote and decision on which we feel comfortable. Thank you, Madam Speaker.
Resuming debate, the honourable member for Abbotsford.
Well, thank you, Madam Speaker, for the opportunity to again speak to this bill. There were a lot of things that I wanted to say the first time around at report stage that I couldn't share because we ran out of time, but hopefully I'll be able to conclude my remarks today. I am splitting my time with the member for Northumberland, Peterborough South. And our leader of the opposition spoke in this House earlier today, and he talked about how this legislation, Bill C-7, is moving our country from a regime of assisted death to a regime of assisted suicide. We presently have in place Bill C-14, which was brought in as a response to the Carter decision. And that response, that Bill C-14, recognized the fact that the Supreme Court had said that assisted death, medically assisted death, was a right, but needed to be surrounded by guardrails, by safeguards that would ensure that the most vulnerable in Canada do not end up dying when they have an opportunity to live a productive life. And that Carter decision resulted in legislation that imposed a requirement that death needed to be reasonably foreseeable. Now, Madam Speaker, this legislation before us eliminates that and a whole bunch of other safeguards that the original legislation was intended to keep in place. Now, why are we at this place in the first place? That's the question. Well, members in this House know that a lower court from Quebec, one single judge, ruled in the Truchon case that the reasonable foreseeability aspect of Bill C-14 violated the Charter of Rights. It was not enforceable. It was unconstitutional. Now, this is a lower court from Quebec, one single judge, making a life and death decision for Canadians across our country. And so one would expect that from a government, a Liberal government, that takes veterans to court, that takes First Nations to the Supreme Court of Canada, you would expect that this life and death decision would be appealed. The Truchon case would be appealed through to the Supreme Court so that we can have the Supreme Court that articulated the Carter decision so that it could comment on whether reasonable foreseeability was in fact constitutional. But instead, this government said, no, we're not going to appeal. In fact, we're simply going to respond to the Truchon case. We're going to do exactly as that judge, a single judge of a lower court, asked us to do. And so they eliminated reasonable foreseeability from Canada's medical assistance in dying regime. That's why we're here. You may recall, Madam Speaker, back when this C-14 first came forward, when the Carter decision had to be responded to, that we as parliamentarians, we noted the fact that this represented the crest of a steep, slippery slope towards making assisted suicide available to a broader and broader and broader group of Canadians, vulnerable Canadians. And that was a concern we expressed at the time, and quite frankly, some people mocked us. You're fear-mongering, they said. They poo-pooed our concerns. And today, here we are. Our concerns have been borne out. Now, Madam Speaker, last time I didn't get a chance to read into the record a letter from a doctor from my community of Abbotsford, Dr. James Warkentine. Now, Dr. Warkentine has expressed his concerns about this legislation, and I'm going to quote from his letter. Quote, I appreciate your invitation to write to you regarding C7. As family physician, the decriminalization of medical assistance in dying in 2016 struck me at my core. How could killing someone one day cost me my license and send me to jail, and the next day be expected of me to provide? Furthermore, how could our most vulnerable be protected from the pressure to end their life one day and then have state-sanctioned avenues the next? And then he goes on to reference the 6 reasons why over 1,000 Canadian physicians have signed a letter opposing Bill C7. And in a moment, I'm going to read that letter into the record, because I believe those judges would appreciate having that letter on the record, so it's very clear that many, many medical professionals across this country oppose Bill C7, which removes many of the safeguards, the guardrails, the protections for the vulnerable that were originally intended under the Carter decision. So I'm going to read this into the record, Madam Speaker, and it begins like this. This bill, expanding medical assistance in dying to virtually everyone who is sick and suffering in Canada, will, if passed in its current form, make our country the world leader in administering death. As medical doctors, we feel compelled to voice our dismay at how individuals who have little lived experience of the realities involved in the everyday practice of medicine suddenly and fundamentally changed the nature of medicine by decriminalizing euthanasia and assisted suicide. Just as a side note, Madam Speaker, when they refer to individuals having little lived experience of the realities of everyday practice of medicine, they're referring to us parliamentarians in this House. So I'll go on. Unfortunately, our patients are the ones who suffer the most from the consequences of this ill-devised scheme. The shock of a sudden illness or an accident resulting in disability can lead patients into feelings of anger, depression, and guilt for requiring care, emotions that, with proper support and attention, can resolve over time. The care and encouragement shown by physicians may be the most powerful force in overcoming despair and providing hope. Unfortunately, patients can no longer unconditionally trust their medical professional to advocate for their life when they are at their weakest and most vulnerable. Suddenly, a lethal injection becomes a part of a repertoire of interventions offered to end their pain and suffering. Bill C7 would allow those who are not dying to end their lives by lethal injection at the hands of a doctor or nurse practitioner. Shockingly, most of the safeguards that Parliament deemed necessary in 2016 to protect the lives of vulnerable individuals from wrongful death are being removed. Under the new bill, an individual whose natural death is considered to be reasonably foreseeable could be diagnosed, assessed, and euthanized all in one day. We are very concerned that removing the 10-day reflection period and other safeguards will lead to an increase in coerced or tragically unconsidered deaths. The reckless removal of safeguards previously deemed essential will place desperately vulnerable patients directly in harm's way and cost them their very lives. Our profession has been coerced into facilitating suicide rather than preventing it for ever-increasing numbers of citizens. We watch in utter dismay and horror at how the nature of our medical profession has been so quickly destroyed by the creation of misguided laws. Madam Speaker, that is an excerpt from a letter from over 1,000 physicians in Canada. It does go on, but I don't have time to complete it. So, Madam Speaker, that is the perspective coming from our medical profession across our country, and it's the disability groups, medical professionals, faith groups, palliative care advocates, First Nations, all calling for more caution before expanding assisted suicide, and yet this government has refused to listen to those concerns. At the committee, Madam Speaker, you may recall, our Conservative opposition members brought forward numerous amendments that would have addressed some of the failings of this legislation, that would have reinstated the protections that the vulnerable within our country are calling for. 72 disability groups that oppose this legislation. They want more protections, and yet they're not there. So, Madam Speaker, please, please, I encourage my colleagues across the way to give this legislation more time, give us an opportunity to get this right. Thank you, Madam Speaker.
Questions and comments? The Honourable Parliamentary Secretary.
Yes, thank you, Madam Speaker. Whether it's the Supreme Court of Canada over 5 years ago through the Carter decision, to the Superior Court decision of the province of Quebec, whether it's parliamentarians of this session or the previous session having opportunity to debate, there are literally hundreds, if not thousands, of hours of discussions and debates inside the House of Commons via committees, chamber debates, second and third readings, and so much more. Literally hundreds of thousands of Canadians. This has been an issue that has been debated in a very passionate way for many years. Let there be no doubt, Madam Speaker, that every life is of equal value. But Canadian society, I believe, wants to see the legislation that is being brought forward. My question is to the opposition, official opposition. When they were in committee, they did propose amendments, and had those amendments passed, I would assume they would have passed this legislation. Yet, it wasn't just the Liberal Party. Other political parties in the House also agreed. Can the member provide his thoughts in regards to that issue?
The Honourable Member for Abbotsford.
Well, Madam Speaker, the member has suggested that the contents of Bill C-7 have been debated for years and years and years. Come on, this legislation has just been brought forward by this Liberal government. The issues of expanding medical assistance in dying to effectively become assisted suicide, those issues need fulsome debate because it is an issue of life and death. And unfortunately, this member doesn't realize that. He doesn't understand how critical it is that the 72 disability groups across Canada who fear that this legislation will put their members at risk, the most vulnerable in our society, whether it's the poor, whether it's children, whether those that have mental health issues, they all feel vulnerable under this legislation. Why is that? And why is the Liberal government not listening to those concerns?
Questions and comments. The Honourable Member for Yorkton Melville.
Can you hear me? There's no less. Okay, great. I really appreciated what my colleague had to say, and on this side of the floor, I am thrilled to be part of a party where we allow conscience protection within our own party when it comes to voting on bills like this. We've stressed that this isn't a partisan issue. With what we've heard from Canadians across this country, this impacts them at their core. So just a little feedback from him on that concept of being able to vote our conscience. And I actually grieve for people across the floor and around me that I don't think have that freedom, and that is something that Canadians absolutely are looking for in their government, the realization of our responsibility in these circumstances to vote our conscience.
Member for Abbotsford.
Well, Madam Speaker, I thank the member for that excellent question, and I'm safe in saying in this House that it is the Conservative Party that is the only party in this House that takes free votes seriously, that actually regularly provides our members, our MPs, with the avenue of saying yes to legislation or no to legislation, especially when it's on issues of conscience. And I would extend that, Madam Speaker, to protections that should be available to doctors, to physicians, to medical practitioners across Canada, not to be involved in any way in facilitating assisted death or assisted suicide. And yet across our country, our physicians are being told, well, you know what? You're going to have to refer. It's part of your obligation as a physician now to refer someone to another physician if in fact you yourself will not counsel on the issue of medical assistance in dying. Madam Speaker, that's not about a country that respects freedoms, respects conscience rights. We need to step into that gap, protect our physicians against doing something against their consciences, in the same way our leader, the Conservative leader, provides us as parliamentarians a free vote on any matters of conscience.
Resuming debate, the honourable member for Northumberland, Peterborough South.
Thank you very much, Madam Speaker. And I have to say, I've been a little disappointed at the tenor of the debate recently regarding MAID, and I'm hopeful that we can carry this back to the sort of the passionate but compassionate debate that we had earlier in the debate. I would first of all say that this is a matter of conscience, and certainly very proud to be part of a party that has given me, as the member of Northumberland Peterborough South, the freedom to decide how I would like to vote on this. And so when we look at this legislation, I'm after extensive consultation with folks in my riding and outside of my riding, there have been a number of issues that have been occurred. And the challenging part for me, Madam Speaker, is that despite many persons with disability advocates raising the alarm bells, numerous media attention on that and how they might feel, is that we really haven't seen any amendment, any changes to this legislation. I would say this in all earnesty and openness to my friends across the aisle. Are we so arrogant that we believe that this language is absolutely perfect and completely beyond improvement? Because I know the member from Papineau was used to say a number of times, there's always room to be better. There's always the opportunity to be better. And I would say that to them with all kindness and respect, that this bill can be better and that there are opportunities. And we have seen that legislation that this government has put in the last year alone has failed. We saw that the rent subsidy program didn't go off as well as they had hoped. I think all reasonable observers and even members on the other side would acknowledge that. And that's why they had to relaunch that program. We've seen the LEAF program also is not working up to capacity and no doubt will have to be redone. And we've seen the challenges. The difficulty, Madam Speaker, with this legislation is that there is no ability to redo. This is a life or death matter. If we lose members of our most vulnerable communities due to this legislation, we cannot come back. There is no redo to this. So I am perfectly aware as a lawyer the obligation that the court has put in front of us from the Truchon decision to get this legislation revised. However, there are multiple devices, as our leader spoke about, to get that time either extended. And I would, in all respect and fairness, say to them, and I think any reasonable objective observer would say, it was their party, it was the government that, of course, prorogued Parliament for an additional 6 weeks. And we would have had the time to pass this on time. But I would just say, and I'll get into my remarks, let's keep the tenor of this debate how it's meant to be, how our constituents want it to be a deep discussion of the important issues of passion, the very reason why our parliament exists, the very reason this reasonable debate is what makes Canada, in my opinion, such a great country. Though, and to get into the substance of my speech, those who support Bill C-7 don't want anyone to suffer. Those who support it don't want to see anyone suffer either. I think it's important to begin this controversial debate by recognizing that both sides, regardless of how different their beliefs are passionate for the right reasons. And as with any legislation that will have a dramatic impact on the people's lives, I believe the discussion is very important. Medical assistance in dying is a relatively new topic. Canada is one of the few countries that has legalized it so far, and as such, we must proceed in this new territory with the utmost caution. As our members have spoken about, we need the safeguards, and this isn't just members of the Conservative Party who are mentioning this. This is some of our most noticed jurists in Canadian history who have brought this up. Jurists from all sides of the political spectrum who have called for and really demanded that there be safeguards because, as we say, and it's only common sense, this is a matter of life and death. And while I believe that we should be guaranteeing a death with dignity, and I believe strongly that we should first guarantee a dignified end of life. And in order to do this, in order to make sure that people are choosing medical assistance and dying for the right reason, I believe that we need to have a conversation around the state of palliative care in our country. Unfortunately, Madam Speaker, the state of palliative care in our country is less than favorable. While medical assistance in dying is currently considered an essential service, palliative care is not. This is an issue that should be gravely concerning everyone in this House and across our country. Palliative care is a type of health care for patients and families facing life-limiting illnesses. It helps patients to achieve the best possible quality of life right up to the end of one's life. I know, and I'm sure that many members share this with me, I have had some of the most important conversations of my life with loved ones and with friends at or near the end of their life. These moments provide so much quality to those who carry forward, and so much advice that I carry forward with me to this very day, that where it is possible to retain a reasonable quality of life, we as a society have a sacrosanct obligation to make sure that people are taken care of, so that if they do in fact decide on medically assistance in dying, they've done so of their own free will, not because of a poor quality of life that could have been avoided. Quality palliative care, of course, focuses on the concerns and patients of family and works to support patients through both physical and mental symptoms of serious illness. This may include everything from helping to manage a patient's pain and symptoms to keeping them comfortable in their home for as long as possible. Unfortunately, while 75% of Canadians would prefer to have their last moments at home, only about 15% have access to palliative home care, and 60% die instead of being surrounded in the homes that some of them have grown up in, die in the cold, stark hospitals. Many physicians have raised the concern because of the majority of Canadians don't have access to high-quality palliative care. It is possible that many people who choose MAID may be doing so, that there are at least some people who may be choosing MAID because that they don't feel there are other options. Amongst the concerns are laid out by Dr. Stephanie Caffey, a family physician in Niagara Falls with a focus on caring the elderly, has said, something that has not been considered in the rush of passing this bill is the state of palliative care. It is not considered an essential service. However, MAID is. In my experience, when many requests were made reflected a need for palliative care, rushing misguided laws regarding the medical profession has led to an erosion of our profession and started to significant damage to doctor-patient relations. Our hands are tied. We are consulted on the drastic changes that are being made. As Dr. Caffey notes, the importance of consulting with doctors in the creation of legislation is so crucial. As so often is the case with parliamentarians, not enough people working on the legislation have any experience in the field itself. Dr. Dribber, a palliative care physician, has spoken out on this issue, stating that this legislation seems to ignore the importance of the dignity that comes with palliative care, the importance of those final moments for both the living and those who will pass on. He has gone so far as to say that the government seems as though the government hasn't fully consulted with experts or people who work in the field to help them guide them through their decision-making process. Madam Speaker, when we come to a conclusion here, I would just, in all earnesty and openness, with my arm reached out to the other side, they know that there are people in their constituencies that have differing opinions than them, as do I, that we need to make sure that all voices are heard. Are we so arrogant as parliamentarians that we shouldn't change the legislation, that we can't, as a member from Papineau said, always do better?
Comments, questions et commentaires. The Honourable Parliamentary Secretary.
Yes, thank you, Madam Speaker. Where I agree wholeheartedly with the member is in regards to the issue of palliative care, home care services or long-term care services. And even though these are provincially administered, that the national government does have a role to play. I have always believed that, and it goes beyond just transferring of cash. That we have to ensure that there's some standards, that there is opportunities for individuals to be able to have those types of services, in particular palliative care. We have too many palliative care patients passing in hospital hallways and rooms, Madam Speaker, versus in a proper palliative care facility or in a home. And I'm wondering if my friend could provide his thoughts in terms of to what degree he would like to see the national government take a more proactive approach in working with governments, other governments, and possibly what role he believes Ottawa should be playing in ensuring that there's more consistency across Canada when it comes to these types of services, in particular palliative care.
The Honourable Member for Northumberland, Peterborough South.
Thank you for that very well thought out and very reasonable question. And I understand completely that the members' intentions are nothing but the best to make sure our seniors and those who are at the end of their life have the best possible care. What I would say to him is that it's also important to enable innovation and provincial innovation, and so that we can see that the province of Quebec is able to do the best, or the province of Ontario, that we are able to get those best practices across the various provinces. It's also, if not critical, that we manage our finances well so that the federal government is in a position to enable to properly fund healthcare transfers, not as they were slashed underneath the Chrétien government.
The Honourable Member for Chatham-Kent Leamington.
Thank you, Madam Speaker. I want to thank my honourable colleague for his comments. His background is in the law. He's a lawyer. And so my question is, there were concerns expressed in 2016 with the legislation then about the potential for judicial creep. And now we're experiencing some of that. But why would the decision then not be appealed to the Supreme Court, where the court could actually uphold some of the guardrails and safeguards that they put in place? I'm wondering if my honourable colleague would have a comment on that.
Honourable Member for Northumberland, Peterborough South.
I thank my colleague for the excellent questions, and truly I believe that we have some of the most brilliant jurists in all the world in Canada in our upper courts and in Supreme Court and at our lower courts as well. So why we would not give them the opportunity to put their learned intelligence and wisdom to this legislation, I just don't understand. And as we've seen, our justices have much to contribute to this debate, whether it be Justice McLaughlin or Justice Corey or Justice Sapinka. They have all offered so much to this debate and to this discussion. In many ways, they define the very terms of this conversation.
The Honourable Member for Timmins, James Bay.
Thank you, Madam Speaker. I always like listening to my colleagues, and I especially like listening to my friend from Winnipeg North because he really focuses the discussion so clearly. Because he said how he thinks it's really important to learn lessons about palliative care and how could the federal government play a role. Well, he stood in the House with his Prime Minister when we brought forward a national palliative care strategy, and the Liberals voted for it. And I raised it during the first round of discussions on end-of-life bill and said, why don't we have a palliative care strategy? And the Liberals said, oh, well, we will, but we have to respond to the Supreme Court. We have to do this first. So here we are. We've got another end-of-life bill, and we have the Liberals saying, can anyone tell us how we could do a palliative care strategy? It's such a good idea. Maybe we could start some kind of conversation. When we've been through this, we voted on it. We told the Canadian people it would happen, and the Liberals did nothing. So how long is it going to take?
Well, Member for Northumberland, Peterborough South.
I think I might be in difficulty answering that question. I do certainly enjoy the member, and he is one of my favorite parliamentarians, I must say, with his ability to ask questions. But in response to that question, I do believe that the time for action is now, and would concur that unfortunately this government does have some challenges sometimes with the follow-through of their great words, as his leader would say.
Resuming debate, the Honourable Member for Langley-Aldergrove.
Thank you, Madam Speaker. I will be sharing my time with the member for Cypress Hills Grasslands. So here we are, December 8th, 2020, only 10 days away from a deadline imposed on this Parliament by the Quebec Superior Court in the Truchon decision. And the Liberal side of this House is suggesting that perhaps it is the fault of members of the Conservative Party for delaying progress on this very important topic. Well, I take exception to that. How did we come to this point in the first place? Our leader spoke this morning, and he raised this topic, and so I'm just going to repeat some of what he had said. First of all, there's the failure of the current Attorney General to have appealed this decision. This decision of the Quebec Superior Court, it's a lower court. It should have, in my opinion, it was a wrong decision, and it should have been appealed, first of all, to the Quebec Court of Appeal. We would have had the benefit of the wisdom of that bench, and then subsequently it should have been appealed, like all important constitutional issues finally end up at the Supreme Court of Canada. I have the deepest respect for the Supreme Court of Canada and the constitutional expertise and scholarship that has come out of that court, and this Attorney General has missed that opportunity to be able to engage the Supreme Court of Canada in a debate on this, in a discussion on this very, very important topic. This Parliament, as our leader said, is the top court of the land. We are sovereign. We can make and unmake any laws that we want, provided that they are within the four walls of the Constitution of this country. That's the dialogue that we should have had with the Supreme Court of Canada. That, sadly, will not be happening on this topic. Now, the second very important point is prorogation. We had been making good progress on Bill C-7. We were talking about this back in February and March already. Prorogation happened. The debate had to go right back to square one. How is that our fault? Why did the Liberal government decide for prorogation? Wasn't for any good policy consideration, was strictly for political consideration. So we're not going to wear that. That is the Liberal government who's going to wear that. Another point that I would like to raise is that if Bill C-7 reacted in the narrow way that the Truchon decision required, this debate would be much shorter, would be much faster. But this government has decided to take the opportunity to expand the debate. And they were suggesting that we are disrespecting the Truchon decision and the Quebec Superior Court by raising these issues. Well, we're not the ones who are raising the additional issues. It is this government in their Bill C-7 that is doing so. If Bill C-7 was just about the Truchon decision, then it would not be talking about removing the 10-day reflection period. The first annual report on medical assistance in dying in Canada, 2019, just recently published by Health Canada, has told us that of the 7,336 made applications in 2019, 236 of them, applicants, changed their mind during the 10-day reflection period. Obviously, that 10-day reflection period is there for a purpose. It's serving that purpose very well. Why are we removing that? Furthermore, C-7 is introduced the concept of advanced directives and consequently the elimination of contemporaneous consent by the person who is asking for medical assistance in dying, thus shifting the final decision away from the person receiving medical assistance in dying to the person who is now going to apply it. We are no further ahead. I don't think that that is an improvement. And then there's this other requirement, removing the second witness. Like, what's that about? Why is that so important? There's so many legal documents that require two witnesses, wills, for example, to make sure that there isn't coercion on the part of people who might benefit from, in the case of wills, being beneficiaries under the will. It's a long-standing legal principle that two witnesses would be required. These changes are significant, and disability groups across the country have told us so loudly and clearly. Of the many groups who appeared before this committee hearings, not one of them, not one of the disability groups, have been in favor of Bill C-7 and the removal of these protections. And that's why we're at an impasse on this 11th hour. I have a quote from Mr. Neil Belanger, Executive Director of the BC Aboriginal Network on Disability Society. He is commenting on a newly released document entitled In Plain Sight, which was commissioned by the British Columbia's Minister of Health, the Honourable Adrian Dix, to review Indigenous-specific racism in British Columbia's healthcare system. It's a review of BC's healthcare system, but the principles in it, I think, would apply right across Canada. Mr. Belanger and the group that he represents is concerned about the proposed removal of safeguards. And here is his quote: "There is no debating that the systemic racism and discrimination within Canada's healthcare system and the experience and deaths of Indigenous people when seeking care. We all would be remiss to believe that this somehow would not permeate into MAID, medical assistance in dying. Further, as I noted in my testimony, Mr. Belanger says to the Senate, the Government of Canada has failed to engage the Indigenous peoples of Canada living with disabilities, elders, and Indigenous leadership in relation to MAID on any tangible level. This lack of engagement is contrary to the government's stated commitment to reconciliation, to adopting the United Nations Declaration of Indigenous People and the United Nations Convention on the Rights of Persons with Disabilities. Other disability groups are saying the same. And yet this government is refusing to listen." And Mr. Belanger takes this a step further, Madam Speaker. He and the organization for which he speaks are advocating for sticking with the end-of-life criteria already in place after the Carter decision and after Bill C-14, which was a well-considered opinion of this Parliament just 4.5 years ago. Here's a quote from Mr. Belanger again. "Recently, his organization presented to the Senate Committee on Legal and Constitutional Affairs on Bill C-7 and stands with our sister disability organization and countless others across Canada in recalling for the removal of Track 2. That's the medical assistance for those people whose death is not reasonably foreseeable. In the proposed changes to Bill C-7 and limiting access of MAID only in the end-of-life criteria. Now, people may state the obvious that this is all water under the bridge. The Truchon decision said that that is unconstitutional. I go right back to my original comments. That decision should have been appealed. It's not. So I'm going to have to tell Mr. Belanger, sorry, that debate has been had already. This government, very sadly, has treated as settled constitutional principle that it is unconstitutional for any law of this country to refuse medical assistance in dying to those who meet all the other criteria but who are not dying. That is a fundamental shift that was not debated. This government often has stated on many occasions that, oh, we had broad consultation, 300,000 people responded. But the one question that they never asked was, do you agree that medical assistance in dying should be given to those whose death is not reasonably foreseeable? The fundamental question was never asked. That's not a true consultation, Madam Speaker. In my opinion, that's just a pretext for advancing a legislative agenda that had already been preconceived. It's been stated on several occasions in this House during this debate that the current Attorney General had voted against Bill C-14 4 years ago because it did not address that, because it did not expand MAID to that point. So this is the current Attorney General just imposing his will on Parliament, forestalling that very, very important debate. I just want to state one other thing. In the recent report on the state of, by Health Canada, on the state of medical assistance in dying, the first report, it stated that roughly 2% of Canadians who died in 2019 died of medical assistance in dying. So that's the average across the whole country. Much lower in some provinces, above the average in Quebec, and way above the average in British Columbia. Now, why is that, I ask myself? Is that because there are more sick people, more old people?
The member will have to complete that thought during the questions and comments. The Honourable Parliamentary Secretary.
Yes, thank you, Madam Speaker. I believe the bill that we're debating is a reflection of a great deal of effort, whether it's the Supreme Court of Canada decision 5 years ago to the Superior Court in the province of Quebec, to tens of thousands of Canadians, to literally hundreds of hours of debate inside and outside the chamber in the form of standing committees and so forth. And that's how this bill is ultimately reflected. It has the support, from what I understand, of New Democrats, Greens, Bloc, and of course the Liberals in terms of advancing, going forward. And what we do know is that it is not an issue of process. And I would counter any false argument presented by the Conservatives that it's about process. It is about that the Conservative Party doesn't want this bill to come to a vote because they believe that it should have gone to the Supreme Court of Canada. And I'm wondering if the members opposite would be transparent with Canadians and make that very clear as to the real reason why they're not supportive of the legislation.
Honourable Member for Langley-Aldergrove.
The real reason why we're not supporting this legislation is because it does not provide adequate protection for the disabled. This is not just members of the members of Parliament of the Conservative Party who are stating that. It is many, many disability groups who have bothered to come to committee to represent the opinions of their group, their members. So this is a broad discussion across all of Canada. And I'm wondering what the real reason is, why the Liberal government is not listening to those real concerns. We have offered reasonable solutions, reasonable amendments. They are turning them all down. It seems like they have predetermined what the outcome will be. They're not listening to the debate.
The Honourable Member for Vancouver Kingsway.
Thank you, Madam Speaker, and thank you to my honourable colleague for his speech. I just want to say that I've been listening to speeches all day today, and I want to thank all my colleagues for, I think, the very thoughtful and compassionate speeches from all perspectives that I'm hearing. I think it does the subject the justice it deserves. But one issue that I don't think I've heard anybody speak about today is Bill C-7 creates a waiver of final consent for those already assessed and approved for assistance who fear the loss of competence before their chosen date. This is colloquially referred to as the Audrey Parker Amendment. Audrey Parker was a woman diagnosed with stage 4 breast cancer, which had metastasized to her bones and a tumor on her brain. And she spent the last weeks of her life raising awareness about these challenges because she was worried that she would lose competence and be unable to give her final agreement because of the influence of the cancer in her brain. So she ended up ending her life prematurely early, which I don't think anybody wants to see. We all want people to get their fullness of life, and we don't want anybody exercising their right to MAID who does it before they would otherwise want to because of a legal requirement. I wonder if my honourable colleague has any comments on that part of the bill.
Honourable Member for Langley Eldergrove.
Good. I want to thank the members opposite for a very thoughtful question. The Audrey Parker argument is a very compelling one, I have to admit. Nobody wants any Canadian citizen to die earlier than they should. But I believe that the best argument against the Parker-Audrey principle, as sometimes people are calling it, is that last year alone, and we have hard evidence of this, last year alone, 263 people during that 10-day waiting period changed their minds. Now, I recognize that even under Bill C-7, there's an opportunity for people to change their mind if they're still cognizant at the time. But if they're not, then ultimately it's somebody else who makes the decision. Yes, Mrs. Parker probably would have signed that document, but ultimately it is the doctor then who has to make the final decision whether or not to apply the lethal injection. That doctor might be thinking she might be one of the 263 people who would have changed their mind. Why is it the doctor's decision?
Questions and comments? The Honourable Member for Thornhill. Oops, he's gone. L'honorable député de
The Honourable Member for Madawaska-Restigouche. Thank you very much, Madam Speaker. I'm listening with great interest to the debate on C-7, and myself, I was a part of the committee on C-14, and I heard the comments from my colleague who said he had great respect for the Supreme Court of Canada. And I'd like to remind him that we talked about C-7 a lot without talking about C-14 first, because C-7 is the natural extension of C-14. And I'd like to remind my colleague, if he doesn't remember, that the Supreme Court of Canada in the Carter affair rendered a unanimous decision. And he has great trust in the Supreme Court. So I'm wondering, is it not natural then to respect the Carter decision because Truchon filled some of the gaps in C-14 to accept that C-7 kind of wraps things up with C-14?
Well, thank you. I really do appreciate that question. It gives me an opportunity to distinguish the Carter decision and the Truchon decision. I do have the greatest respect for the Supreme Court of Canada. Great scholarship coming out of there. But the Carter decision underlined the importance of scrupulous regime of protection for and safeguards for the disabled. Truchon didn't undermine that, so there's no contradiction there. It is this Parliament that is contradicting Carter.
Resuming debate, the Honourable Member for Cypress Hill Grasslands.
Thank you very much, Madam Speaker. You know, it's always an honour to be here and to speak to the most important issues that we face here of our time. Earlier this morning, the Leader of the Official Opposition began today's debate with a strong speech about the problems with Bill C-7 and how the government has been handling everything about it. He started by saying it could be the most important bill before this Parliament, regardless of how long it actually lasts. After all, we're discussing a matter of life and death, and the decision we make here will make all the difference for countless Canadians. These are people who will be making their own choices, which will directly impact their own lives, their legacy, their loved ones, and their caregivers. It's a choice they might not have expected to ever have to make, whether it's because of a sudden illness, the unrequested suggestion of assisted suicide, or some other reason. Anything could happen, really. So that's why we have to maximize the amount of protection and safeguards there will be for each person involved, especially for those who are most at risk of abuse and neglect. At this last stage of debate in the House of Commons, I want to focus on the choice, or in some cases, the lack of choices that a person might face. Some argue that we are seeking their best interests by expanding access to MAID, not only for relief of suffering, but also purely for the sake of free choice. So going back to that idea of choice, we have to remember that this is not an ordinary decision. After someone dies, prematurely or otherwise, it is literally a point of no return. The decision is final, and along with all the different circumstances leading someone to consider end of life, it gets complicated very quickly. To explain it from someone's lived experience, I will quote journalist Ben Matlin, who suffers from spinal muscular atrophy. He wrote in the New York Times the following, quote, "I've lived so closely to death for so long that I know how thin and porous the border between coercion and free choice is, how easy it is for someone to inadvertently influence you to feel devalued and hopeless, to pressure you ever so slightly, but decidedly into being reasonable, to unburdening others, to letting go. Perhaps as advocates contend, you can't understand why anyone would push for assisted suicide legislation until you've seen a loved one suffer. But you also can't truly conceive of the many subtle forces, invariably well-meaning, kind-hearted, even gentle, yet as persuasive as a tsunami, that emerge when your physical autonomy is hopelessly compromised." End quote. So despite Matlin's significant physical disability, he is a father, a husband, an author, and a journalist. He has a successful life, and he knows what it is that he wants. He is less vulnerable than others who lack the confidence and spark in life that Matlin has, and could become easily persuaded that assisted suicide is their best option. In this way, the idea of this happening voluntarily is, by many subtle ways, the start of a slippery slope that leads to it happening less voluntarily or involuntarily. The choice isn't always so free, especially if their real alternatives are lacking. And you know, one of the greatest fears that a lot of people face in their lifetime really is their own mortality. And in a lot of breaths, that's what we are discussing here today. And when I talk about C7, when I talk about, facing our own mortality, I quite often, reflect back on the experiences that myself and my wife have had where, grandparents and other loved ones within our family have passed away, and we have spent countless hours at their side, either in the hospital, in their care homes. And that time that you spend with your family, it's so precious and it's so valuable. And just within this last year, my wife's grandma, she's in a position where her health has deteriorated. Her husband passed away a few years prior, and she's been living in I think it's a level 1 care for the most of COVID as it happened. And we weren't allowed to go into the facility. We had to stand outside the building. She had a nice corner unit there with lots of windows, so we were able to stand at the windows. And we were able to observe her condition. We were able to speak to her through the window. And over that course of time, we could steadily and progressively watch her state of mind and her physical state deteriorate and constantly degrade, all the way down to the point where it got to where she literally couldn't even lift her head when we came to the window to be able to talk to her. She couldn't see who was there. But when it got to, when the restrictions were lifted a little bit to the point where they would allow 1, maybe 2 people to go into the unit with her, where my wife, being one of those people, was able to sit down beside her grandma, to be able to hold her hand, and to be able to say, "Grandma, I love you." And to just see her state elevate again. Just to be able to uplift her spirits like that was so powerful. And I just think that as we're having this discussion on C7, we especially need to make sure that we are ensuring that we value life, to make sure that we are giving people every option to live their life, but also that we have the opportunity to have our loved ones at our sides as we go through those final moments, as we face the ultimate end of our mortality, the end of our life. And we need to make sure people have the full supports to them. And one of the biggest parts of C7, and I've, at risk of sounding like a broken record, I've talked at length previously about the need for palliative care, to make sure that we are providing real choice and real options to people. so that they have all the options that they need and, quite frankly, that they deserve. Because as we're talking about C7, the vast majority of people that are going to be considered for C7 or who will consider it are going to be in our senior population. So when we look at the contributions that they have had to our society, these are the people that built our country. These are the people that have provided us with the freedoms and the opportunities that we have here. And here we are today discussing and really going to be voting on a bill in the near future here, basically providing a way and signaling to them that we don't value your life, that we don't value the contributions that you have put to this country. That's what the bill signals. I know people will argue that that's not what the bill is doing, but sometimes it's not what the bill directly does, but what it's going to indirectly do. And the moment that we signify to our country, to our citizens, that we inherently don't value and defend life to its fullest extent, I believe that we are sending the wrong message to people. And at its core, I do believe that C7, the people that will advocate for medical assistance in dying, I realize that they are doing it from a position of compassion. And I will never question somebody who will say that is the reason why that they are advocating for C7. But we also need to realize that part of a compassionate response to people who are in that point in their life.
I apologize. The member will have 2.5 minutes to finish his speech after oral questions and 5 minutes of questions and answers. But we now have to go to statements by members. Déclaration des députés. The honourable member for Etobicoke Centre.
Speaker, Gandhi once said, "The future depends on what you do today. Today I rise to honor someone who shaped our future, but what she did every day." Last month, our community lost Anna Kisil. Anna immigrated to Canada from Ukraine in 1990, and with her family built several businesses. Then she gave back to our community, to Canada, to Ukraine, and not just with her generosity, but with her leadership, eventually becoming president of the World Federation of Ukrainian Women's Organizations. Anna received many medals and awards for her service, including the Ivan Mazepa Cross awarded by the President of Ukraine. What struck me about Anna is how she supported younger people to ensure that they could make a difference for today and for the future. In fact, one time Anna fought for me and gave me an opportunity without which I would likely not be standing here today living my dream, and I am not alone. About that moment, Anna once said to me, she said, "I fought for you because I believed in your potential to make a difference." Anna Kisil not only made a difference, but she helped others to do so as well, and in so doing made a monumental contribution to Canada, to Ukraine, to our community, for today and for the future. Vichnaya Pamять.
The honourable member for Carlton Trail, Eagle Creek.
Madam Speaker, I want to thank all those constituents who have reached out to me with their questions and concerns during this pandemic. Canadians have questions about the decisions being made by their governments and the plans to get their lives back. It is alarming to hear the pushback on citizens who are engaged and asking critical questions about the Prime Minister's own comments during a speech to the United Nations about a reset. By refusing to answer these legitimate questions and hiding behind name-calling, the Prime Minister demeans his office. To quote a recent article, labeling concerned citizens conspiracy theorists and claiming that those who accept the Prime Minister's very words given at the United Nations are succumbing to disinformation is sheer bullying. Our key to freedom and upholding democracy is knowledge, action, and civic involvement, end quote. I encourage my constituents to keep asking critical questions. We owe it to ourselves and future generations.
Honourable member for Richmond Hill.
Madam Speaker, I'm pleased to rise in the House to mark the first reading of my private member's motion, M36, calling for the designation of August 1st as Emancipation Day in Canada. Our motion calls for the House to recognize the abolition of transatlantic slave trade in August 1st, 1834. As well, the motion aims to recognize the significance that August 1st holds as a historic celebration of freedom amongst Black Canadians. I want to acknowledge the support that this motion has received from Senator Wanda Thomas Bernard and Honourable Member from Hull Aylmer and the members of all-party Parliamentary Black Caucus. I want to commend the valuable insight I received from community voices like Rosemary Sadler from Royal Commonwealth Society, the Ontario Black History Society, and the Canadian Association of Social Workers. In closing, I'll call upon colleagues in the House to vote in favor of designating August 1st of every year as Emancipation Day throughout our wonderful nation.
L'honorable député de
The Honourable Member for Montcalm. Madam Speaker, Acadia has a national holiday to underscore its history, the history of a proud, unique, but mistreated people. Every year, even in Montcalm, I feel these celebrations of Acadia on the 15th of August, and I'm very proud of that. I am a Quebecer of Acadian origins, and I represent a riding in which there is the Nouvelle Acadie, which is where several Acadian families ended up. But this year, because of the insensitivity of the bureaucratic apparatus, Acadians will be deported again symbolically because they're being asked to move their national holiday to Canada Day or Quebec's national holiday if they want to be subsidized. That's a frontal attack on the dignity of a nation which deserves that its national holiday be respected. It's a day that celebrates the resilience and the pride and the struggle of the Acadian people. What is the Minister of Heritage waiting for in order to do something about this affront? The Honourable Member for Brome-Missisquoi. Thank you, Mr. Speaker. On the 27th of November, 114 Canadians were brought into the Order of Canada. That is one of the highest honorifics in the country. I would like to today congratulate one among them, Christian Bartomeuf, a resident of Brome-Missisquoi and owner of the Frélisburg Domaine Clos-Serragnan. Throughout his career, he made many contributions to the world of winemaking by creating new methods of cultivating strains that are tailored to the Quebec climate. He is especially recognized as the inventor of ice cider, a famous product that has won many awards internationally. He has brought Quebec products abroad and has brought Quebec much notice on the international stage. After a 40-year career, he has never stopped innovating and continuing to offer new gastronomical projects from our region. I would like to send all of my congratulations to this winemaker and entrepreneur who makes our region, Brome-Missisquoi, very proud.
For Tobique Mactaquac.
Thank you, Mr. Speaker. On that starry night many years ago, there was a message of hope given in a very dark place of history, declaring, "Be not afraid, I bring you good news of great joy that will be for all people. On this night a Savior is born. Glory to God in the highest, peace on earth, and goodwill to all people." If there's ever been a year that we needed some good news to pierce through the darkness of fear, doubt, and despair, it would be this one. May we embrace the peace that was promised all those years ago and overcome the uncertainty and fear we face today. May the goodwill that was expressed that night continue to be expressed through our lives, as has been so clearly displayed in the valiant efforts of our frontline workers, small business owners, truckers, grocers, farmers, and fish harvesters, and so many others, who have all made tremendous sacrifices and have together laid the foundation for our country's comeback. May the love, joy, peace, and hope that was brought that night many years ago be with you and your family this Christmas and throughout the coming year. On behalf of my wife, Crystal, and our family, I'd like to extend to every member of this House and to all Canadians a very Merry Christmas and a happy and healthy New Year.
The Honourable Member for Pickering-Uxbridge.
Mr. Speaker, let's face it, 2020 has been the worst. But after hearing yesterday's announcement about vaccines rolling out, we know there's light at the end of the tunnel. Unfortunately, though, Christmas and the holiday season is still going to be difficult and different. And for some, it will be particularly difficult. So I'm asking the residents of my great riding of Pickering-Uxbridge and Canadians across the country to think this holiday season about helping to support local businesses by shopping local, or by, perhaps consider donating to local food banks, picking up a couple extra toys and donating to local toy drives. Because, Mr. Speaker, despite the difficulty this year, we can all, in the name of the holiday spirit, do our part to help make this year a little bit brighter for those who really need it. So, Mr. Speaker, Merry Christmas, Happy Holidays, and good riddance 2020.
The Honourable Member for Long Range Mountains.
Mr. Speaker, it's wonderful to stand in the House again on behalf of the wonderful folks of the Long Range Mountains, and I want to thank them and all Newfoundlanders and Labradorians for doing their part to control the spread of COVID-19 in our province. And as my colleague has said, the light is at the end of the tunnel. But today, as we take time to talk about church bells and sleigh bells and jingle bells, I want to speak of another bell, Charlotte Bell. Many of us know Charlotte as the CEO of TIAC, the Tourism Industry Association of Canada. We know her passion for the tourism and hospitality sectors, and we know that passion only grew during the pandemic. Her forward thinking and outright love for this industry, its leaders, workers, and clients, many of us have seen firsthand. We have seen the results of her hard work and planning among the many winding roads that she's traveled throughout our country from coast to coast to coast. Charlotte is now traveling along another road, and wherever this road leads, I know her passion for tourism will always be with her. So my friends, here and at home in the riding of the Long Range Mountains, when you hear the bells of the holiday season this year, I want you to pause and reflect. Be safe, treasure those near and dear to you, and may the road that we all travel on lead to a magical place. Merry Christmas.
The Honourable Member for Prince Albert.
Mr. Speaker, this summer, Canada lost a true friend and ally. Jim Phillips was the President and CEO of the Can-Am Border Trade Alliance for almost 3 decades. His legacy embodied this in the strong relationship and organization that forged between Canada and the United States. Under Jim's remarkable leadership, the essential decision makers from both countries could gather in one room and always left the game plan to fix any border irritant with real results following closely along. Without Jim's hard work, among many other things, we would not have Nexus cards or a border that flows reliably and safely as the 49th parallel. Jim will be greatly missed by all of us engaged on Canada-US issues, and we'll work tirelessly to keep up the work that Jim dedicated the last 30 years of his life to. Thank you, Jim. Rest in peace, my friend.
The Honourable Member for Sault Ste. Marie.
Mr. Speaker, this past Saturday, Lisa and I were very saddened to learn of the passing of our dear friend, the Honourable Ron Irwin. At the local level, he served as a school trustee, city councillor, and mayor. In 1980, Ron was first elected as a Liberal member for Parliament for Sault Ste. Marie and served as parliamentary secretary to then Justice Minister Jean Chrétien. Ron was elected again for a second term in 1993 and served as the Minister of Indian Affairs and Northern Development. Irwin was invested into the Order of Canada, a recipient of the Queen's Jubilee, and I had the honour to present him a Canada 150 pin for his exceptional public service career spanning over 35 years. Ron served not only our community, but our nation with strong conviction and persevering efforts. He served as Canada's ambassador to Ireland and as a consul general to Boston. I was blessed to have Ron as a friend and a supporter. Nobody campaigned like Ron. Rest in peace. Rest in peace, dear friend. Lisa and I offer your condolences, our condolences to wife Marg and his family and so many friends. And thank you from all constituents in Sault Ste. Marie for your years of service.
The Honourable Member for Selkirk, Interlake, Eastman.
Mr. Speaker, I just received hundreds of surveys back from my constituents raising concerns about poor internet and cell phone connectivity in our riding. The ongoing frustrations of the COVID-19 pandemic, especially with restrictions to work and school from home, have amplified their exasperation and demands for better service. Back in 2017, only 37% of rural households had access to the sufficient internet speed identified by the federal government, compared to 97% of urban households. But now in 2020, as more people are working, studying, and streaming at home, our already unreliable connections have worsened. This Liberal government has repeatedly promised to improve internet connectivity, but has failed to deliver. This is a slap in the face to my constituents who pay more to get less and often buy additional equipment like boosters just to get 5 megabytes per second downloads if they're lucky. Canada's Conservatives are demanding concrete action from this government to connect rural Canadians and eliminate these barriers to equal opportunity in today's digital economy and society.
On la députée de Bellechasse, les Etchemins.
The Honourable Member for Bellechasse, les Etchemins-Lévis. Mr. Speaker, the Liberals love to parade around the Davie shipyard and make all sorts of promises, but after the photo op, they leave and there's nothing left for the workers at the shipyard or for all the suppliers. And yet, the Coast Guard and the Navy have urgent needs, and only Davie has the capacity and availability to deliver these new ships here in the country within an appropriate timeline. The Liberals are claiming that the Davie shipyard is integrated into the naval strategy. But because of them, ferries are being built abroad. Mr. Speaker, the Liberals need to take action. They need to do something for the Davie shipyard by Christmas. They need to stop ignoring one of these incredible shipyards that are our pride as Canadians.
Kootenay.
Mr. Speaker, a few days ago we lost Dr. Myler Wilkinson, former instructor of literature and peace studies at Selkirk College in Castlegar. Myler was an accomplished scholar, an award-winning author, and an educator whose students often said he was the best teacher they ever had. Now, the West Kootenay has long had a strong vein of peace activism. There are the Doukhobors, whose motto is toil and a peaceful life. There were thousands of American opponents of the Vietnam War who found a haven in the Kootenays in the 60s and 70s. Myler and his wife Linda had the brilliant vision to build on this core of peace activism to form the Meir Centre for Peace Studies at Selkirk. It has flourished since 1999, providing courses on transformative justice and peace studies. I'm proud to represent a riding with such a brave and bold history of peace activism. We will all miss Myler, but we have the legacy of the Meir Centre to carry on his passion for peace on earth and goodwill to men.
L'Honorable Député de Lac-Saint-Jean.
The Honourable Member for Lac-Saint-Jean. Mr. Speaker, 30 years ago yesterday, Jean Duceppe, one of the greatest Quebec artists, passed away. He was an actor and a host, and he made a great impression on TV, radio, at the cinema, and at the theatre. He had many memorable roles, such as my Uncle Antoine in Death of a Salesman, Charbonneau and the Chef, and The Family Plouffe. He also founded a theatre company that still bears his name. He was an ardent defender of Quebec. He loved his people and left a remarkable cultural legacy. He was also my grandfather. He had many memorable one-liners. Towards the twilight of his life, I remember a particularly remarkable thing that he said, and it resonates just as powerfully as when I was a child. Quebec is our only country. Thank you, Mr. Speaker.
Honourable Member for Stormont, Dundas, South Glengarry.
Mr. Speaker, it's been nearly 2 weeks since the Minister of Health and I had exchanged a debate on the floor of the House here about ending the gay blood ban. This government was reminded that it's been 5 years since the Liberals promised not to study and research the issue anymore, but to end the discrimination and stigma that gay men face in this country. The Minister is aware of a safe, science-based solution that asks questions based on sexual behaviour and not sexual orientation. The Canadian Medical Association and the All Blood is Equal campaign are calling and backing this campaign. The time for talk and excuses is over. Gay men want to make a difference. We want to be treated the same way everybody else is. We can get this done. All I'm asking for, Mr. Speaker, is the Liberals to keep the promise that they made in the past 2 election campaigns. All parties are united in this. Let's make history and get this done. Not in months and years from now, but now. Let's make the change that's long overdue for gay men in this country. Thank you, Mr.
Speaker.
The Honourable Member for Brossard-Saint-Lambert.
First, let me wish you, all my fellow parliamentarians, and all those who work on the Hill as happy a Christmas as possible. But just as importantly, I would like to wish my fellow constituents in Brossard and St. Lambert a healthy, safe and loving holiday. The year is drawing to a close, and I think we can't wait to see it in the rearview mirror. What immense challenges and real threats to our security and well-being 2020 has presented to us. I hope during this holiday season we will have the opportunity to find solace in the warmth of our families and to take a moment to appreciate what we do have. This global pandemic has profoundly changed the way we live. No one has been immune from both the personal and social effects of the COVID-19 virus. But we have not been alone in the face of this new threat either. Many sacrifices have been made by everyone, and we have been able to adapt our behavior and our routines. We have all had to face these challenges, and we are slowly seeing the light at the end of the tunnel. Once again, I would like to wish you all a Christmas as merry as the circumstances will allow, and like you, I look forward to better days in 2021. Thank you, Mr. Speaker.
Questions orales, oral questions. The Honourable Leader of the Opposition.
Mr. Speaker, the Prime Minister tried to criticize us for asking questions on the CanSino deal. It turns out we weren't the only ones with questions, Mr. Speaker. The Globe and Mail is reporting that the government's own vaccine task force recommended against working with CanSino. The Prime Minister has said repeatedly that scientists were guiding the government's decision with respect to the vaccine. Why did this government make an exception for the Chinese pharmaceutical giant CanSino?
The Honourable Minister.
From the very beginning, Mr. Speaker, we stepped up for Canadians. We reached out to procure potential vaccines from every possible source. We were not going to close any door that would maybe help Canadians. We ended up, therefore, with 7 contracts signed with a diverse group of the top vaccine manufacturers in the world. We will continue to ensure we're doing everything we can, based on the best advice of experts, to get these vaccines to Canadians so we can get through this pandemic once and for all.
Chef d'opposition.
The Honourable Leader of the Opposition.
The first door the Prime Minister opened was with China. We also found out last week the government had been briefed on the security risks involving the Chinese company CanSino. The Prime Minister said that news report was making things up. Now we learn that the scientists agreed with the security experts on CanSino. So if the security experts were against partnering with China and the scientists were against partnering with China, why did the government partner with China?
The Right Honourable Prime Minister.
Mr. Speaker, we signed 7 contracts with different vaccine producers from around the world in order to deliver vaccines reliably to Canadians. And we looked for all partnerships, including something that was a successful partnership in developing an Ebola vaccine a number of years ago with CanSino. That one didn't pan out for a number of different reasons, but what we are left with is 7 extraordinary contracts that have secured more doses per capita for Canadians, potentially, than any other country in the world.
Honourable Leader of the Opposition.
Mr. Speaker, we lost 5 months on the China deal that the Prime Minister said didn't pan out. We didn't prioritize domestic vaccine production. The government didn't listen. Instead of pursuing a made-in-Canada solution that was actually put forward by their own experts, the Liberals signed off on a partnership with CanSino. They put millions into a facility for that partnership that they were told wasn't ready for vaccine production. Why did this Prime Minister favor a made-in-China solution instead of the made-in-Canada solution their own experts were demanding?
The Right Honourable Prime Minister.
Mr. Speaker, every step of the way we leaned on our experts, on the immunity task force, on the vaccination task force, to make recommendations on what we should do to ensure a solid supply of potential vaccines to Canadians. And that advice actually led us to being in the enviable position of having more doses from more companies than just about any other country. And we are hopeful to be receiving our first vaccinations next week. This is what a government that listens to experts and works hard for Canadians has been able to deliver.
The Honourable Leader of the Opposition. Mr. Speaker, last week the New York Times illustrated how easy it was to access child pornography on an adult site. And they continue their activity because the federal government isn't doing anything about it. This company has its head office in Montreal. When will the Liberal government open an investigation onto this issue to protect our young people? The Right Honourable Prime Minister. Mr. Speaker, we are working actively on the creation of new regulations to force online platforms to remove illegal content. That includes hate comments, child sexual exploitation, and violent or extremist content. Our approach will ensure that illegal content will be removed quickly, the platforms will be monitored, and victims will have access to a quick, transparent, and independent process. We are working with our international partners on this initiative and will be putting forth the regulations as soon as possible.
The Opposition.
En masse, des députés.
In March, Canadian senators and MPs from 4 political parties sent a letter to the Minister of Justice calling for steps to be taken to deal with these companies producing pornographic material. With respect to age, verification of age, and the removal of content,
When will the government take action to protect our young people from sexual exploitation? The Right Honourable Prime Minister. Mr. Speaker, as I said, we are working actively at present on measures for new regulations to force online platforms to withdraw all illegal content, be it sexual exploitation of children, child pornography, or hateful comments. We will always be there to protect Canadians, and we are working on measures to put in place. The Honourable Member for Belleuil-Chambly. Well, thank you, Mr. Speaker, and allow me to say quickly that the government has our support for all measures to put an end to sexual exploitation of young people. On a different topic now, we know that the government could have had vaccines made in Canada and could have had adequate facilities. We know that it could have done without. It could have synchronized its steps for approval. It could have taken a number of steps, but it didn't do so. To hide it under the carpet, the government is buying 250 million doses for Quebec. That means some 30,000 doses. We can't even look after seniors in, say, Sherbrooke, for example. When are we going to take more action that's more than just cosmetic? The Right Honourable Prime Minister. Mr. Speaker, since the beginning, we have been working with scientists and experts who've made recommendations on how to protect Canadians. On their advice, we signed more contracts with more companies developing a vaccine than any other country, and we have secured scores of doses of vaccine, more than any other country. Vaccines could arrive as early as next week. Production is underway, and we will be able to vaccinate many, many Canadians in the start of 2021. The Honourable Member. Regardless of what's already been done, it wasn't done well enough because there are delays. Now, with respect to the choices of the government, it's a false and dangerous sense of security. But only 125,000 people will be vaccinated, so that's inadequate. Can the Prime Minister talk about the plan and raise the issue on Thursday and come through with increased health transfers as the Premiers are requesting? The Right Honourable Prime Minister. Mr. Speaker, we are working to deliver vaccines as quickly as possible, and it, of course, depends on production by companies that will be providing these vaccines. With respect to the Premiers, I have worked with them for the months now to deliver billions of dollars in assistance for the health care systems, alongside the armed forces and the Red Cross. We will ensure that everything during the crisis, that the provinces have everything they need from the federal government. I'm keen to.
Member for Burnaby South.
Merci, Monsieur le Président. Thank you, Mr. Speaker. Canadians were encouraged to hear that a small quantity of vaccines would be coming from Pfizer, but that's the problem. It's difficult to transport it, to store it, and we're very concerned for our seniors. They need to have access to the vaccine. The Moderna vaccine can help. What is the plan for the Moderna vaccine to protect our seniors? The Right Honourable Prime Minister. Mr. Speaker, we have worked with all vaccine companies to ensure that we obtain doses quickly in compliance with all rules. There are 4 companies that are currently being assessed, including Pfizer and Moderna. We hope that the Pfizer vaccine will arrive shortly, and Moderna in the months to come. We know that it will take different types of vaccines to help everyone, and that's why we're confident that we will be in a position to vaccinate 3 million Canadians in early 2021. The Honourable Member for Burnaby South.
Thank you, Mr. Speaker. Canadians were encouraged by the announcement of a small quantity of Pfizer vaccines being available in Canada. But the Pfizer vaccine presents some problems. It's difficult to store and difficult to transport, and it won't be available for people who live outside of major Canadian cities. And I think about the outbreaks in Indigenous communities and rural and remote communities and the fact that they won't have access. The Moderna vaccine is promising in solving some of those problems, but we want to know what the plan is. So what is the plan for the Moderna vaccine to provide access to people who live outside of major cities?
Right Honourable Prime Minister.
Mr. Speaker, Pfizer is in the news right now because we are expecting to see the first deliveries of those vaccines as early as next week, and we can start working on the delivery of those vaccines, which are logistically more complex. Moderna vaccine is a somewhat more simple vaccine to transport and to administer. That is why we are counting on the Moderna vaccine to be able to reach further off communities and northern Canadians. That's why we are working very closely with Moderna to ensure that we get those doses to them as quickly as possible. As I said, we're expecting millions of people to be vaccinated, the most vulnerable.
The Honourable Member for Carleton.
Mr. Speaker, the Finance Minister has a big idea, and it involves your bank account. She's very worried that Canadians are saving too much, even though those same savings are lent out to and invested in other job-creating businesses. So now she's looking for ideas on how the government can act to unlock those savings of Canadians. Does the government really believe that holding Canadians upside down by the ankles and shaking their change loose is a stimulus plan?
The Honourable Minister of Finance.
The Conservatives are misconstruing my words. It almost makes me wonder if they're doing it on purpose. The fact is, there is nothing dystopian or even very complicated about the idea of a preloaded stimulus. We all know that local small businesses are the heart of our economy. We all also know that because of physical distancing, we are unable to patronize them now. That is why, as soon as it is safe for our economy to fully reopen, our government is looking for ways to encourage Canadians to support our local small business.
The Honourable Member for Carleton.
Preloaded stimulus. It sounds like she wants to use Canadian savings as her own preloaded credit card. But this is no surprise from a government that's running the biggest deficit in the G20 by far, even with the worst unemployment other than Italy and among the higher rates of COVID mortality. But now the minister says she has no fiscal anchor. Instead, she has fiscal guardrails that will one day be attached to a fiscal anchor. Won't the anchor at the bottom of the sea pull those guardrails off the edge of the cliff?
Honourable Minister of Finance.
Mr. Speaker, the member opposite still seems to have some trouble understanding why it's good economics to support our small businesses and to encourage Canadians to do that. So let me quote someone he might find a little more simpatico. Ontario's Conservative Premier Doug Ford. Here's what he's had to say. Now more than ever, we need to support our own. During COVID-19, business supported communities and healthcare workers. Now it's time for us to support them as consumers. I couldn't agree more.
The Honourable Member for Chicoutimi-Lafiore. Mr. Speaker, after days of being questioned by our party, the Liberals acted in haste to come up with some vaccines for Canadians. And it's only a tiny fraction of what's needed. Now, we know that the armed forces will be involved in the vaccination effort, including several from CFB Bagotville. How will the government distribute the vaccines to the members of the Canadian Armed Forces who fall under federal jurisdiction? The Honourable Minister.
Every step of the way, we've been transparent with Canadians as we secured the most doses per capita, as we had the most diverse portfolio for Canadians, as we planned with provinces and territories to distribute vaccines so they can deliver on their immunization responsibilities. And, Mr. Speaker, we'll work with the federal organizations under our jurisdiction as well to ensure that everyone has access to a vaccine.
The Honourable Member. Mr. Speaker, things are going so well in Canada that several provinces are reviewing lockdown procedures. We won't be able to talk about economic recovery until people have immunity. Canadians deserve certainty, clarity, and competency from their government. When will we develop herd immunity, and how long will we continue to be in lockdown? The Honourable Minister.
Important that all Canadians look forward to immunization and indeed plan to get immunized when those immunizations are proven to be safe here in Canada. I want to thank the regulators at Health Canada who are working so hard to ensure that no matter what vaccine arrives, that it will not be deployed until it's proven to be safe. And, Mr. Speaker, I think one of the things that will happen is ensuring that we don't share misinformation with Canadians about the risks of vaccination.
Honourable member for Lakeland. The honourable member just want to activate her microphone.
Thank you, Mr. Speaker. Yesterday, the Justice Minister said, quote, "We expect law enforcement to enforce Canada's laws. But a Canadian-based website has videos and images of people under 18 and children being exploited, abused, and raped. Videos are re-uploaded and stay on the website for years and years. The minister said the Liberals take gaps in the law seriously. So does the Minister for Public Safety think this is a so-called gap that needs to be fixed right now?
The Honourable Minister of Public Safety.
Mr. Speaker, let me assure the member opposite that the sexual exploitation of children is among the most heinous of crimes, and we've been working very hard to ensure that we support law enforcement in every way with resources, not just for the RCMP, but for provincial and municipal police services as well, to make sure that they have the resources and the tools and authorities they need to combat this most heinous crime. And I've reached out to the RCMP and asked them to speak to the police of jurisdiction, in this case in Quebec, in the city of Montreal, and in the province of Quebec, to ensure that they have all the help that we can provide.
The honourable member for Lakeland.
But this is still happening right now. Some private sector companies are taking steps to protect youth and victims of abuse. 3 major payment processors say they will or have cut off the website's ability to monetize child abuse. Victims say the website is, quote, "making money off the worst moment in my life," and, quote, "became my trafficker." Experts say there's more than 62 million pieces of child abuse online. How many more children will be harmed so heinously before these Liberals act and this is stopped?
The Honourable Minister.
As a father of 3 girls and a legislator, I find profoundly inhuman the content of these platforms. This is why our government has been working for months with experts, non-governmental organizations, and foreign governments to bring forward legislations to this House at the beginning of 2021. This new regulation will require online platforms, not just websites, to eliminate illegal content, including hate speech, child sexual exploitation, and violent or extremist content. Thank you, Mr. Speaker.
Député de Joliette.
The Honourable Member for Joliette. Thank you, Mr. Speaker. Well, the premiers will be meeting on Thursday to discuss health transfers. We're seeing the real consequences of federal underfunding in our hospitals. Now, Mr. Speaker, the leader of the official opposition is heckling again. He continues to heckle.
Chamber. We'll go back to the. Nous allons. Alors, la traduction, l'interprétation.
The interpretation isn't working?
Order. Order. We can't continue on. C'est pas possible pour continuer.
We can't continue on until the noise is reduced. The Honourable Member for Joliette. Well, thank you, Mr. Speaker. While all of the premiers are meeting on Thursday to discuss health transfers, we're seeing the real consequences of federal underfunding in our hospitals. Because Ottawa's not doing its share and its part, Quebec is forced to make heartbreaking choices. Doctors are forced to choose who can be treated because there isn't enough staff to treat everyone. And Quebec is forced to cut its operating room capacity to 50%. It could drop to 30% quickly. On Thursday, will the government finally announce a sustainable increase in health transfers? The Honourable Minister of Health.
Monsieur le Président,
Thank you, Mr. Speaker. We are supporting Canadians and the provinces. We have announced $19 billion under the Safe Start Recovery Program to help recover from COVID-19. The provinces must invest this funding to increase their capacity, their testing, contact tracing, and data collection. The Honourable Member for Joliette. Mr. Speaker, for every $10, only 15 that the federal government invests, only 15% goes to health. Now, every day we're seeing the COVID numbers, but what we don't see are people who don't have access to care, the number of people who can't have surgery or receive cancer treatment, the number of people on waiting lists whose quality of life is deteriorating because of a shortage of healthcare workers, and that's what happens when healthcare is underfunded. One-time assistance won't help them. When is the government going to realize what's happening and increase health transfers in a sustainable way? The Honourable Minister.
Speaker, throughout this pandemic, the federal government has been there for provinces and territories. In fact, 8 out of every $10 spent on responding to COVID-19 has been spent by the federal government. We've been there for provinces and territories, Mr. Speaker, with direct transfers for things like testing, contact tracing, data management, but also to help with crisis through the investment of the Canadian Red Cross to go into nursing homes and support right on the ground to help bring down outbreaks. Mr. Speaker, we'll be there for provinces and territories. They need to spend the money to get ready for whatever comes next.
Member for Calgary Nose Hill.
Experts have testified about the devastating impact COVID-19 lockdown has had on the mental health of Canadians. Alcohol and substance abuse is exploding, so is domestic violence, opioid deaths, and suicide. Some have described these impacts of COVID lockdown as epidemics in and of themselves. With Christmas fast approaching, a time when mental health is always an issue for many, and COVID lockdown still in place, does the government feel it's done enough to prevent a second wave of suicides, domestic violence, and overdoses over Christmas?
The Honourable Minister of Health.
Mr. Speaker, for a very long time, we've been focusing on mental health and substance use in this government. In fact, we did more as a government than that previous government ever did on the issue of substance use. And I'm proud of the work that we've done, Mr. Speaker, to treat people who use substances like human beings. Furthermore, Mr. Speaker, I'll tell you this. We have invested through COVID-19 by direct transfers to provinces and territories, by setting up Wellness Together, a federal support to overlay that transfer to provinces and territories. I would encourage all Canadians to visit wellnesstogether.ca to receive support and access to professionals to help them through this difficult time.
Honourable Member for Calgary Nose Hill.
Tens of thousands of Canadians have been separated from immediate family members for months due to COVID lockdown and border closures, and there are 4 million Canadians who live alone. For some of these people, sitting alone through Christmas lockdown might exacerbate mental health issues. For Canadians who live alone and who are desperate to reunite with family during the holidays for the sake of their mental health, what advice is the federal government offering them on how to safely reunite and mitigate the mental health impacts of isolation while preventing the spread of COVID-19?
Honourable Minister of Health.
Mr. Speaker, every step of the way, we've asked Canadians to sacrifice tremendously. We know that. All across the world, in fact, people are sacrificing to contain COVID-19 and protect their loved ones. And I don't underestimate that sacrifice, Mr. Speaker. And in fact, I thank Canadians for protecting each other, for protecting their communities. There is light at the end of the tunnel, though. We do have successful vaccines coming on board. And Mr. Speaker, I will remind all Canadians that if you need help and you don't have access in your own particular jurisdiction, please reach out to wellnesstogether.ca of both official languages and translation into 200 others.
Deputy Desnathy, Mississippi, Churchill River.
The Honourable Member.
Mr. Speaker, during the 2015 and 2019 elections and as recently as this summer, the Prime Minister repeated his now broken promise to lift all drinking water advisories by March 2021. The government has used COVID as cover, but that does not hold up under scrutiny. The member for Kenora has been in contact with several Indigenous community leaders in his riding who've been able to continue with infrastructure projects, including water, during the pandemic. Will the government admit that the clean drinking water promised to Indigenous people was empty from the beginning?
Here, here. The Honourable Minister.
Thank you, Mr. Speaker. We are not backing away from our commitment to ending all long-term drinking water advisories to First Nations on reserve, but instead making a more profound commitment to the long term. In every community with a long-term water advisory, there's a project team, an action plan, and people dedicated to lifting it. And last week we announced $1.5 billion to accelerate the access to clean water in the short and the long term, as well as the stability necessary to ensure this occurs not only by spring 2021, but after that. While we can't underestimate the impact of COVID-19 on long-term drinking water timelines, we're optimistic.
The Honourable Member.
Thank you, Mr. Speaker. Mr. Speaker, last week, instead of owning up to his own failure to Indigenous communities, the Prime Minister hid behind this minister and forced him to take responsibility for not meeting this March 2021 promise. When it was time for an election promise, the Prime Minister was more than glad to be in front of the camera and center stage and to be in the spotlight. Now that this promise has been broken, he is nowhere to be found on this. Mr. Speaker, that is not leadership. How can Indigenous people trust the words of this Prime Minister and his government?
The Honourable Member. The Honourable Minister.
Well, Mr. Speaker, let me complete what I was about to say. While we can't underestimate the impact of COVID-19 on long-term drinking water timelines, we're optimistic that by spring 2021, the number of communities under long-term drinking water advisories will be down to 12. We're committed to working with these communities in partnership for the long term. That's what the announcement last week of $1.5 billion to communities was about. And yes, that is my responsibility to get it done as a Minister of the Crown.
Member for Victoria.
Today's report from the Parliamentary Budget Officer shows that any scenario where the Trans Mountain pipeline would be profitable is a fantasy. Construction costs have soared to over $12 billion, and any additional climate action, like this government's own net zero legislation, will mean the project isn't viable. Yet the Prime Minister is determined to push ahead with this environmental and economic disaster. When will the Prime Minister stop selling this fantasy, throwing away billions of dollars, and instead make the investments we need to fight the climate crisis and create good, sustainable jobs?
The Honourable Minister.
Mr. Speaker, there are many factors that go into determining whether a pipeline is necessary, such as contractual support, shipper choice, the nature of the markets that would receive the products delivered by the pipeline. TMX is a good project that has created more than 7,000 jobs for Canadians. There is a very strong business case for the project, and construction will continue. Thank you, Mr.
The Honourable Member for Rosemont-la-Petite-Patrie. Not only is the Liberal pipeline wasting public funds, but their government is a laggard in terms of the climate crisis. In terms of the climate crisis, the Liberals are clearly failing. Canada is 55th out of 60 countries. It's embarrassing and irresponsible. In Quebec, a petition with 100,000 people signing it has just been tabled, and the Quebecers show that they want a lasting and green transition. When will the Liberals take the climate emergency seriously and invest in electric transportation and renewable energy? The Honourable Minister. The Honourable Minister. We've taken many measures nationally to address the climate emergency, and of course it's something we are aware of. We have to do more, and in coming weeks we are going to do more with a new plan to address climate change.
For Scarborough Agincourt.
As we continue to see record-breaking number of cases in regions across Canada, I know that families in my community of Scarborough Agincourt are concerned about the safety of their loved ones of all ages. Yesterday, the Prime Minister announced that 249,000 doses of Pfizer's COVID-19 vaccines will be available in Canada before the end of the year. With hope on the horizon, what would the Minister of Health say to reassure families, not just in my riding, but in communities across Canada?
The Honourable Minister of Health.
Well, thank you very much, Mr. Speaker, and I thank the member for her very important question. Of course, the arrival of vaccines in Canada is a very hopeful symbol that the light is indeed at the end of the tunnel. And I know that families all across the country are worried about their loved ones, and I thank them for the incredible efforts they're taking to keep each other safe. Work is well underway with provinces and territories to make sure that we have a quick and efficient way to deploy these vaccines. I want to thank the provinces and territories for working at all levels to make sure that when vaccines arrive in Canada, we can deploy them.
The Honourable Member for Charlebourg-Saint-Charles. Mr. Speaker, we all read or heard fairy tales in our childhood. The most recent one is called Frank Baylis and His Liberal Friends. The story is simple but shocking. But the problem is that the main characters deny being friends, even if their actions show the opposite. And my question is simple. Did the minister award other contracts to shell companies like FTI, a company that was only created a few days before signing a $237 million contract for friend Frank Baylis? The Honourable Minister of Public Services. Thank you very much, Mr. Speaker, for the question. To date, we received more than 3 million ventilators for Canadians. And this is very important for our effort for all Canadians, for people in hospitals. It's very important, Mr. Speaker.
Canadians, our government has stocked up on PPE and all sorts of medical equipment. Businesses from across this country have stepped up, and we are so grateful to those businesses and Canadians at large.
The honourable member for Charlesbourg-Saint-Charles. Mr. Speaker, Baylis's ventilators weren't even approved by Health Canada when the government awarded the contract. And what's more, Baylis needed money and had to finance its buildings because it had issues. Did the government pay twice the price for these ventilators because Frank Baylis had financial issues? And is this why they hid the extra in the overall price? The Honourable Minister of Public Services. That's an interesting story, Mr. Speaker, but that is not at all the case. After an in-depth examination by a group of independent experts, Mr. Speaker, we awarded a contract to FTI. It is for Canadians and hospitals, Mr. Speaker, that we did this, and we are here for Canadians. Thank you.
For Wellington, Halton Hills.
Mr. Speaker, I'd like to give the government the opportunity to clarify its policy on China. I have a very simple question and hope that it will be answered. Has the government already put in place its new framework on China? Yes or no?
The Honourable Minister of Foreign Affairs.
Mr. Speaker, I'd like to thank my honourable colleague for giving me the opportunity to talk about our policy with China. Mr. Speaker, Canadians who are watching at home understand that our relationship with China is both complex and multidimensional, Mr. Speaker. Canadians at home understand that China of 2020 is not the China of 2016, and that our strategy needs to evolve with the China which is evolving, Mr. Speaker. As I've said many times in committees, the member asked me many questions. Our policy is based on our interests, on our values and principles, including human rights, and on building global partnership and abiding by international rules, Mr. Speaker.
Member for Wellington, Halton Hills.
Mr. Speaker, that answer demonstrates why this government's policies are such a mess. They can't answer a simple question. 2 weeks ago, the minister appeared in front of committee and gave contradictory messages. The Canadian press reported that the government had already put in place its new framework on China. The National Post at the same time reported that the government had yet to put in place this new framework. If we can't figure it out and the media can't figure it out, how on earth is anyone else, including China, supposed to figure out this government's policy on China?
Honourable Minister of Foreign Affairs.
Mr. Speaker, I think it's very clear. Canadians have figured out, Mr. Speaker. Maybe the opposition have not. But I can assure that Canadians understand that China of 2020 is not China of 2016, Mr. Speaker. And after 2 hours and a half of questioning, if they don't answer yet, I think they have a problem, Mr. Speaker, because Canadians understand.
The Honourable Member for Montcalm. Mr. Speaker, the court ordered the government to correct MAID legislation before December 18th, but the bill is paralyzed. The Liberal prorogued Parliament for 6 weeks, so they are to blame if time runs out. Nevertheless, the hostage-taking of this work by the religious right is deplorable. There are vulnerable people waiting who are suffering. Will the government ensure that C7 passes in time without a gag order? Or does it think that the government, that the conservative leader needs to call his fanatics back to order? The Honourable Minister. Mr. Speaker, we were very disappointed to see the Conservatives pursue their tactics to obstruct the legislation on MAID. We know, Mr. Speaker, that the large majority of Canadians believe that medical assistance in dying is a fundamental human right. The deadline was imposed by the Superior Court of Quebec, and the Conservatives are trying to deny the urgency of the situation. It's a serious situation, and the leader of the official opposition has to show his leadership in this respect. The Honourable Member for Laurentides-Labelle. Mr. Speaker, the hostage taking of work by the Conservatives' religious right on MAID should serve us as a lesson. It shows why religion must be kept as far away from government affairs whenever possible. State secularism is fundamental, and this value must be protected. But yet, right now, the federal government is involved in a court challenge to fight state secularism in Quebec. Will it learn a lesson from what's happening today and stop taking Quebec taxpayers' money to do what? Challenge the secularity of Quebec. The Honourable Minister of Justice, Mr. Speaker, we have a very clear position on this. What I can tell you is that we're not participating in the court challenging Quebec in that trial. That is a case where Quebecers are challenging this legislation before the courts. That's their right, and we're following this case closely.
For Central Okanagan, Similkameen Nicola.
Mr. Speaker, during this pandemic, Canadians are ordering more and more through home delivery. But what they aren't able to order are all the fantastic beer, wine, and spirits made by our great Canadian producers. Liquor monopolies hide behind outdated rules to prevent people from buying what they want, and this government has done nothing to fix it. Today I tabled a bill to give people more choice and to free Canadian beer, wine, and spirits. At this critical time, Mr. Speaker, will the government support this bill to help Canadian businesses and their workers?
Let it flow! The Honourable Minister. The Honourable Minister.
Mr. Speaker, I'd like to thank the honourable colleague for his question. He knows full well our government is committed to reducing barriers between provinces and territories. That is why we negotiated the Canadian Free Trade Agreement, and we look forward to working with the members opposite to make sure we reduce red tape to create more opportunities for businesses and, more importantly, more choices for Canadians. Thank you very much.
The Honourable Member for Steveston, Richmond East.
Well, thank you, Mr. Speaker. Pandemic job losses and economic downturns have significantly impacted young Canadians. The Fall Economic Statement mentions phraseology like funding for new career opportunities and introducing additional measures. Well, here's the problem, Mr. Speaker. There's no details, no timelines, no assurances for our young people to know when and if they can get back to work. Will the minister end the platitudes and deliver details on job measures for young Canadians?
The Honourable Minister. The Honourable Minister.
Thank you, Mr. Speaker. I'd like to appreciate the question, and that's why our government has been responding to the needs of youth. We know that COVID-19 has impacted all Canadians, and disproportionately certain segments, and young people are no exception. When it comes to the Canada Summer Jobs, jobs remain open, and I encourage young people to apply. When it comes to making sure that we had a moratorium on Canada student loans, we were right there to make sure interest was not accumulating. When it came to young professional entrepreneurs, we increased funding to Futurepreneur so that young people can continue being part of the solution. Mr. Speaker, our government will continue working on behalf of all Canadians, including students and youth, and I thank the member for his concern.
The Honourable Member for Barrie, Springwater, Oro-Medonte.
Mr. Speaker, last week I had the pleasure of visiting Curio Exploration Hub, an innovative new child activity centre opened by the mother of 2 young children, Stephanie Stout. Ms. Stout is hardworking, entrepreneurial woman who, unfortunately, through no fault of her own, found herself opening her business during the pandemic. Ms. Stout is struggling to survive and keep her business open. As a new business, she does not qualify for any of the current government assistance programs. Ms. Stout has put her heart, soul, and savings into this business. Why won't the government fix these flawed programs and help Ms. Stout?
The Honourable Minister of Finance.
Mr. Speaker, first of all, let me remind Canadians that our government has put in place an extensive safety net for Canadian businesses. I would argue no country in the world has put in place as extensive a safety net to support its businesses. The wage subsidy, the rent subsidy, CEBA. Now, Mr. Speaker, In putting together our programs, we need to balance integrity measures against the pressing need to support Canadian businesses. We are always looking at ways to improve the programs and are looking at particular cases that fall through the cracks.
The honourable member for Glengarry Prescott Russell. Mr. Speaker, last week, the Government of Canada made an announcement about an emergency loan for entrepreneurs through CEBA. Our government has already served several agricultural and other businesses in my riding of Glengarry Prescott Russell through the $40,000 loan with the possibility of writing off $10,000. Could the minister inform this House of other similar measures? The Honourable Minister of Small Businesses. Mr. Speaker, I'd like to thank the member for his question. We announced that businesses can obtain a second emergency account loan of $20,000. We continue to support our SMEs in dealing with the pandemic by extending the wage subsidy and supporting them with our new rent assistance paid directly to tenants. We will continue to support businesses in Glengarry Prescott Russell.
Member for Sturgeon River Parkland.
Mr. Speaker, Canadians are growing ever more concerned about the ability of the government to distribute vaccines in a timely manner. Disturbing news has emerged that hackers are working to disrupt vaccine supply chains. The Cybersecurity and Infrastructure Security Agency in the United States is sounding the alarm. The consequences of inaction will be fatal to Canadians. What is the government doing to protect our vaccine supply from cybersecurity threats?
Good question.
The Honourable Minister of Health.
Mr. Speaker, we're so fortunate to have embedded in the Public Health Agency of Canada Major General Fortin and 30 of his colleagues that have been working for months on our vaccine planning, including protecting the entire chain of vaccine delivery, including looking at the potential threats that exist to the vaccine security for Canadians. Mr. Speaker, we will stop at nothing to ensure that vaccines are safe and protected for use in Canada.
Honourable Member for Abbotsford.
The Prime Minister has until the end of next week to comply with the will of this House to block Huawei from using our 5G networks to spy on Canadians and undermine our national security. All of our Five Eyes partners, the US, UK, New Zealand, Australia, they've all agreed to restrict or ban Huawei. And yet here in Canada, the Prime Minister dithers, no backbone. When will the Prime Minister grow a spine and say no to Huawei?
The Honourable Minister.
Mr. Speaker, I'd like to remind the honourable colleague that we are right now under the process of doing a comprehensive review of how to deploy 5G in a safe and secure manner. We've been abundantly clear that we will continue to work with our national security experts as well as our allies to make sure that we proceed in a manner that protects Canadians, their safety and well-being. And we've been absolutely clear that we never have and never will compromise on the safety of Canadians.
The Honourable Member for Chatham-Kent Leamington.
Mr. Speaker, a critical part of our economy involves businesses that make the machinery of business. We are world-class players in this field in southwestern Ontario, but face-to-face meetings are critical for Unifab, a Leamington employer that wants to expand, wants to double their size and add 150 good-paying jobs, but they need access to Michigan. His truckers can cross the border daily, but he, as owner, can't without spending 14 days away from his business. No one is suggesting we compromise safety, but when will rapid testing be accessible at all of Canada's borders?
The Honourable Minister of Health.
Mr. Speaker, it was an opportunity to partner with the province of Alberta to pilot a study to understand the best way to test people at the border and combine that with quarantine. Because listen, at the end of the day, all Canadians expect us to ensure health safety at our borders, and that's exactly what we're doing, Mr. Speaker. We're looking at the evidence, we're looking at the research. We'll have more to say when the research study concludes.
The Honourable Member for York Centre.
Mr. Speaker, during the pandemic, we've seen a rise in the number of hate-filled incidents where people have been harassed simply because of their race or religion. This is completely unacceptable and needs to stop. While some people view these incidents in isolation, we know that they have a broader impact on our wider community. I'm proud as the newly elected parliamentarian to represent the very diverse riding of York Centre. It's home to synagogues, mosques, and black churches, all of which are too often targets of anti-Semitic, Islamophobic, or anti-black hate-motivated crimes. I will always fight to ensure that all of my constituents can live, worship, and pray openly, peacefully, and without fear for their safety. Can the Minister of Public Safety and Emergency Preparedness please update this House on what the government is doing to provide support for the security of all of our communities?
Honourable Minister of Public Safety.
Thank you very much, Mr. Speaker. I'd like to thank the member for York Centre for her excellent question and for her strong advocacy on behalf of her constituents and in the fight against hate. Mr. Speaker, all Canadians, regardless of their race, ethnicity, or religion, should feel safe where they live, work, gather, and pray. And since forming government, we have quadrupled the funding under the Security Infrastructure Program to keep at-risk communities safe. And Mr. Speaker, just last week, as we announced in the Fall Economic Statement, we're investing an additional $13 million to protect communities at risk from hate-motivated crimes by providing not-for-profit organizations such as places as worship, schools, and community centers with funding. Our government will always support Canadians, ensuring that they can feel safe in their local communities, schools, and places of worship.
The honourable member for Courtenay Alberni.
Mr. Speaker, when the pandemic hit and frontline workers and hospitals were short on PPE and sanitizer, Canadian small business owners stepped up. Distillers and brewers started making hand sanitizer. They saved lives, and many did it all for free. But when it came time for the government to order sanitizer, instead of giving these Canadian small businesses a chance to fill some orders, the Liberals sent over $500 million to multinational corporations. Can the minister responsible explain what Canadian small businesses need to do to get the support they deserve from this government?
The Honourable Minister.
Mr. Speaker, we've been very clear that we want to support Made in Canada solutions. That is why we had a call of action to businesses across the country, and many small businesses stepped up. And presently, approximately 50% of our procurement comes from Made in Canada solutions, from local businesses. That's up from virtually 0% in March. We're very proud of supporting Canadian businesses right across this country, and we'll continue to work with them and promote our Made in Canada programs going forward.
The honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker. It's very tempting to ask about the Parliamentary Budget Office report from this morning that made it clear that the TMX pipeline only makes money if all climate actions fail. But we have another hot topic, and that's the government's attempts to evade the Basel Convention on the shipment of plastics and other non-hazardous waste. There are very clear rules coming into effect January 1st for Basel, but Canada is evading them by contracting with the United States, a party not a member of the Basel Convention. What will the Minister of Environment do to plug this loophole?
The Honourable Minister of the Environment and Climate Change.
Thank you, Mr. Speaker, and thank you to the honourable member for the question. Canada takes its international obligations on the management of weight very seriously. Canada took a leadership role in negotiating the amendments to the Basel Convention, and we tabled these amendments this fall. The United States is not presently a party to the Basel Convention on the transboundary movement of waste. The agreement that we are putting into place with the United States will ensure that waste that moves between our countries is handled in a manner that is consistent with the Basel Convention. Mr. Speaker, through this agreement, we can ensure that waste that moves between our two countries will be managed in an environmentally sound way.
This will conclude the question period for today. I have a notice of a point of order. The Honourable Parliamentary Secretary to the Prime Minister.
Thank you very much, Mr. Speaker. Look, 2 or 3 months ago, when a Conservative Member of Parliament on Twitter tweeted about far-right anti-Semitic conspiracy theories about the relationship between George Soros and our Deputy Prime Minister, she apologized and deleted the tweet. So you can understand why I was surprised when I heard a Member of Parliament here in the chamber today repeated and peddled the same conspiracy theory again. So I want to give my honourable colleague the chance to withdraw his comments and apologize for what he said here today.
thank the Honourable Parliamentary Secretary for his intervention. I don't know that I see any other member rising. We'll take his point of order.
Mr. Speaker, if he doesn't...
I'll take his point of order under advisement, and we'll get back to the House if necessary.
Mr. Speaker,
The honourable member.
Thank you very much. If he's not willing to say it himself, I can point him out. This is the honourable member from Barrie Innisfil, so maybe he wants to explain what he said here in the chamber.
I see the honourable member for Barrie Innisfil rising. If he wishes to add to this point of order, the honourable member.
Mr. Speaker, I would encourage you to listen to the tapes. There was nothing in what I said that was in any way anti-Semitic, and I'm not going to sit here and take what they are doing in this situation lightly. I encourage you, Mr. Speaker, to listen to what was said, and there was nothing in there that was in any way anti-Semitic, and I'm not going to sit here and take what they have to say. Thank you.
I thank both honourable members for their interventions. I think we are treading into an area of debate and the interpretation of such. So I think we'll need to leave it at that for the time being. I have a notice of another point of order. The member for Courtenay Alberni.
Mr. Speaker, in the spirit of the holiday season, I think if you seek it, I believe you will find unanimous consent for the following motion: that the House recognize that small business owners have canceled or postponed staff holiday parties and celebrations in an effort to stop the spread of COVID-19 and have chosen to purchase gift cards for their staff in lieu of physical gifts in an effort to buy local this holiday season. And given that in-person holiday parties and dinners up to $150 are currently tax exempt, while gift cards qualify as taxable income for their employees, the House call on the government to exclude gift card purchases up to $150 from employment income for the 2020 holiday season, so that small businesses, nonprofits, and local governments can honor and thank their staff for their hard work, especially during these difficult times.
As members will be familiar, and this being a hybrid sitting of the House, I will only seek to hear if any are opposed to the honourable member for Courtenay Alberni proposing this motion. So I therefore ask all those who are opposed to the honourable member moving this motion, please say nay. So there is no unanimous consent. Je vois aussi l'honorable député.
The honourable member from Mégantic-l'Érable has raised his hand on Zoom. The honourable member of Mégantic-l'Érable, therefore. A point of order, Mr. Speaker. Mr. Speaker, during question period, there was questions in English and in French. I asked the unanimous consent to table the following document, asking the language checks for presentations at the Treasury Board to help the President of the Treasury Board, asking language analyses when contracts are granted, such as that for We Charity. Once again, this is a hybrid session. So, for clarity, I would ask only those who are against this motion to say nay. Therefore, all those who are against this motion proposed by the honourable member from Mégantic-l'Érable, please say nay.
No.
There is therefore no unanimous consent with regards to this proposal.
That is all that we have for points of order arising from a question period. So we'll go to orders of the day. Ordre du jour.
Ordre du jour, en permanence du gouvernement, reprise du débat.
Resuming debate, third reading, C7, an act to amend the criminal code and medical assistance in dying.
When the House last took up debate on this question, the honourable member for Cypress Hills Grasslands had 2.5 minutes remaining in his time for debate, and we'll now go to him, resuming debate. The honourable member for Cypress Hills Grassland.
Thank you very much, Mr. Speaker. So yeah, I'll try to pick up where I left off. I believe I was talking about compassion and how that is shown to Canadians, and in particular, as it pertains to how we look after our senior and aging population, particularly in Saskatchewan. this is becoming an increasing problem. In 2015, Stats Can did a survey. What they found out was that, you know, as we're going forward, it's going to, I think it's in 8-year increments, it's going to, our population is going to age at about 4 or 5% over and over in that time frame. So our population is continuing to age. We look at our palliative care strategy, we look at the infrastructure that exists. We're at a deficit here as we're going forward, and we're spending all of this time in Parliament going over C7. The government has decided to make that their priority, figuring out how they can reduce criteria so people can get further access to medical assistance in dying, which is basically why there are advocacy groups out there saying this legislation more or less amounts to assisted suicide. And that is a message that we particularly do not want to be portraying to Canadians, particularly as we look at many areas of the country that are under a suicide pandemic of their own in its own right. So we need to be sure that we are sending the message clear and concise to Canadians, that we are focused on providing life-affirming care, that we are providing life-affirming support, and that we do not want to just give Canadians the impression that we've just kind of given up and just said, you know what, instead of providing life, we're going to provide you the option for death. I find that a very dark path to be going down from this government. So, again, I think we just need to make sure that we're sending the right message to Canadians. Again, that we cherish all life and that our focus will solely be on the life and well-being of Canadians. Thank you very much, Mr. Speaker.
Questions and comments. The Honourable Parliamentary Secretary to the Government House Leader.
Thank you, Mr. Speaker. And I would take the opportunity just to emphasize the importance of the issue of palliative care, long-term care, and ensuring that by making the statement every so often as I do in terms of that all life is of equal value. It's something in which I genuinely and truly believe in. But the legislation that we have before us today is a reflection of many hours of discussions and debates, tens of thousands of Canadians providing input, the Superior Court of the province of Quebec that has made a decision. It's reflective of other decisions that were made previously, and it seems to have the support of the Bloc Party, the Green Party, the NDP, and obviously the Liberal Party. And I'm wondering if my friend could just provide his thoughts in terms of just the amount of dialogue that has taken place and the amount of support, at least from political entities in the House. If he could provide his thoughts in terms of why he believes that's the case, that we should be moving forward with regards to this bill.
Honourable Member for Cypress Hills Grasslands.
Well, I thank the member opposite for his question and for his point on support for the bill. There is a lot of support for maintaining some kind of a framework around C7. In particular, we want to see the framework for ensuring that there's protections in there saved, and some of those protections have been removed. So he also was talking about how there's tens of thousands of people that were consulted on this, but there's one group in particular that receives zero consultation. That is disabled peoples in Canada. So one of the primary objections that myself and numerous other people have is what it has to do for people with disabilities and what it's signaling to them.
Questions and comments? Questions et commentaires. We'll go by video conference. The Honourable Member for Sherwood Park, Fort Saskatchewan.
Thank you, Mr. Speaker. I thank my colleague for his excellent speech. There's been a lot of discussion, certainly coming from our side of the House, about the need to do better when it comes to people with disabilities and how many people living with disabilities have reported being pushed towards euthanasia and even being called selfish when they choose not to pursue that option. And that's why we put forward a reasonable amendment to say that euthanasia should be a conversation initiated by the patient, not pushed forward by somebody else. And one of the other points about the discussion on disabilities is that I think, we hear people talking about new benefits, new spending from government, but I think what we need to recognize as well is that people with disabilities have a significant contribution to offer in terms of employment. And that's why the member for Carleton put forward a great bill in the last Parliament that would have removed barriers to employment for people people living with disabilities. So I wonder if the member could talk about more how we can just promote full inclusion across the board for people living with disabilities.
Member for Cypress Hills Grasslands.
Yeah, so the member for Sherwood Park, Fort Saskatchewan makes a great point about, well, why we need to affirm life in every individual. We need to stand up and defend the dignity of life for everybody. And he hit on a great point about people with disabilities being able to contribute in the workforce. There's such an important part of the fabric of our communities. I know particularly in Swift Current where I am, the Swift Current Abilities group, they have such a fantastic group of people there, and they do such great work in our community, and it's such an uplifting presence that they have in our community, and they do such great work. And so what this bill signals to them is now that their contributions to our society aren't as meaningful, and we need to make sure that we're sending the right message across.
We have time for a short question and response. The honourable member for Regina Leuven.
Thank you very much, Mr. Speaker, and thank you, my honourable colleague from Cypress Hills, for his great speech. And we heard some questions in question period today that were really attacking some people that took some issue with this bill. And I think it was on partisan political attack that really has no place for a conversation around some of the most important decisions around life and death. So I'd like my honourable colleague to expand on some of the reasons why the Conservatives put forward their reasonable amendments. It has nothing to do with politics. It has to do with some fundamental beliefs that us and the people we're representing on this side have, including the people in the disability communities and people throughout different sectors that are having trouble with this Bill C-7. And it has nothing to do with politics, but it has some fundamental beliefs people hold very dear, and there shouldn't be any room in this discussion for partisan politics.
Member for Cypress Hills, Grasslands.
Yeah, I think the member for his question, I mean, he's absolutely right. I mean, the assertion that was made in QP that there are regular, everyday Canadians that are considered fanatics for their opposition to this bill is absolutely ridiculous. So, I think we've got to stay focused on what we are doing for Canadians. We got to focus solely on doing what's best for Canadians, and people are adamant that we need to stand up and defend dignity in life.
Resuming debate, the honourable member for Saskatoon West.
Thank you, Mr. Speaker. I just wanted to let you know that I'll be splitting my time with the member for Yorkton Melville today. Dr. Heidi Jantz, who's the committee chair of the Council of Canadians with Disabilities, expressed her alarm at the breakneck speed at which the Finance Committee was operating, called on members of the committee to extend public consultations on the legislation. I agree with her. I believe that we are moving way too quickly on this issue. And it reminds me of something that one of my constituents told me back in February, and that is that we need to slow this down. We also have to remember the reason that we are here. It's because of the WE scandal and the prorogation that the government chose to do. That took away a month plus time that we could be debating this issue here in this House, and so that has caused this to all of a sudden become a panic and this supposed rush to get this done. I thought it was important that maybe I repeat a few things. Sometimes Canadians, as they're watching these debates, may get a little confused as we talk about different things. And I just wanted to summarize a couple of quick things. Number one, we're here because of the Truchon case from the Quebec Superior Court. This case was said that the section of the current law that says death must be reasonably foreseeable, it struck it down, and it said it needed to be changed. And so that was the initial start of this particular bill. Our government chose to not appeal that, which is quite unusual, because normally when a lower court makes a ruling against a government bill, especially one that is significant, the government of the day typically appeals, in this case to the Quebec Court of Appeal and ultimately to the Supreme Court. But our government, for whatever reason, has decided not to appeal it, which is quite unusual. And because of that, this bill will now be open to those who are chronically ill and chronically disabled. It's interesting to note that they specifically excluded mental illness, as opposed to excluding, say, someone who's a paraplegic. To me, this is arbitrary. It's picking winners and losers in a sense, and it's certainly going to make this legislation open, if it passes, open to a charter challenge. I also want to mention safeguards that have been removed in this legislation. The 10-day reflection period, and as one of my colleagues mentioned this morning, since the MAID legislation has been in place, there have been 263 Canadians who initially chose to pursue MAID, and then within the 10-day reflection period, changed their minds and did not pursue MAID. 263 Canadian lives that were saved because of the 10-day reflection period. That reflection period is gone, and any future Canadians who might make that choice will not be saved if this goes through. Another thing that's been removed on the safeguard side is final consent. You can now give advance consent for this procedure. And
This is a problem to me because you don't really know in the end if the person, when the time comes, really wants to go through with this procedure because it's not required anymore. The other thing is in the current legislation, you must have 2 witnesses agree that this makes sense for the individual. That is now down to 1, so there's no more need for witnesses to agree, just one person has to say. I also want to mention the 90-day waiting period. This is a new safeguard that's been added for those for whom death is not reasonably foreseeable. And I just want to mention why I think 90 days is not long enough. For example, if you have a spinal cord injury, your spinal cord injury may not even begin to recover within 90 days. In Ontario, if you need access to specialized long-term care, it takes on average 126 days to get that care. If you need specialized pain clinics, the median time to get that is 5.5 months. And even if it's something as simple as applying for a CPP disability benefit, that takes 120 days. All of those times are far more than 90 days. And in my opinion, 90 days is far too short for a waiting period. Now, there is a group of people who have been very vocal since this has come out, and that is the disabled community. And Mr. Speaker, I want to mention a few quotes. Inclusion Canada said, by providing MAID beyond end-of-life circumstances to Canadians with disabilities, Canada would signal that these Canadians are expendable and threaten their lives, dignity, and belonging. Canadian Physicians for Life said, this bill prejudices marginalized patients to the incidental effects of a regime that endorses death as an appropriate response to non-life-threatening illness and disability. Furthermore, this bill not only creates an unavoidable risk that some individuals could actually be euthanized against their true wishes, it increases that risk by removing key safeguards that ensure such requests are valid in the first place. The Christie Legal Fellowship says the risks created by this bill, risks that will have a devastating impact on marginalized Canadians, are grossly disproportionate to the benefits it attempts to confer on those seeking more expedient access to MAID. The Catholic Bishops of Canada remain steadfastly opposed to Bill C7. And just to show that I'm not completely one-sided in this, I wanted to read from the Canadian Unitarian Council, who are in favor of MAID, and they said this, of necessity during this time of pandemic, our healthcare systems are burdened and stretched. We urge the government to find ways to provide resources to make sure that those who want access to medical assistance in dying are able to do so, especially those living in remote and under-resourced communities, which sounds an awful lot like this is a solution to an overburdened medical system. 50-plus religious leaders in Canada penned an article, and I wanted to read a brief portion of that. They say, with our world-renowned healthcare system now endorsing euthanasia as a solution to human suffering, we will be undermining the creativity and resolve that is needed to confront some of the most complex cases of care. We are, in effect, imposing the intentional taking of human life as a solution to human suffering. How precipitous a fall have we made into a moral abyss? This is not what we as Canadians have in mind when thinking of ourselves as a caring, compassionate, and inclusive society. Instead, we must embrace those who suffer and offer exceptional care to those who are confronting illness and death. And I also received a lot of correspondence from people in my riding, Mr. Speaker, and I wanted to read some of those. Cecile Goodmanson wrote, Bill C7 is a horrible law, and I'm asking you to oppose it. It is basically a suicide pact. Under Bill C7, we as a society are saying that it is okay to kill sick, disabled, lonely, and mentally ill people. If those people feel like life is not worth living, we should go along with that lie and dispense with them post-haste. This is ridiculous. I thought we were not supposed to discriminate against the disabled, the elderly, and those who are sick or mentally ill. Becky Thomas, she wrote, the new Liberal government Bill C7 to expand assisted suicide and euthanasia is truly horrifying. It would allow people who are not even dying to be able to demand that a doctor help kill them. Anyone will be able to demand the state and taxpayer participation in their execution, provided they claim they have intolerable psychological suffering or physical suffering, terms which are very broad and open to every interpretation one could imagine. Please speak out against this push. Pat and Donna Rogel wrote this to the Justice Minister, and I'm not sure that he read it, so I'll read it so that he can hear it. As someone opposed to physician-assisted suicide, we did complete the questionnaire. However, found the online survey very difficult to complete because it was formed on a basis of presupposed agreement with euthanasia and assisted suicide, and did not give those of us opposed a proper voice. I heard over the course of a couple of weeks of many who in conscience felt they could not participate in such a survey for that very reason. This survey was flawed in so many ways. Time allotted, the assumption everyone had access to computers, to mention just a few. David Dombowski wrote, I'm very concerned that the Liberal government is not doing the promised 5-year review of their liberal euthanasia law, but instead liberalizing it well beyond the court ruling that prompted the government's response. This government has not charged anyone or even decided to investigate any of the several publicized cases of abuse under the existing euthanasia law, and now they propose to remove many of those existing safeguards. And Cheryl wrote, the Government of Canada prides itself on championing inclusion and accessibility. With its current position on the reintroduction of MAID, the government reminds us that they have a glaring blind spot when it comes to their vision of a more inclusive Canada. This is not simply an unfortunate omission, it is a betrayal of the foundational principles of inclusion, one that puts the lives of people with disability at risk. Madam Speaker, as I end, I just want to mention a few men who have gone before me. My Uncle George, who was born around 1940, and he had Down syndrome. He was my father's oldest brother, or next oldest brother, and my father would say that my father didn't even know that his brother had Down syndrome until my father was 8 or 9 years old. My Uncle George died naturally at age 53. My Uncle Ken, he suffered a horrific farm accident when he was 4 years old, and he became a paraplegic. His life was very difficult in those days, especially for his parents dealing with a newly paraplegic son. But he persevered, and he had a successful career with the provincial government, and he became a very senior bureaucrat. I looked up to him, and he was by far my favorite uncle. And he died of cancer in his 50s. I am who I am today, in part because of these two men. I stand on the shoulders of these two men. Without words, they taught me tolerance, acceptance, and love. And I'm here today in part because of those two men. Let's not create a Canada where men like Uncle George and Uncle Ken are erased from existence. Let's slow this down.
Questions and comments. Questions et commentaires. The Honourable Parliamentary Secretary.
Yes, thank you, Madam Speaker. And I think it's important that we recognize, because there is a clock that does tick on this particular piece of legislation. The Bloc Party raised it up in question period today. Other people from other political parties have raised the issue in terms of seeing it passed. And the Conservatives should not try to give a false impression that it is about the process that would cause the delay in passing. For the Conservative Party to be completely transparent on this issue is to say that the Conservative Party does not support the legislation because fundamentally they believe that the decision should have been appealed to the Supreme Court of Canada. And that is the reason, the core of the reason why they don't support the legislation. And I'm wondering if my colleague from across the way would acknowledge that, in fact, to be the case.
The Honourable Member for Saskatoon West.
Thank you, Madam Speaker. I guess I would say that perhaps the Parliamentary Secretary needs a little bit of information he doesn't currently have. And the government seems extremely stuck and confused as to what to do here. There's many options available to them. Number one, they can ask the Quebec Superior Court for an extension, as they've already done. That's a tool they've already used. I'm sure they could do it again. Secondly, they could appeal. It's something that's commonly done, and it is necessary in a case where the law that's being changed has such profound impact on the country. And so there's many tools the government could use if they chose to, and they're just choosing not to.
Honourable Member for Abbotsford.
Well, thank you. I want to commend my colleague on his speech and for referencing the human side of this. He mentioned his two uncles, both of whom had serious disabilities and yet lived productive, satisfying lives. And he mentioned that those uncles taught him tolerance, which is sometimes in short supply here in this House, as we heard today during question period, where those who oppose the expansion of medically assisted suicide, they referred to those people as being religious fanatics. I'd be interested to hear this member's views on whether that is the appropriate way for MPs to characterize those of us who have serious, substantive reservations about this legislation.
The Honourable Member for Saskatoon West.
Well, absolutely inappropriate would be my short answer to that question, Madam Speaker. There's 338 of us in this House. We certainly all do not agree on everything. We come from different walks of life, different faith backgrounds. Some have no faith, some are different. We all have different beliefs, different lived experiences, different families. We are different in every way. And that's what the strength of this House is. We come together with all of those differences and we make good laws by bringing our unique experiences to this House. And so I believe it's very important for someone like me, someone like you, and everybody else that's in this House to bring their lived experiences here, share that with everybody, and together come together and make good laws.
Questions and comments? Questions et commentaires? The honourable member for Stevenson Richmond East.
Thank you, Madam Speaker. From the member of North Winnipeg, it sounded like there has been a repeating tactic of using a conspiracy theory. And I have heard also conspiracy theory about the Liberal Party of Canada on the MAID strategy. It sounds like the conspiracy theory said that they wanted to withdraw the palliative care so that they could actually save more money and by pushing for more MAID. I don't believe the Liberal Party of Canada would actually be sinking so low, but I would like to ask my my colleague to comment on that, please. Thank you.
Member for Saskatoon West.
Well, conspiracy theories are always an interesting and strange place to go, but he raised something that I wanted to mention, and that is palliative care. My mother-in-law experienced an end-of-life situation in palliative care, and it was a very important to our family to have that ability. Unfortunately, 70% of Canadians do not have access to palliative care, and that is in part driving the demand for MAID. And so I believe it's important that we as a country and as our government comes up with a strategy and a plan to develop proper and improved palliative care in this country, and I think that would go a long way to helping seniors and helping those in end-of-life situations. Thank you.
Resuming debate, the honourable member for Yorkton Melville.
Thank you, Madam Speaker. I consider it an honour to be able to speak for a third time on C7, as this is a bill which would dramatically expand access to assisted death in our country. And so I rise again to represent the thousands of voices across this country who feel that this bill puts them in crosshairs. I'm referring to vulnerable Canadians living with disabilities and disabling conditions who believe that they've been targeted. They've told us that this legislation singles them out by providing them with a special path to assisted death. They want us in this place to know that their lives matter. This is the last opportunity for now for members of this House to legislate in regards to C7 to ensure that their best interests are considered. I want to use my time today to reiterate what has been a common theme throughout my interventions on C7. The Liberals are moving to impose sweeping, consequential legislation despite what they've been told clearly by Parliament and by Canadians. Yes, they've even ignored their own legislation. The government should not have moved to implement this bill before the parliamentary review of C14 that was slated to take place before the end of June next year. They should have done that first. We do not yet have a clear enough picture of the impact a Canada-wide MAID regime has had on our country. 5 years is not remotely enough time to take stock of trends and of abuse and the impact of MAID on charter-protected conscience rights. I remember the words of the former member from Winnipeg Centre, Robert Falcon-Ouellette, during debate on C14. In his view, the Liberals should have delayed the implementation of Canada-wide MAID regime for at least 5 to 10 years, until it could be adequately determined what the impact of assisted death would be in all communities across our vast and diverse country. Mr. Ouellette spoke against adding fuel to the suicide crisis that has taken such a heartbreaking toll on our reserves. Tyler White, CEO of Siksika Health Services, said recently that C7 runs the risk of undoing the work that Indigenous elders have done to curb the frequency of suicides amongst Indigenous youth. Mr. Speaker, what message does Madam Speaker, what message does C7 send these young people? If Indigenous advocates believe that C14 was a step in the wrong direction, why are they taking things even further, this government, with C7? What is the purpose of rushing this? I also remember the elements of the C14 debate pertaining to instances of MAID abuse in other parts of the world. And this is key. The Belgian model, of which C14 was modeled after, is known for its abuse. In Belgium and the Netherlands, MAID's laws, once limited to mentally competent, terminally ill adults, now includes adults and children with mental deficiencies, severely disabled individuals, and even those with treatable psychiatric conditions such as anorexia and depression. Between 2012 and 2017, the Netherlands alone saw a 600% increase in euthanasia, which was sought to address psychiatric conditions. Speaker, when was the government planning to take a hard look at Canada's MAID regime and how we can plan to prevent this kind of abuse in the future? The Minister of Justice says it's in the works, it's part of the plan. Why was it not done first? This is the cart before the horse. It's the tail wagging the dog. By ignoring a 5-year review, this government has also cast aside the concerns of physicians. We can't ignore the monumental importance medical professionals place on their Hippocratic oath. Such is true of Dr. Ramona Colho, a champion of conscience rights in her field. She told former MP David Anderson at the end of Parliament, and I quote, "Doctors know the importance of conscience rights to protect themselves and their patients. People like me are being pressured to leave family medicine. I know palliative care doctors in Ontario who have stopped practicing. I know nurses in institutions who are feeling bullied, shift the focus, or retire early. The pressure is there, and we are looking for relief." End quote. It saddens me that this government has yet to establish conscience protections for medical practitioners who do not wish to violate their conscience while at a patient's bedside, as this bill is asking doctors to go far beyond what C-14 even asked them to do. In Dr. Colho's words, quote, "It is my conscience that pushes me to go the extra mile, and I think patient care will suffer if doctors are not allowed to live with integrity and follow their conscience." End quote. Speaker, it is because of this risk of abuse on many fronts that many of us on this side of the House walked away from the C-14 debate with an unpleasant feeling in our gut. One that suggested that the implementation of the MAID regime had started Canada down a very slippery slope to a culture of death on demand. We're at C7 today. However, there was an ever-present light at the end of that tunnel with C-14. The 5-year review was important to members of this House and indeed to all Canadians. It is shameful that we find ourselves ramming through this legislation before this review is even started. On that note, I realize that the Liberals are frustrated that my colleagues and I have been so diligent in vocalizing the outpouring of concern from disabled Canadians, concerned medical professionals, and those whose personal beliefs conflict with this bill. That's our responsibility. The Liberals desperately want to speed up the passage of this life and death legislation. They want to meet the deadline imposed by the Quebec Superior Court. A deadline, I want to add, that they could have met comfortably if the House had sat in May and June and the Prime Minister hadn't prorogued Parliament in August. But, Speaker, in a way this is beside the point. The December 18th line is arbitrary, as was the deadline for C-14. As legislators, our mandate is to pass the best legislation possible for all Canadians. I underscore the words all Canadians. Speaker, this bill has barely been studied as the Justice Committee only held 4 meetings of hearings. Many witnesses and briefs were denied a voice because of this, and of course, they certainly could have, should have, and still could appeal the Quebec Superior Court decision. We could have struck a balance in good faith of what Canadians actually want when it comes to end-of-life decisions. As I said in a previous debate, 4 years since the passage of C-14 has allowed Canadians to further process the idea of assisted death. Almost 80% of Canadians believe that it should be easier to make end-of-life decisions for themselves. That number is 7 points higher than it was 4 years ago upon the passage of C-14. At the same time, Canadians are unwavering in their support of strong safeguards for the most vulnerable in our society, as well as conscious protections for medical professionals. They are unwavering. According to an Angus Reid Institute poll released last month, the same majority of Canadians who desire empowerment in their end-of-life decisions want Parliament to weigh the risks of MAID for those living with mental health issues such as depression. Madam Speaker, 69% fear that depressed individuals could see MAID as a means to escape dealing with the underlying cause of their condition. 65% of those surveyed want Parliament and the courts to consider MAID's impact on the elderly and those with disabilities. They fear that death on demand could encourage these Canadians to seek it as a means of ending their perceived burden on others. This perceived feeling is being encouraged, and more research needs to be done. 62% want Parliament and the courts to examine the potential impact of MAID on our healthcare system. There is a danger that increased reliance on assisted death will lead policymakers to begin neglecting long-term and palliative care. And I'm being gracious in saying begin, Madam Speaker, because in my view, we can see this discouraging trend unfolding already. 70% of Canadians continue to live without access to palliative care, while this government has failed to invest the $3 billion they promised to help in closing that gap. Clearly, there is a discrepancy. Canadians are equally as outspoken when it comes to conscious protection for doctors or for those whose faith bars their participation in MAID. 57% agree that nursing homes and hospices with conscientious objections should be able to deny MAID to those who request it. The Canadian Medical Association indicated 23,000 doctors are available to provide this service. That is more than enough across Canada. We need to protect our conscious protections. Canadians want to see reasonable safeguards maintained in Bill C7. They want to see Parliament legislate with their interests in mind, their interests, not those of the courts. They want to see this House continue to give credence to the views of medical professionals and those with disabilities. Regrettably, judging by what we've seen through debate, C7 is another example of this government allowing the courts to legislate for Canadians. This bill is not reflective of what Canadians hold dear: care and compassion for all, regardless of age, disabilities, or religious beliefs. Public health and economic safeguards have been the highest priority of this House throughout the pandemic. That's why so many in this place and across our country find that C7's attack on end-of-life safeguards so painfully ironic and troubling. It is for this reason that I cannot and will not support this bill.
Questions and comments. Questions et commentaires. The honourable member for Peace River Westlock.
Thank you, Madam Chair. And I just want to relay to the honourable member a bit of a story that I had. I shared recently on my Facebook page a picture of a clinic that said suicide prevention on the front door and a set of stairs going up to there, and assisted suicide on the side door and a ramp going up to there. And this is something that I've raised often about this particular bill, is that we've created two classes of citizens in this country. I recently had a constituent from Whitecourt reach out to me, Ms. Kay, and she's concerned that that picture that I shared on my Facebook page was not reflective of the current situation in Canada. I have assured her that it is indeed reflective of the case, and I'm just wondering if my honourable colleague can comment around the two classes of citizens that we're creating right here in Canada with this bill. Thank you.
Member for Yorkton Melville.
I thank my colleague for this question, and it definitely needs to be discussed. For some reason on the other side of the floor, they feel that they've heard from the disability community. I have no idea who they've spoken to, because across this country, every major disability organization has come out saying that this bill is a danger to them and they want to see the safeguards in there. So unfortunately, maybe there's a lot of Canadians that are just waking up to this reality, but I can tell you that every letter that I've received, as my colleague has, indicates that there is great concern, and we are people in this country who value life, who value every person. My children had the privilege of growing up in school where those with handicaps and disabilities were just part of the classroom, which was something very different than I experienced, and there's such a growing and growing appreciation of the fact that all lives matter, regardless of your conditions, and we all have something to contribute to this country, to our families, and to our communities. Thank you.
And comments, questions et commentaires. The honourable member for Abbotsford.
Thank you, Madam Speaker. I want to thank my colleague from Yorkton Melville for an excellent speech. She did reference the issue of this steep, slippery slope upon which we find ourselves. And back when C-14 was being debated in this House, many of us had concerns that this was indeed a slippery slope, and we were generally mocked and we were accused of fear-mongering. And today, here we are. In fact, it was very clear it was a steep, slippery slope. And it's the vulnerable in Canada that are being exposed to medically assisted death. And I would ask the member to comment on The assurances the government has made that those with mental health issues, that children will not be exposed to this in the future, that other vulnerable Canadians will not be exposed and are fully protected under this legislation. Just her comments on whether she takes those words at face value or questions them.
The Honourable Member for Yorkton Melville.
Thank you to my colleague for that question. I'm very, very troubled by what this government says and what it does. They put things up on websites, preambles, and yet don't include them in their bills. I'm sorry, I think I put something on my Facebook where I had said, if it's important and you say it is, it should be in there. If it's not, there is reason for concern. And we have heard that concern on this side of the floor as the official opposition from groups across this country. If they truly mean what they say, make sure those safeguards are in there. As a matter of fact, go the extra mile to say that you truly do care about the vulnerable and make it your priority, because right now there's no way that Canadians are hearing that from this government.
The Honourable Member for Sturgeon River Parkland.
Thank you, Madam Speaker. And, you know, it was alluded to earlier, it was stated earlier in question period from a member that, you know, it's members of faith communities that are holding up this bill and that they have an agenda. But in my observations throughout the committees and hearing the witnesses, it has been primarily, you know, faith-based communities have been involved, but it's been primarily disabled communities and Indigenous communities that have been sounding the alarm on this legislation. And I was hoping the member could comment on how incredibly inappropriate it is to try to cast aspersions on the motivations of vulnerable people who are just trying to stand up for their right to live. Thank you.
Member for Yorkton Melville.
Yes, thank you to my colleague for that question as well. Very disconcerting when it drops to that level. I guess that shows desperation. That being said, the reality is that we all have faith. My faith may be very different than someone else's, but whatever we do in this place is motivated by who we are and what we have entrenched in our lives through the relationships and the exposure and the perspectives that we bring to this place. And I am honored to be here for who I am, and we are at the House of Commons. We represent the sense of Canada across this nation, all our different regions, all of our different perspectives, and it's an honor for me to stand here and to represent the people that came to us for help on this issue, people with disabilities.
Fortunately, I have to resume debate. The Honourable Member for Elmwood Transcona.
Thank you very much, Madam Speaker. I'm rising today to participate in the debate, in the third reading debate of Bill C7, and I just want to, you know, recognize the very real and legitimate challenge and the difficult questions that are raised by the Truchon decision, which declared the reasonable foreseeable death criterion to access medical assistance in dying as being as going against the charter and being null and void. And so when we talk about the deadline in December that we are working towards, we're talking about that moment when the court decision will take effect. And that criterion, regardless of what passes or doesn't pass in terms of Bill C7, will become effective. And then reasonable foreseeability of death will no longer be a condition for accessing medical assistance in dying. So that raises a lot of difficult questions. It raises a lot of questions about the nature of human dignity. And of course, one of the things to consider in the long-standing debate around medical assistance in dying is the dignity that comes for people who are experiencing severe suffering, who know that it's not going to get better, to have the sense of autonomy that comes to be able to choose their own time to go and the conditions under which they go. The other really important side, and we've heard some other members speak to this already today, of human dignity is the dignity of those who choose life and who want to choose life, and have to know that in so doing, they have the resources and the respect for their human rights that it takes in order for them to make that affirmation of life and to choose to go on. And I want to take some time to recognize that for people in the disability community in Canada, this debate comes in a very difficult context. It comes in the context of decades of neglect and inadequate resourcing and support and recognition of the barriers that they face in trying to live a full life and realize their potential. It comes in the context of a pandemic where there's been conversations about how to allocate scarce resources and a real worry on the part of people living with disabilities that decision makers might not value their lives in the way that they value the lives of others, which has to be scary. And when they look for reassurance that the government has their back and understands these concerns, what they saw over the first number of months of the pandemic, about 6 or 7 months, was a lot of heel dragging on a commitment just to make a simple one-time payment to support people with disabilities in the added costs and difficulties of the pandemic. And I can understand why that doesn't engender a lot of confidence that the government has their back, understands their real concerns. And so in light of the Truchon decision and the long-standing neglect of people living with disabilities and the heightened sense of urgency given the pandemic, I can definitely understand how this has become such a charged issue, and the very strong feelings that people, especially in the disability community, are facing, Madam Speaker, because they don't want to be faced with the terrible dilemma of having to choose between a life of poverty and suffering on the one hand, or a premature death on the other hand. And we've heard there are certainly, people in the House speaking today to one side of that dilemma, which is, wanting to ensure that people are not forced into a premature death. But I put it to you, Madam Speaker, that you can't do that if you're not willing to address the other side of the dilemma, which is to recognize the overwhelming numbers of people in Canada who are living with disabilities that are forced into a life of poverty. There are a number of people living with disabilities who have managed to overcome a whole bunch of barriers and to get gainful employment and to support themselves and their families, and that's a wonderful thing. That's what I would wish for all people living with disabilities for whom that's a possibility. But we also have to recognize that for many people with disabilities, they're not going to be having a full-time job just like everybody else. There are barriers that simply won't permit that, and that's why we see such a high representation of people living with disabilities on various kinds of social assistance plans and other kinds of income support programs. Those programs have been totally inadequate in terms of allowing the people who depend on them for their income to live with dignity. So when we talk about dignity, it's really important that we talk about that, and we talk about human rights, and we talk about the importance of recognizing that people living with disabilities are people who have rights and who deserve to live in dignity, and that it takes resources in order to be able to do that, Madam Speaker. And so I really want to take the time to put the emphasis on that side. And because the court has made a decision about whether a reasonably foreseeable death can be part of the criteria for medical assistance in dying, the government chose not to appeal that. I can't change the government's decision on that. The NDP can't change the government's decision on that. But what we can do is try and add and take on the sense of urgency that the government has had around getting this legislation through the House when the House has been sitting. And I take the point, and I think there's some real legitimacy to the point that we all know that we could have had more House time in order to consider these questions. So when members talk about the effect of prorogation on House time, I think they're quite right. I think they're quite right about that, Madam Speaker. But nevertheless, what I want to say is that, we've seen some urgency around this legislation from the government. What we need is to see that same urgency around putting the supports in place for people living with disabilities so that they're not, so that the overwhelming majority of people living with disabilities aren't forced by virtue of being on some kind of income support plan to live a life of poverty. And that's why I was proud as the NDP's disability inclusion critic to write alongside the member for Esquimalt-Saanich-Sooke to write the government last week and to call for them to institute one national disability income support program that would cover people who are already receiving income support under the auspices of a disability program, whether it's through the provinces, territories, or the federal government, and to set that at a rate of $2,200 a month to recognize what I think many in the country have recognized during the pandemic in terms of $2,000 a month being a reasonable standard. Not easy for everyone for sure, but a reasonable standard in terms of income that we've seen a larger consensus than ever form around, but also to recognize, as we did when the Canadian Emergency Student Benefit was established, that people living with disabilities do face additional costs. And there was a differential for students living with disabilities. They were paid a little bit more in recognition of those additional costs. And so $2,200 a month would accomplish that. It would make sure that no matter where you lived in Canada, you had some kind of basic income that would allow you to put a roof over your head and to get the basic necessities of life. So when we talk about valuing life, that can't just mean not death. It has to mean providing the resources for people to really live a life that they value and that they feel allows them to meet their full potential, Madam Speaker. And that's not just a question of income. It is also a question of income. It's also a question of getting very deliberate and focused about an employment strategy to change the attitude of many employers who don't have experience with people living with disabilities in terms of educating them about what they can do in their workplace in order to make it a workplace that's more friendly to people living with disabilities to help overcome some of those barriers and to change attitudes in society generally, Madam Speaker. It's also about supports like investment in good public housing. That's where rent is geared to income, so that if you're not a high income person, you can still afford to be in good housing. It's about investing in good transportation options so that people living with disabilities who aren't able to own or aren't able to operate their own vehicle still have good options for getting around the city. That helps with things like employment, but it also helps with socializing in times where we're able to do that. And these are all the things that I think if we want to talk about the value of life, we have to not only talk about, but we have to do. And we have to do them with the same sense of urgency that the government has put on passing this legislation. So I'm very much looking forward to, and the NDP will continue to push in order for us to do those things in that urgent way. Thank you very much, Madam Speaker.
Questions and comments. Questions et commentaires. The Honourable Member for Sturgeon River Parkland.
Well, thank you, Madam Speaker. I thank the member for his question. I actually had the honor of listening to the member's father, a very long-standing and esteemed member of this House, when he came and spoke at my university about the intersection between faith, social gospel, and the founding of the NDP. And in the context of this debate, it was raised by a member in question period that those of the faith-based perspective who might be opposed to this legislation are so-called religious fanatics. And I wanted the member to talk about, and affirm that, people who do have a faith-based perspective on legislation such as MAID do have a legitimate point of view.
The Honourable Member Elmwood-Transcona.
Well, thank you very much to the member for the question. Yeah, I don't think comments like that are helpful for the debate. I think in terms of the comments that were made earlier in question period today, this is a difficult issue. It's rightly a difficult issue. It's one of the most important issues, and it's a fundamental existential issue. So I do think, and people bring their faith to that debate. That doesn't mean everybody is going to agree. We know that not everybody in the Christian community, for example, agrees on this point. There are people of faith who are proponents of medical assistance of dying, just as there are people of faith who are opponents of medical assistance of dying, and just about every position in between. I think the important thing is to stay focused on the issue at hand and to not get into ad hominem arguments. I know there's often a temptation for that in politics, but I think particularly on issues like this, it's important to avoid that temptation.
The Honourable Parliamentary Secretary.
Thank you, Madam Speaker. One of the concerns that I believe has a lot of legitimacy, and it would be nice to see some further dialogue on it, is in regards to the palliative care. And depending on where one might live in the country, whether you even might be urban versus rural, there's a great deal of difference in terms of where one can actually achieve palliative care. Now, the member from Elmwood is very much aware of the fact of provincial jurisdiction versus federal jurisdiction, and I'm interested in hearing his thoughts in regards to what he believes the national role should be in regards to the issue of palliative care. And if he could go above the area of just providing money, I would very much value his opinion.
Honourable Member for Elmwood Transcona.
Well, I thank the member for Winnipeg North for that question and for raising the issue of palliative care. I just want to take a moment to recognize the very good work of the member for Timmins James Bay over the years on that very point, and a motion that he helped the House get to passing, which was calling for a national palliative care strategy. And I think when I talk about the urgency that the government accorded to Bill C-7 being accorded to other issues, this is one of those issues. I mean, that motion passed a long time ago now, and we just haven't seen that kind of action happen. And we need to get moving on these things. And I think, it's the lack of action on those things that people in the disability community and other vulnerable communities look at, and it's part of why they worry, because the government has words and people in politics have words about these things, but we need to show that we can pass to action. We need to do that when it comes to palliative care. We also need to do it when it comes to things like pharmacare and dental care, ensuring that everyone, regardless of their employment status or their income, has access to those things is part and parcel of valuing life and creating those supports for people living with disabilities that will allow those who want, and I believe that's most people, to choose life and to have a life in which they can flourish and live with dignity.
This is the Honourable Member for Esquimalt, Saanich-Sooke.
Thank you very much, Madam Speaker, and I want to thank the member for Elmwood Transcona for his speech today, but also for working with me on the proposal we sent last week to the government for a national income support program for people with disabilities that would replace the patchwork of programs across the country managed by the provinces. I wonder if the member could comment on what he thinks the provincial premiers or provincial government's reactions would be to a federal national income support program for people with disabilities.
The Honourable Member for Elmwood Transcona.
Well, thank you very much to the member for his question. I think most members of this House are aware of the fact that provincial governments have been struggling a lot as a result of the pandemic. They've asked in many cases for additional transfers of funding that don't have any conditions attached. And I think that the federal government in this moment, as the government with the most financial wherewithal, and in a moment where the medical assistance and dying regime is changing, and I think that gives an even stronger added sense of urgency to the need to support people living with disabilities. This means freeing up some room in the budgets of provincial governments that currently have income support programs for people with disabilities to spend on other priorities. I would hasten to add, it shouldn't mean that it's a replacement for the non-income supports that they provide, so things around housing and transportation. But this would be a quick way to put some money back in the pocket of provincial governments while raising up the level of support for people living with disabilities, no matter where they live in the country. And I think that's one of the virtues of this proposal.
The Honourable Member for West River, Peace River Westlock.
I want to thank the honourable member for his speech there. I was just wondering if he's not concerned about the two classes of citizens that this bill creates. One, if you're an able-bodied Canadian, where suicide prevention measures will be given to you at your first request, and another one where if you're a disabled Canadian, if you're on your worst day and you're attempting suicide, that you will be provided with MAID. Is he not concerned about this, the two stream and the two classes of citizens that we're creating with this bill? Thank you, Mr. Speaker.
The Honourable Member for Elmwood Transcona.
Well, I thank the member for his question. I see it as an opportunity to highlight a provision of the bill that I don't think has really been talked about in the context of the debate in this way. I've heard conservatives say that they're worried that the 90-day period isn't enough for people whose death isn't reasonably foreseeable. But that waiting period is the waiting period that would apply to people living with disabilities whose death is not reasonably foreseeable. So actually, I think Bill C7 helps add something that if we don't add by passing the bill by the deadline, won't be there. And then so then you will have a case where people whose death is not reasonably foreseeable, but they meet the other criteria, could get access to MAID a lot more quickly than if we pass C7 before the deadline.
The Honourable Member for Vancouver East.
Thank you very much, Madam Speaker, and I thank the member for his comments. As always, I have to say this, his comments are always very thoughtful and well considered. So I really appreciate that. Now, on the issue around dignity of life, and it centers very much about people's ability to support themselves and the issue around income. And to that end, the proposal for a new program from the government to support people with disabilities, what sort of response has he received from the government on this proposal?
Honourable Member for Elmwood Transcona.
Well, to date, we haven't received a response. We sent the letter about mid last week. But what we do know from the government is that they had a vague commitment in the speech from the throne to a bold new disability income support program. So we're trying to fill in the blanks. Oftentimes we see with this government on other issues make promises without a lot of details. And I think characteristically, New Democrats are interested in the details and how you get it done. So that's why we've proposed a number, we've proposed a way to do it, and we've proposed what the advantages of doing that would be in terms of making sure that it doesn't depend on what part of the country you live in, what your level of income support is as a person living with disabilities. It's a way to put money back in the hands of provinces at a time when they desperately need it. And it's a way now to make sure that if you do need income support as a person living with disabilities, that you're not forced below the poverty line. Because if you look at the rates that are paid across the provinces and by the federal government, it's not enough to make it. It's just not enough. That has to change. When we talk about valuing life, when we talk about people choosing life, when we talk about not forcing them into a dilemma between premature death on the one hand and poverty and suffering on the other, it has to mean an income that doesn't keep them below the poverty line. That absolutely has to change, and that's the real crux of that proposal. We are hoping that the government will see that as a good way to implement its own promise. If they've got another idea, they better hurry up and share it, because this needs to be addressed with the same sense of urgency that this bill has been pushed through the House.
Resuming debate, the Honourable Member for Sturgeon River Parkland.
Well, thank you, Madam Speaker, and I apologize for my long speech. If I had had more time to prepare, it might be a shorter one. So it gives me no pleasure to rise yet again to oppose this deeply flawed and dangerous legislation, Bill C7. Now, the government has been complaining in the media that they think that the Conservatives are holding up this legislation and that they're going to miss their court-imposed deadline of December 18th, but they really have no one but themselves to blame. Conservatives are doing our constitutionally mandated job to hold this Liberal government accountable on its legislation. Looking at the record over these past 8 months, it is clear that our party has bent over backwards in giving the Liberals the breathing room to implement emergency economic aid and other COVID-19 related measures. We've been very cooperative. We have also seen a great deal of government legislation move fairly quickly through this House just this fall, and in a minority parliament at that. No, let's look at the Liberal record on getting this legislation forward. From the very beginning, the government really made its own bet on this one when they refused to defend their own legislation, C14, which was just passed in the last parliament. And even some of their own members came out on Twitter and said, well, that legislation was unconstitutional, admitting that they felt it was unconstitutional even when they were voting for it. But they did not use the opportunity to appeal this legislation to the Supreme Court. And that really just shows to me that it was the government's intent to use the courts to circumvent Parliament. And Parliament was mandated under C14 to conduct a thorough review of medical assistance in dying. And I believe that review was to occur next year. And I think it's important to have these sort of reviews built into legislation, because when we're talking about something as serious as medical assistance in dying, which is a novel legislation, it's a new innovation in our social fabric, and Canadian people really haven't had adequate time to digest how they feel about this legislation and to examine their lived experiences with this legislation. And so I believe a 5-year review was a very adequate provision to give Canadians a little bit of time to assess the bill, and then to have Parliament come forward and make recommendations and possibly changes to the legislation so that we could fix this bill, whether that meant tightening up some things that were prone to abuse, or maybe changing some things to loosen it up in cases where it was needed. But in the Liberal government's desire to short-circuit that legislative process, to short-circuit the will of the previous Parliament, they chose to fast-track this legislation by not choosing to appeal this to the Supreme Court. And I believe this was done very purposely to ensure that this legislation would pass before a review would take place, because I believe that if the review had gone forward, I think, and what we've seen from the Canadian Council of Academies, is that there are a lot of questions about the practice of this legislation and about how it's been carried out over the past few years. And I think there are abuses, and that's been raised at committee, and it's been raised in this House repeatedly. And yet in this legislation, the government has really taken no efforts to take those experiences and try to make this a safer piece of legislation for vulnerable people. Because of the COVID-19 pandemic, the government was required, so going on to like the next example of why this is the government's problem that they made themselves, with the COVID-19 pandemic, which I agree wasn't the government's fault, they were required to request several extensions of the bill. And the courts were willing to approve those extensions. And in the late summer, they chose to prorogue Parliament. And by proroguing Parliament, they made the choice to clear the decks of all their legislation, starting right from the beginning, sending us back to the drawing board. And by doing that, they delayed this legislation yet further weeks. So for the Liberal government to claim that Conservatives are holding up this bill when what we're doing is our constitutionally mandated job, especially on an issue as important as life and death, I mean, it doesn't ring true. And another example is that if this bill was so important for the government to get passed so quickly, then why wasn't it the first justice bill that they put forward? I mean, we had Bill C-3, which was passed in a very expeditious manner. It was passed with all party support in this House. It was passed, with largely the support of committee with minimal amendments, and but that delay, even in that expedited manner, that delayed the government's legislation by weeks, and so they're talking and complaining about how us Conservatives are allegedly delaying this legislation. Well, it was their own choices that resulted in a delay in this legislation. So now we're left today. The government's complaining that the Conservatives are doing their job. We're doing our job by criticizing their legislation. We're holding them to account. We're championing the rights of vulnerable people. And Mr. Speaker, we will never apologize for doing what our constituents have sent us here to do, and which is to stand up for their deeply held beliefs, to stand up for their concerns, and stand up for vulnerable people. Vulnerable Canadians have made their desires known and their concerns known very loudly and clearly at the committee. And I'm pleased to see that the other place has had more time to hear from witnesses. I believe they've heard from over 80 witnesses, and the vast majority of whom are opposed to this legislation. And frankly, in the House, we only had 4 committee meetings for this very important legislation. So I am pleased that the Senate is taking its responsibilities seriously and thoroughly examining this bill and hearing from vulnerable people and others who are concerned about this legislation. These members of these communities they were afraid of C-14. They were assured by this government that they would be protected, that there were protections from people with mental illnesses from accessing it. There were protections for children. There was the reasonably foreseeable death requirement, which was touted as a great protection for the disabled community. But I can tell you what they're saying is that they are terrified by what they see in this bill from this Liberal government. And I read today on CBC that the Minister of Justice, and it appears like he's in a showdown with disabled groups who are demanding a halt to this bill. The idea that the Minister of Justice, whose role is to uphold the Charter and rights and freedoms for Canadians, is fighting and ignoring the pleas of disabled and other vulnerable Canadians is just plain wrong. Conservatives have been listening, and we have been fighting for these vulnerable Canadians. And it appears like nobody else is willing to fight for them. And so that's what we will do. We are fighting for these vulnerable Canadians by, we're not being intransigent about this bill. Conservatives have a wide range of perspectives on this issue. And we have put forward, as a party, some very common sense amendments that don't undermine the legality of medical assistance in dying as a general practice, but will do a lot to assuage the fears of vulnerable Canadians. And some of these common sense amendments that were proposed at committee include protecting patients from undue coercion. And, by coercion, people immediately draw up images of doctors in a deeply immoral situation, pushing medical assistance in dying on vulnerable people who are isolated from loved ones and family members. And I'm not trying to say that is happening. And frankly, I think what we have seen is that it's a lot more benign than that. It's not doctors aggressively pushing medical assistance in dying on people, but when you're in a situation where there's a power imbalance, where you're a disabled person or another vulnerable person or a person who is, older, and you might not have family members, you might not have access to, supports like social workers or a psychologist, and in this situation, you trust your doctors, and that's a good thing because our doctors work very hard and they're very professional. But when you have that trust relationship with your doctor, and a doctor comes and says, "Have you considered medical assistance in dying?" That seems very benign. For an average person, if I was in a situation like that and a doctor came to me, I'd say no, thank you. But you never know, what somebody's going through and what challenges they could be going through. And if they don't have somebody to turn to, they can feel like, the doctor, they're looking out for my best interests and they're suggesting that, maybe I should consider medical assistance in dying. Maybe they're right, and maybe I should. And so in this case, we recognize that there's a power imbalance. And so at committee, we suggested putting forward some very strong protections to say that healthcare professionals should in no way be presenting medical assistance in dying as an option to patients. And I think this is a basic protection. And, this is something we talked about with the last bill. And I was actually very disturbed during debate in the second reading that there was a Liberal member who stood up and was talking about how there was a couple that, they knew, and it was a very touching story. And the couple had not ever considered medical assistance in dying. And the member sort of just very nonchalantly said, well, the doctor came in and passed them a brochure and said, "Have you ever considered medical assistance in dying?" And, the member, I think, thought that this was a very innocuous and benign situation. But for me, and for the people in disabled and vulnerable communities, this is a very scary situation that if they're being put into, that without adequate supports, that they're going to be, they might feel like they're being coerced into a decision. So, we also wanted to put in some stronger protections around a period of reflection. And, I think this period of reflection is key because even in the government's own reports on medical assistance in dying, there were many cases where people did not receive their disability supports, and they received MAID while still not receiving their disability supports. There were people who were waiting to get palliative care who had not received access to palliative care who also received medical assistance in dying. And so, it clearly illustrates that this government is not putting the resources in to help disabled Canadians, to help Canadians who need palliative care. And if we shorten the timeline or eliminate the timeline altogether, then we're really losing an opportunity for people to access these wonderful services, which can, make end-of-life decisions, make our end of life a much more peaceful life. So one of the sad things, about me debating this bill today is that I feel like I'm being forced to defend the status quo that was implemented in the last Parliament under C-14. And I wasn't a big fan of C-14, and I think that as legislation, it has proven time and time again to fail to protect vulnerable people. It certainly didn't protect the prisoners who underwent medical assistance in dying, and this issue was raised by the Office of the Corrections Investigator. And this is an issue with deep moral and ethical problems. Prisoners who are in the prison system really have no power. And he raised some cases where a prisoner was coming close to the end of death and they wanted to die peacefully in the community with access to palliative care, and they were denied the opportunity to do so. And then they chose MAID instead. And I think the corrections investigator is very astute in bringing this up, is that a situation where somebody doesn't have a right to determine the own manner of their death or the manner that leads up to their death, how can they be given a free choice to access medical assistance in dying? And so that raises some big issues. It also didn't support, and there's been numerous cases where people were largely not sick with anything. There was one case, and it was in the news, it was in the Globe and Mail a number of years ago, where an elderly couple wanted to die together, and they were in their 90s, and they weren't suffering from any pre-existing conditions except for arthritis, according to the article. But it was ruled that because they were so old, their death was reasonably foreseeable. And that is really troubling, because it's been raised by medical professionals that a reasonably foreseeable death is not actually anywhere in any medical journal. There is no definition of reasonably foreseeable. It's so subjective. And so one thing that I would have really liked to have seen with this legislation is for the government to come forward with actual medical definition for reasonably foreseeable. But instead, they've chosen to just eliminate this language altogether, which is just further watered down the protections. C-14 didn't save people who were suffering from mental illness challenges from receiving medical assistance in dying. There was a case in Chilliwack where somebody who had a history of depression was able to access medical assistance in dying in an expedited manner. Their family wasn't informed until very late into the process, and they weren't able to intervene in a way to explain that this person, while they did have a reasonably foreseeable condition, that they also suffered from depression and other challenges, and that maybe with a social worker or a psychologist, those things could have been worked out, and a medical assistance in dying procedure could have been avoided. So it's clear to me that we're even removing the barest of protections, and we're removing this adequate reflection period, and we're making this legislation that's already prone to abuses, now with this new legislation, even more open. So this new bill, which the government claims would deny those who, they're saying this is safe because we're explicitly denying people who are suffering exclusively from a mental illness from receiving MAID. And it's interesting because in the previous legislation and in committee appearances at the Joint Special Committee, which I sat in on a lot of those meetings, even though I wasn't a member of the House at the time, Dr. Sonyu Gain from the Canadian Psychiatric Association, was very hesitant to endorse medical assistance in dying for people suffering from mental illnesses, because, especially exclusively mental illnesses, because in their testimony they said, we don't treat any mental illness as if it's untreatable. There's always a treatment. Sometimes it's a very difficult treatment. It's an ongoing treatment, but we must never accept as a society that there is not a way to treat mental illness, because the alternative is that we stop helping people and that they seek medical assistance in dying. And so, it's a bit tricky when the government's talking about, well, we're making it, excluding it from people with exclusively mental illnesses. But what we're seeing is that too many people who, might qualify for medical assistance in dying because they have a physical condition, they have a reasonably foreseeable death, but they also have a mental illness. And in the case where we have doctors involved, and doctors are very well-educated people, but they're not necessarily educated all aspects of health. And certainly not every doctor is a psychologist or qualified to make mental illness determinations. And so, how do you know that somebody who might have a reasonably foreseeable death, might have a grievous condition, is not, depressed and is not, seeking medical assistance and dying for the purpose of their mental illness? Under this legislation, there's no protection from those people seeking a medical assistance and dying because, well, the government says you qualify because you have, a grievous and irremediable condition. But, we need to have more protections to ensure that people with mental illnesses are not seeking medical assistance and dying, maybe in the heat of the moment. Maybe they've had an incident that has led them to want to get this, and given more time to reflect, they might be dissuaded from seeking out that decision. So, there are no mechanisms, as I said, and, I'm going to put forward, I'm not just going to criticize, I'm going to put forward actual concrete ways that I think that we can make this legislation better. Unfortunately, it doesn't seem the government's in the mood to accept too many amendments from the Conservative side, but I'll go ahead and say them anyways, is that we should be requiring that social workers and a psychologist is involved with decisions where it might be identified that there are underlying mental health issues or issues related to access to income supports or poverty. I was very disturbed to read in Maclean's magazine that some people are seeking medical assistance and dying because they're living in poverty. And it's like, that was never written in the legislation. That was never intended as a purpose for medical assistance in dying. And so by including these important medical professionals, I think we can make it much more difficult for people to get medical assistance in dying who might not make that decision if it was just between them and a doctor. And that leads me to sort of one of my final points that I want to make here is that the government's removing some of the witness requirements. And under previous legislation, it was required that an independent witness who's apart from the medical process is involved in this. And I think what that would do is it would provide accountability to ensure that doctors and healthcare professionals are crossing all their T's and dotting all their I's to make sure that this is a completely kosher procedure. But by removing the independent witness requirement, you're basically just leaving it up to a doctor and the patient. So with that, I want to say I'm going to be opposing this legislation, and I look forward to the other place coming back with some very strong amendments. And I look forward to debating those amendments again and getting the best possible legislation that will protect vulnerable people in this country. Thank you, Madam Speaker.
Questions and comments? Questions et commentaires. The Honourable Member for Hamilton Centre.
Thank you very much, Madam Speaker. And I know this honourable member to be a man of compassion and deep caring, certainly has now spoken at length, raising many compelling arguments, of which I tend to have many points of agreement on, many places of common ground. And we've heard Conservatives, Madam Speaker, talk about dignity in life, and yet earlier in this debate, when it was proposed that we provide actual financial supports, a member of the Conservative caucus answered that it had to be in exchange for support of the extractionary oil and gas sector in a very flippant way, Madam Speaker. So I'm going to give this honourable member the opportunity to clarify on behalf of CARE and Compassion that all the talk about supporting people and the dignity of life, does this honourable member, is he willing to support our proposition that we provide financial supports for people living with disabilities in a way that would lift them out of the poverty and despair that we are hearing them advocate for as it relates to C7?
The Honourable Member for Sturgeon River Parkland.
Well, thank you, and I thank the honourable member for the question. And I'm not going to, comment on the interaction. I'm not aware of the context of the interaction that he alluded to, but I will say that I am unreservedly in support of better economic supports for the disabled and those who are in poverty. But it's really about how we reach that place. And we live in a confederation. We have provinces that have their own income support measures. I know the NDP, we're talking about, a national measure, and it's all about finding what is the best politically workable solution to ensure that people can get access to the income supports that they need. And something that has been alluded to is that a lot of people who are accessing medical assistance and dying, the statistics have been showing that they're generally people who are in the the upper class who are accessing this legislation, but that there are people who are impoverished who are accessing this because they have concerns over their ability to make their payments or to live life the way that they want to live it. And we need to address those intersectional socioeconomic factors with this legislation. And I just don't think that that's been given adequate coverage.
Honourable Member for Saskatoon-Grasswood.
Well, thank you, Madam Speaker. I want to thank Sturgeon River Parkland, our colleague. You know, I've sat in the House today for 6 hours and I haven't heard the word Robert Latimer. Robert Latimer was a farmer from Biggar who killed his daughter, Tracy, who was 12 years old at the time. He was convicted of killing his 12-year-old daughter. She had several severe disabilities. You know, Tracy, at the time I was in the newsroom at CTV Saskatoon, and we would do several stories with the Latimer family almost every week. In fact, I think that case is one of the most polarizing in Canadian legal history. Robert Latimer actually killing his 12-year-old daughter, Tracy. Tracy could not walk, she could not talk or feed herself. And here we are over 25 years later in the House now talking about a situation like this. And I just want to know from my colleague from Alberta, he's heard of the case. Everybody, I think, has heard of this case over 25 years ago. Robert Latimer served time in Victoria, about 10 years. I just want to ask the question from Alberta, his thoughts as we debate C7 here in the House today.
Honourable Member for Sturgeon River Parkland.
Well, I thank the honourable member for that question. And yes, that was a very shocking case, and I think it laid bare just some very very difficult questions. And in my perspective, when we're talking about this legislation, I think that's one of the strong reasons why there was so much all-party support to prevent minors from accessing medical assistance in dying. And I think it's absolutely critical that we ensure that remain the policy in this country, is that minors not be allowed to access medical assistance in dying. And I think it also raises questions about how we value human beings. And I myself, my younger sister, who has since passed, had Down syndrome. And, I have seen how some people have shown that we live in a much more inclusive society today, and I think that's a wonderful thing. But we've seen how people can devalue the lives of people like my younger sister, and we need to ensure that we stand up for the value of those people's lives. And I think that as a Conservative caucus, that's what we're trying to do when we're fighting for vulnerable people who we believe will be impacted, in some cases fatally, by this legislation. Thank you.
Questions and comments? The Honourable Member for Abbotsford.
Well, thank you, Madam Speaker, and thank you to my colleague from Sturgeon River Grassland for his wonderful speech, which reflected compassion, but it also reflected a high respect for human life. Unfortunately, there's a lot of us here in this House that lament the fact that we can no longer critically debate. We can't establish our views based on the merits of the arguments. And today we saw that in question period, where those who oppose this legislation were referred to as religious fanatics. I would ask my colleague, does he agree that the vilification and disparagement of those who don't support the Liberal government's effort to expand assisted suicide is appropriate?
The Honourable Member for Sturgeon River Parkland.
Thank you again, Madam Speaker. I thank the honourable member for his question and for his wisdom on this issue. And as the member who spoke previously from the NDP said, it's very unhelpful to this debate to be casting aspersions and to be singling out certain groups of people and questioning their motivations. I know the motivations of people who come from a faith background and a faith perspective on this issue from both sides of the issue are honourable people who want to do what they feel is right. And but certainly I think it's very demeaning to just cast all opposition to this bill in that singular bucket when we have so many people from the disability communities, from Indigenous communities and other vulnerable communities who are raising the alarm about this bill. And I just think it's a cheap shot that undermines, the quality of this debate, and it undermines our ability as legislators to come here and bring the views of our constituents and to have, what democracy is all about, to have an opportunity to share our perspective and shape the way that our country is going. And that's incredibly important. And I think the member's right that seems to be decaying, and we must put a stop to that, and we must reverse that as soon as possible, because I think our country will suffer when one side is being told that they can't participate in debate. Thank you, Madam Speaker.
The honourable member for Hamilton East, Stony Creek.
Thanks, Madam Speaker, and I appreciate this debate. But in light of what recent was just said, I would point out that the member across the way depicted the Attorney General as having ignored the pleas of the disability community. And I would ask him if he honestly thinks that man, the Attorney General, is ignoring the pleas of the disability community, because all of us on this side, and hopefully all of us all on the other side, all have the best interests of Canadians at heart. And this is a difficult, complex issue. We understand that, and it's good that we're having this debate. But does the member actually think that the Attorney General ignored the pleas of the disability community?
Honourable member for Sturgeon River Parkland.
Well, thank you, Madam Speaker. And there's a saying that goes that the road to hell is paved with good intentions and the best of intentions. And I think, that you don't have to take it from me saying that I believe that the Attorney General is ignoring the pleas of disabled Canadians. You can take it from them themselves. They've been saying it at a committee. I just read it in the CBC today that he's in a showdown with disabled and vulnerable communities who are calling for this legislation to be halted. And so if the minister is indeed listening to the pleas of the disabled community, why has the committee majority rejected any of the recommendations put forward by the disabled and vulnerable communities? And why are they so intransigently fighting any effort from these communities to shape this legislation in a way that would protect their lives and protect their dignity? So, it's really up to the government to show and demonstrate that they're listening to the pleas, because I have seen absolutely no evidence that the Attorney General has done so. Thank you, Madam Speaker.
Thank you for the question. Conformément à l'article 38 du règlement,
it is my duty pursuant to Standing Order 38 to inform the House that the questions to be raised tonight at the time of adjournment are as follows.
Housing. The Honourable Member for Regina Luan, Air Transportation. The Honourable Member for Leeds, Granville, Thousand Islands and Rideau Lakes, Ethics. Resuming debate, the Honourable Member for Tobiqua-Mactaquac.
Thank you, Madam Speaker, and it is a privilege to rise in the House again this afternoon and today talk about a bill that I believe deserves long and serious consideration. The ramification of this bill will last a very long time, long beyond any one parliament or group of parliamentarians. Hence, I think it would behoove this parliament to make sure that we spend the adequate time reflecting on this bill and making sure we get it right. As I've said before, I believe it bears repeating, especially as we debate this bill, that the character of a nation is reflected in how it treats its most vulnerable citizens. Madam Speaker, there is an ancient writing from the book of Psalms that many of you would be familiar with. It's been utilized all over the world and been heard for centuries and generations. And it simply states this from Psalms 23, "Yea, though I walk through the valley of the shadow of death, I will fear no evil, for you are with me." And one of my previous roles as a minister, I had the privilege of walking with individuals and families as they traverse the valley of the shadow of death. I have both witnessed and experienced personally what it means to be affected by the passing of a loved one, as I'm sure many, if not all, in this chamber have as well. This bill brings with it great responsibility and literally deals with matters pertaining to life and death and decisions of absolute and complete finality. I believe it would behoove this House that we take adequate time to reflect upon the powerful testimonies that we have heard at committee, such as Mr. Roger Foley's testimony, where he shared his story of being denied health services he requested and instead was pressured to pursue a medically assisted death. He's now fighting for others to not be put in the same situation he was, and he supports our amendments to the bill. Krista Carr also gave testimony at committee from Inclusion Canada, working with persons with disabilities, stated at committee, and I quote, "The worst fears of those living with disabilities are being realized by Bill C-7. This government's own Minister of Disability and Inclusion has stated MAID should not be brought up by doctors to the disabled. Indigenous leaders have also raised serious concerns over this bill and its inadequate safeguards, including the former Attorney General and Minister of Justice for Canada. Medical practitioners have raised concerns pertaining to conscience rights as it pertains to medical assistance in dying. So in light of all these concerns that have been brought to the table and all of these powerful testimonies that we've been able to hear, and you can see from across the country, Canadians raising the alarm bells and making sure that and encouraging those of us who are parliamentarians to get this right because of the finality that this decision entails. What would be wrong for us to pause and adequately reflect about such serious matters and take the time to ensure that adequate safeguards are built in so that the concerns of our most vulnerable amongst us are adequately addressed? No one could deny that those concerns have not been expressed and expressed with fervency and urgency. We as all parliamentarians should take the time to reflect at this point and say, what steps are we taking to make sure those concerns are being addressed in this legislation? I remember a lady I got to know in my time as a pastor who had suffered greatly with a disease that had caused her to become completely incapacitated in many ways. She couldn't walk. She couldn't even lift her arms to feed herself as the disease continued to progress. Her health was deteriorating. Her emotional stability was already ravaged by having gone through the loss of her husband overseas. And I remember visiting her in the hospital. And at that time, watching as her mother had to feed her with a spoon. Almost like I would say almost a pablum-based type of nourishment, because she was slowly losing her ability to chew the food. Her circumstances were overwhelming. And in visiting and being in the hospital with her at this time and with her mom, what we saw there, you couldn't leave and not be affected. And I must say, our community responded, and our faith community and church community did everything they could to provide encouragement and support and visits and make sure adequate food and support was provided where possible. And she had been through so much. And she had a hard time even expressing all that she was going through. And I remember one such day, and it didn't appear like that she had all that long to be with us. I went to visit her in the hospital and witnessed this. And as she was taking the nourishment from her mom, I remember leaving that hospital room shaken and just, I wish there was a better way for this lady. Well, I'm glad to report to you that it was amazing the turnaround that she had. Her story didn't end where we thought it was going to end. And though her pathway had been up to that point marked with a lot of suffering and discomfort and terrible loss, I'm glad to tell you that over 12 years later, this woman has fully recovered. She's married again. She's enjoying life, and she's doing well. And you say, well, what does that have to do, Richard, with what we're talking about? It has a whole lot to do with it. I believe that there are many, many other Canadians who have walked through that valley of the shadow of death, and it seemed like they weren't going to be able to get to the other side of it. And they wondered if their life was still worth living, and they wondered if they could make it to the other side. But because of the support, the care, and the love of friends and family and community members who stood by them in that most difficult of circumstances, they were able to get through that valley and get to the other side. And I wonder how many other Canadians who are in terrible circumstances and at the moment seem overwhelmed by what they're facing, that by having people who will walk with them through that valley, that may be all that they need to get to the other side. It may not be the case for everyone, but I know for that lady, and I'm so glad it was the case for her, it made all the difference in the world to know that others kept believing when she had lost the ability to believe herself. And then when she got to the other side, she has served as an inspiration for many others. So I want to conclude with this, Madam Speaker, that though the valley of the shadow of death casts a very long and dark shadow for those going through it and their families, as a member here who has lost a loved one, I can attest we have an obligation as parliamentarians to pause and ensure that every safeguard is in place so that when someone is walking through that valley, they don't make a decision while still in the darkness when they may be at the end of that valley. The last part of that writing I shared at the beginning is, for you are with me. I think the question that every parliamentarian needs to ask themselves, are we going to be there for all Canadians who are in the midst of the valley of the shadow of death? Are we going to be with them by ensuring every safeguard is in place and the supports necessary to carry on are amply supplied? Thank you, Madam Speaker.
Questions and comments? Questions et commentaires. The Honourable Parliamentary Secretary.
Yes, thank you, Madam Speaker. And I like to think that I will be there. You know, I went through a personal experience, and I'll just cite my father as an example, where his dying days was very difficult because of the severe amount of pain he was experiencing. And I am ever so grateful that I was with him at his time of passing. And it was medicine that ultimately alleviated the pain. But as some healthcare professionals indicated to me, it likely might have shortened his lifespan also. I understand the importance of and the difference between an assisted death and assisting someone in suicide. My father was a very proud man, and I believe from my heart that he died with dignity and the way in which he wanted to pass. I understand how important this legislation is. And I would remind members that this is a debate that has been taking place now for many years. And even after we deal with this legislation, the debate will continue because we all recognize, no matter where we fall on the issue, the importance of making sure that we get it right. And we will continue, I suspect, to do so in the form of committees. But we do have some deadlines that do need and should be addressed. And the member might provide his thoughts on that or my comments, whatever he feels most comfortable on. Thank you, Madam Speaker.
The Honourable Member for Tobique-Mactaquac.
I'd like to thank the Honourable Member for his comments. And I want to say that I really appreciate him sharing his personal story, walking through the valley with his dad. And I can relate, having had a brother who was 34 years of age and had cancer and suffered quite tremendously towards the end. And I remember being there and watching that. And yes, medication played a role in in alleviating the pain and helping with the suffering. But ultimately, we walked through that valley and all the treatments and all of the things that we went through. Some of it was not easy at all to witness. But I will say this, I was very, very thankful to have every moment that I did have with my brother. And I was extremely thankful for how others came through in that time and the people that rose to that occasion from our community, from all walks of life. And I think sometimes in a rush to alleviate suffering, which we all want to do naturally, we sometimes, perhaps, can miss the lessons and the virtues that only suffering can bring in life. It's as the ancient saying once said, there's more to be learned in the house of mourning than in any other house. And I think sometimes the lessons that we learn from people who've gone through tragedy or gone through hardship or dealing with painful circumstance, it helps all of us to understand what matters most. And one of the greatest lessons I learned in that time was that every bit of life that we have is to be cherished. And I'm so thankful for that. And the things that are said in those moments.
If I may just interrupt for one last question from the Honourable Member for St. Albert, Edmonton.
Thank you very much, Madam Speaker, and I want to thank my friend from Tobique-Mactaquac for his impassioned speech. The Honourable Member brought up the case of Roger Foley, and as he concluded his speech, he talked about the need to ensure that there are adequate safeguards in place. I was wondering, having regard for the case of Roger Foley, if the member could provide his thoughts on the removal of a key safeguard in this bill, and that is to provide for to provide for 2 independent witnesses. This legislation removes that and actually provides that persons who are attending to the care of someone requesting medical assistance in dying can constitute a witness. Can the member speak to that?
Honourable Member for Tobique-Mactaquac.
I'd like to thank the Honourable Member for his comments and his question. And look, I think, again, when it comes to this, any safeguards that are being removed, to me, pose a great threat to, I believe, providing adequate safeguards for everyone who's traversing this valley, the valley of the shadow of death.
And I have to resume debate. I'm really sorry. The Honourable Member for St. Albert, Edmonton.
Thank you very much, Madam Speaker. I'm pleased to rise once again to speak on Bill C7, the government's medical assistance in dying legislation. I do acknowledge that this is an incredibly complex subject matter for which there are many diverse views. With that said, the way in which the government and the Attorney General have handled this legislation is a lesson in what not to do, having regard for the gravity of this legislation. And I say that having full respect for the Minister of Justice and Attorney General. I believe that he is a sincere and intelligent individual who is compassionate and does want to do what he believes to be right. But with that said, Madam Speaker, when the Minister of Justice spoke in this House at second reading, he indicated that there were widespread consultations and that out of those consultations there was a consensus. Madam Speaker, neither are true. The consultations that the minister spoke about were largely over the course of 1 month in January of this year. They were online consultations that excluded vulnerable segments of the population, including persons with mobility, cognitive, or visual impairments, persons without access to the internet, persons living in remote and northern communities. Their voices weren't heard or not heard as easily as a result of the online consultation process that started and ended within roughly the period of 1 month. Madam Speaker, not only that, the consultations were said to have had a predetermined outcome. In other words, the minister had an idea of the legislation that he sought to craft, and he used the process as a way of getting the answers that he had hoped to receive. Now, don't take my words for that. Take the words of persons who were involved in the consultation process, including Heidi Jantz of the Council of Canadians with Disabilities, or Dr. Catherine Frazee, the former Chief Commissioner of the Ontario Human Rights Commissioner, and a leading advocate for persons with disabilities. They said that the consultations were predetermined when they appeared before the Justice Committee. Now, what about the consensus that supposedly arose out of these so-called extensive consultations that simply were not so? Well, Madam Speaker, we know that out of those consultations, just about every national disabilities rights organization opposes this bill. As we speak, they're calling on the minister and the government to put this bill on pause. We know that more than 1,100 physicians have penned a letter expressing their opposition. Concerns were expressed by the UN Special Rapporteur on the Rights of Persons with Disabilities. And just about every witness, if not every witness, other than the minister himself, who appeared before the Senate Legal and Constitutional Affairs Committee, which held hearings the last couple of weeks, panned the bill. No one, Madam Speaker, it seems, is happy with this bill. So much for the minister's assertion at second reading in this House that there was a consensus. There was no consensus because there was no meaningful consultation, and there was a predetermined result that has resulted in legislation that just about everyone in one way, shape, or form has been highly critical of. Now, Madam Speaker, I hear over the course of the debate members of the government and other parties talk about this issue in the context to which, or as if there are no risks. Get out of the way, let the patient make their choice, and throw out safeguards, because otherwise one is infringing on individual autonomy. Well, Madam Speaker, the Supreme Court of Canada recognized in Carter, quote, "There are risks to be sure," closed quote, at paragraph 105 of the Carter decision. And the court talked about that those risks can, quote, vary substantially be minimized through a carefully designed system that imposes strict limits that are scrupulously monitored and enforced, close quote. Very substantially minimized through a carefully designed system, scrupulously monitored and enforced. That is what the Supreme Court of Canada said. And when we talk about those risks, one need look no further than the case of Roger Foley, who is someone who is severely disabled, who requires 24-hour care, who is in a hospital facility in London, Ontario, who said this about his experience. And I read his words because they're really quite shocking when he came before the Justice Committee about what can happen when there are not sufficient safeguards. And we're talking about safeguards that are in Bill C-14, safeguards that are now being further removed by this bill. He simply said, quote, "I have been coerced into assisted death by abuse, neglect, lack of care, and threats. For example, at a time when I was advocating for assistance to live and for self-directed home care, the hospital ethicists and nurses were trying to coerce me into an assisted death by threatening to charge me $1,800 per day or force discharge me without the care I needed to live. I felt pressured by the staff raising assisted dying rather than relieving my suffering with dignified and compassionate care," close quote. In the face of that, we put forward an amendment to say that this must be patient-initiated. The minister responsible for disabilities inclusion said that she has grave concerns about what happened to Roger Foley and that she has heard about this regularly. And yet, even in the face of that evidence, the government rejected that very common sense amendment. They rejected other amendments. Instead, they have moved recklessly ahead, and we are now in this untenable situation where the most vulnerable persons in our society could be put at risk. It really is unfortunate that it has panned out this way. I can only hope that the Senate will bring forward substantive amendments to this deeply flawed legislation. Thank you, Madam Speaker.
Questions and comments. Questions et commentaires. The Honourable Parliamentary Secretary.
Yes, thank you, Madam Speaker. And the member, looks over to the government and accuses the government of defeating Conservative amendments. And I suspect that if the member were to reflect in terms of what had taken place in committee, that he would likely find that is in a minority situation, that it's not just the Liberal Party that actually votes and that will carry the vote in a committee, as the member knows full well. So the Conservatives were unable to be able to convince enough members of the committee to be able to support Conservative amendments. Madam Speaker, I suspect that the current legislation as it is reflects the overall thinking dating back to 2015 from the Carter decision to the Superior Court decision in Quebec, which has, in essence, put the deadline for December 18. My question to the member is with respect to other members of his caucus, one in particular that said, well, the government of Canada has options. And the option is to go to the Court of Appeal or go to Quebec and say, we need the extension, or to go to the Supreme Court. And I'm wondering if he shares that opinion and if he could expand on it.
The Honourable Member for St. Albert, Edmonton.
Madam Speaker, very simply, I do share that opinion. And I would further add that it should never have come to this, because the appropriate course of action for the Attorney General to have taken was to have appealed the Truchon decision in the first place. Had the minister done so, at the very least, we would not be in this position of trying to rush through legislation on the eve of the stay of the Declaration on Constitutional Invalidity expiring.
The honourable member for Nanaimo Ladysmith.
Well, thank you, Madam Speaker. I know the Conservatives have expressed a lot of concern about people who are making money during the pandemic who shouldn't be making money during the pandemic. And I know they're not talking about the 20 billionaires who made $38 billion in the first 6 months of this pandemic. They're talking about people who got the CERB who don't deserve the CERB. And in the last week, I've had a number of constituents, people with disabilities, who have contacted my office because they're getting letters from the CRA saying that they need to pay back the $14,000 in the CERB that they received. These are people who have disabilities and have self-employed businesses. They use that self-employed income to pay their rent, to pay their utilities, to help out with their expenses. But they didn't understand the difference between the gross and the net in the application process. And people on disability benefits here in British Columbia can earn $12,000 a year before their disability starts getting clawed back on them dollar for dollar. And I'd like to know from the honourable member whether he would like to see more compassion on this issue, taking care of people with disabilities now, while they're alive, trying to survive, and what he thinks should be done.
I'm sorry, but I have to give the honourable member for St. Albert Edmonton a time to answer.
Thank you, Madam Speaker. And what I would hope is that the concerns expressed by the disabilities community would be heard as we debate this important piece of legislation. But unfortunately, those voices were not heard by the Attorney General. They weren't heard by Liberal MPs in the Senate. They were heard by my friend from Nanaimo Ladysmith, who did bring forward some important amendments at the committee, which we supported, which we thought moved in the right direction to provide greater certainty to protect vulnerable persons. But those amendments were rejected by the Liberals across the way. So I hope in the face of all of that, the Senate will do better than the process that we have had in this House.
Resuming debate, the honourable member for Denete, Mississippi, Churchill River.
Thank you, Madam Speaker. You're right, that is a mouthful. I knew that entering federal politics would mean participating in many very important debates in this House. But speaking on matters of life and death brings that to a whole new level. As someone who comes from a small city in northern Saskatchewan and now has the privilege of representing the entire northern 52% of Saskatchewan, I hope to bring somewhat of a unique perspective to this debate. As we stand here in Ottawa and debate this legislation, there are several communities in my riding that are dealing with very high suicide rates. And in the case of Makwasagaikan First Nation, a community of about 1,000 people, they have over 100 community members currently on suicide watch. There are long-term care home and palliative care shortages across the country, but this is even more true in northern and remote communities. We need to consider what message we as legislators are sending to these vulnerable communities when we are going way beyond that of the Supreme Court of Canada Carter's decision by removing safeguards that would protect Canada's most vulnerable. The government is now seeking to play an active role rather than a passive role in the end of Canadians' lives. I find this extremely troubling, and I implore my colleagues on the other side of the aisle to allow the necessary time to consider the truly long-term ramifications of this legislation and to listen to all of the voices that are speaking out on it. This does not need to be done with unnecessary hurry. Madam Speaker, there are two main topics that I want to address when it comes to Bill C-7. Number one, the impact that passing this legislation will have on Indigenous communities, and number two, the importance of safeguards to protect Canada's most vulnerable. Madam Speaker, I do not stand here pretending for one moment to speak on behalf of Indigenous people in Canada. However, over my lifetime, I have developed relationships with many First Nation and Métis people in northern Saskatchewan, and over the year have discussed this issue of assisted dying with many of them. There's a great worry among leadership of these nations that legitimizing suicide in our culture will have grave impacts on their younger generations, as well as those who are nearing the end of their lives. These concerns were actually raised during the debate in the last Parliament by Liberal MP Robert Falcon Ouellette during his speech on what was then C-14. And I'm going to quote, "In the Indigenous worldview, everything is interconnected. It is holistic, meaning that when a change is made in one place, the impact will be felt elsewhere, and the two cannot be separated. In the Western worldview, often we compartmentalize things. We believe that we can play, that we can control certain situations, that we can affect change here and not see change in other places. Above all, we have come to believe ourselves able to predict and control all, to control the future. This does not mean, though, that we should not take action. The impact of this bill on people in Toronto may be very different than on the people of Nunavik or Attawapiskat. Our role as parliamentarians is to place ourselves in the moccasins of others, to place ourselves outside of our own experiences, to see the world through another cosmology and other worldview, and to see the impact that our decisions may have on others. We are making profound changes in concepts surrounding life, which cannot be undone in the future. In the Indigenous tradition and philosophy, we are required to think 7 generations into the future. If I am wrong, and there is no connection between Attawapiskat and physician-assisted dying or suicide, if the average person does not see a connection and communities do not see a greater stress, then I will gladly say I was wrong. But if there is an impact which is caused by the valorization of suicide, then what?" End quote. Madam Speaker, Mr. Ouellette then goes on to share a very personal and difficult story of hardship he and his siblings faced as young children, leading him to nearly take his own life. He goes on to say this, quote again, "If in my life I had seen or I had known that my grandmother had somehow used physician-assisted dying or physician-assisted suicide, or others in my family had completed the irreparable act, then it would have made it much more difficult for me to continue. We might not think the impact will be there, but we do not know. We assume we know these things. We are deciding the future of a few for the end of a few." Speaking to CBC during the debate on C-14, Senator Murray Sinclair shared some similar views, and I quote again, "From the Indigenous perspective, ending one's own life was not encouraged. In fact, it was discouraged. And there are teaching in my community, Ojibwe teachings, around whether or not you will be able to travel to the spirit world in the proper way, or a ceremony could be done for you if you make the decision to end your life without reason." End quote. In speaking to his colleagues in the Senate, Senator Sinclair, speaking about younger people, said, quote, "It will not take much for a young, vulnerable person to believe that their situation is intolerable to them, and therefore we need to ensure the message we send to the Canadian public with this legislation is that it is not right that it's not a right that should be easily exercised or that we are embracing." Madam Speaker, First Nations people in northern Saskatchewan, Mr. Ouellette from Manitoba, and Senator Murray Sinclair are not alone. Tyler White, Chief Executive Officer for the Siksika Health Services, as well as Dr. Thomas Fung, a lead physician of the same nation, are sounding alarms in response to this legislation. During an interview with CTV, Mr. White said, "The expansion of MAID sends a contradictory message to our peoples that some individuals should receive suicide prevention while others suicide assistance." In a letter shared with my office, Mr. White and Dr. Fung told a story about a patient who suffers from a lung disease that causes him to become easily short of breath even when doing simple household tasks. This patient uses a walker, but cannot walk for more than a couple of minutes without gasping for breath. While the man's condition is incurable, he could certainly have an improved quality of life if he had access to funding to support his home oxygen, but he was just out of the range of being approved for funding. Dr. Fung concluded by writing that under C7, this patient would qualify for assisted death, when it should be clear to all that there are other ways to relieve this man's suffering to improve his quality of life. Patients like Dr. Fung's deserve better. In a country as developed and resourceful as Canada, we cannot allow ourselves to abandon people like this. Our healthcare system is the pride of many Canadians, but that is because of universality of access to life-saving treatments, not the universal admissibility to a physician-administered death. Madam Speaker, secondly, I want to talk for a minute about the safeguards for vulnerable Canadians and how this legislation fails in providing these. I am not a lawyer, Madam Speaker, but thankfully the Leader of the Opposition is, and we're probably all glad that that's the case, that I'm not the lawyer. I was glad to be in the House during his speech on C7 this morning. Leaning on his legal expertise, allow me to repeat some of what he said regarding previous litigation surrounding assisted death, because it struck me as very important. And I quote again, all of them talked about the role of the state in protecting the decisionally vulnerable, as they were called at the time, people who could be pushed into end-of-life treatment as they feel they are a burden. This has been talked about since the 1990s, and this Attorney General was removing the safeguards from our regime. Every ounce of case law on this issue of assisted dying, euthanasia, or assisted suicide talks about protecting those vulnerable. Speaking on protecting the vulnerable, the Leader said this morning, all major disability groups in Canada agree with the compassionate and reasonable position being presented by my Conservative colleagues. I am very proud of the advocacy we have shown. We have also been joined by legal scholars, Indigenous leaders, and people working with people with mental health issues. Madam Speaker, I wholeheartedly echo the comments made by my honourable friend this morning and repeat the need for this government to step back from their repealing of the provisions that would ensure a 10-day waiting period as well as 2 witnesses. As a matter of fact, Madam Speaker, regarding the 10-day waiting period, a senior employee of the AFN shared on Twitter recently, this 10-day period literally saved a member of my family's life. MAID must be accessible, but also account for clear and thoughtful consent. The Liberals should rethink this. Madam Speaker, in closing, I want to completely acknowledge that both sides of this debate are coming from a point of view of compassion. I understand that the government has approached the drafting of this legislation in good faith, but the reality is they have fallen short in their duty to Canadians. That is why I will be voting against this dangerous bill, and I hope that my colleagues on the other side of the aisle will reconsider their support for it as well. Thank you, Madam Speaker.
Questions and comments. Questions et commentaires. The Honourable Member for Barrie-Innisfil.
Thank you, Madam Speaker, and I want to thank my honourable colleague for talking about, as he referred to at the beginning of his speech, a life and death issue. And oftentimes, as we sit in this place, we look to these issues with a degree of magnitude that they deserve. As this went through committee, there were some challenges, and I know that there were some reasonable amendments that were put forward by our Conservative caucus. I'm wondering if he could speak to those reasonable amendments and just how important they are to determining this piece of legislation. Thank you, Madam Speaker.
The Honourable Member for Denette Mississippi Churchill River.
Thank you, Madam Speaker. I want to thank my honourable colleague for the question. I agree there were some reasonable amendments proposed, and the one that we would like to see really emphasize back is this 10-day reflection period that I talked about. And I would like to just share a really personal story about this that I think would emphasize that point to the House. Back in 2014 in my small city in Meadow Lake, Saskatchewan, there was a young lady had graduated from high school, a tremendous athlete, had just finished her nursing degree, and I think it was one Tuesday night she was in a terrible car accident and ended up a paraplegic at the time. This was a family friend of mine, and I had the, I don't know if it was the privilege or the horror of being in the hospital with her family that night and in the following days. And I'll guarantee you that young lady would have chose death over life at that point if she had that opportunity. Now this young lady, several years later, is a Paralympic athlete. She's got back to doing incredible things with her life. She's been all over the world in athletics, and I could go on and talk for a long time, but I'm going to say just this one quote that came from her dad. He said, one of the really cool things we are slowly catching up on is that members of this special group of people don't see themselves constrained in any way. These people with disabilities do not see that when they get past the hurdle of the original burden of in this case, this young lady's accident.
Questions and comments. The Honourable Member for Yorkton Melville.
Thank you, Madam Speaker, and I really appreciated the heartfelt speech from my colleague from Saskatchewan. We know that physicians are also very concerned about this bill with conscious protections for medical practitioners. And right from the beginning with C14, that was something that was really stressed that should be part of this, and yet the Liberal government has totally ignored this and punted it down to the offices, the provinces, where now I believe that it's impacting palliative care, it's impacting people's perspectives of serving in the medical profession, just like some comments from him in that regard.
Member for Denison, Mississippi, Churchill River.
Thank you, Madam Speaker. I want to thank my colleague from Saskatchewan for the question. I fully agree, and it's probably the second most common concern I've heard from people on this is this idea of conscience rights, and talking to people that is a huge issue for, where they don't believe that their personal belief system, that their faith, that their life journeys should be impacted by some imposition of government on that. That's probably the second most common thing I've heard. But I want to just share one other quick comment here, if I have a moment, Madam Speaker, is that, back in the debate around this in the last Parliament, the former Attorney General and Justice Minister made the comment that preventing the normalization of suicide to protect vulnerable persons who are disproportionately at risk of inducement to suicide. She spoke of that repeatedly. And she went on, and again, I quote, in defending, this is a quote from an article, not her quote, sorry, I'll be clear. In defending it before the Senate, the former Justice Minister warned that expanding the eligibility criteria to include anyone who is suffering intolerably would send the wrong message that society feels it is appropriate to address suffering in life by choosing death. The message may encourage some who are in crisis and already considering suicide to act. I really don't think we should be putting our medical professionals in that place.
Resuming debate, the honourable member for Prince George, Peace River, Northern Rockies.
Thank you, Madam Speaker, and I just feel honored tonight to be speaking to this with so many great speeches by my Conservative colleagues of concern about our citizens and those especially in the disabled community and the senior community. Oops. And, sorry, Madam Speaker, am I still on? I'm good. Okay. Madam Speaker, I speak today deeply concerned about Bill C-7 and the changes being proposed in the legislation. I know this is an emotional issue for everyone, and it is an important discussion that we are having this evening. Any legislation that is introduced in Parliament requires a thorough review, but this is especially true for bills that are literally matters of life and death. It is my firm belief that the federal government should have appealed to the Supreme Court so that we would get certainty on the framework within which Parliament can legislate. Unfortunately, that did not happen. And so here we are with a rush bill that puts the lives of our most vulnerable at risk. Make no mistake, as a Christian, I am firmly against the use of medically assisted dying. That said, I understand that the courts have made a ruling and the legislation is required. However, we must ensure that this type of legislation includes safeguards for the most vulnerable in our society, as well as for the conscience rights of physicians and health professionals. That is why we Conservatives introduced a number of reasonable amendments to reinstate protections that the Liberal government has simply removed. And it's troubling. These include reinstating a 10-day reflection period when death is reasonably foreseeable, extending the reflection period when death is not reasonably foreseeable, protecting vulnerable patients by requiring that the patient to be the one who first requests information on medical assistance in dying, and protecting the conscience rights for healthcare professionals. It's unfortunate that these amendments have been rejected by the government. I'm deeply concerned that this legislation will allow assisted death for Canadians who are not dying by removing the requirement that a person's death must be reasonably foreseeable in order to be eligible for assisted suicide and euthanasia. As the son, as I've already said, of two elderly Canadians, my dad is 86 and my mom is 76, I'm very concerned about what this would mean for our nation's seniors and the positions they may be put in when trying to access health care. Will they be placed in a position where they will have to decide between care and ending their lives due to outside pressure? As this bill expands medically assisted dying further, it risks that palliative care will suffer, and as a result, patients will view medically assisted dying as a better option. I know Canadians share my concerns. It must be said that every national disability organization in Canada opposes this legislation. Or as Krista Carr, Executive Vice President of Inclusion Canada, said at committee, Bill C-7 is our worst nightmare, close quote. These organizations caution that removing the end-of-life requirement discriminates against those who are disabled and puts their lives at even greater risk. Again, quoting Ms. Carr, the end-of-life requirement was the only safeguard whereby disability was not the sole criterion. By having the disability itself under Bill C-7 as the justification for the termination of life, the very essence of the Charter of Rights and Freedoms would be shattered. Discrimination on the basis of disability would once again be entrenched in Canadian law. It is shameful that the Liberal government's rush to pass this bill before Christmas, they continue to neglect and to address legitimate concerns being raised by persons with disabilities. I'm also deeply concerned about the limited protections for the conscience rights of our medical professionals. While some doctors and healthcare workers may have been comfortable with medical-assisted dying under Bill C-14, the continued expansion may cause them to rethink their participation. Others who have always been against medically assisted dying are already feeling the pressure to go against what they believe. As the Physicians Alliance Against Euthanasia said in a news release in this just last March, the pressure has been intense for many physicians, especially amongst palliative specialists, some leaving even before this latest development. Descriptions were made of toxic practice, work environments, and fear of discipline by medical regulators. Members in the Justice Committee have heard firsthand from disability advocates vehemently opposed to Bill C-7 and its rapid expansion of medical assistance in dying, who argue it amounts to a deadly form of discrimination, making it easier for persons with disabilities to die than live. It's shameful. Healthcare professionals also have spoken out, concerned not only about their conscience rights, but also about the speed at which this government is trying to pass Bill C-7. To quote Adam Taylor about the lack of consultation on this legislation at committee, quote, as an emergency and family doctor, I know the importance of consultation along with the day-to-day experiences and the sufferings of Canadians, which cannot be ignored. I'm terrifically concerned about this, close quote. Yet here we are, the Liberals are continuing to push through the bill, ignoring concerns of those who will be directly affected by these changes. And again, it's shameful. As the Evangelical Fellowship of Canada said in their submission to the House of Commons Standing Committee on Justice and Human Rights, we must carefully consider the impact of Bill C-7 and the concerns being raised by many Canadians, particularly Canadians with disabilities. This legislation is too important to be rushed. The legislation, not to mention human lives this bill will negatively affect, are too important to be rushed. Thank you, Mr. Speaker.
The honourable member for Prince George, Peace River, Northern Rockies will have 4 minutes remaining in his remarks for when the House next returns to debate on the question. It being 5:30 p.m., the House will now proceed to the consideration of private members' business as listed on today's order paper. Orders of the day. Order du jour.
Private members' business. Consideration of motion M36 on Emancipation Day, standing in the name of Mr. Johari.
Just one moment. Just hold that thought for a moment. Mr. Johari, seconded by Mr. Fergus, moves that the House recognize that A, the British Parliament abolished slavery in the British Empire as of August 1st, 1834. B, slavery existed in British North America prior to its abolition in 1834. C, que les abolitionnistes.
C, that the abolitionists and others who struggled against slavery, including those who arrived in Upper and Lower Canada by the Underground Railroad, have historically celebrated August 1st as Emancipation Day. D, the Government of Canada announced on January 30th, 2018, that it would officially recognize the United Nations International Decade for people of African descent to highlight the important contributions that people of African descent have made to Canadian society and to provide a platform for confronting anti-Black racism.
The heritage of Canada's people of African descent and the contributions they have made and continue to make to Canada, and that, in the opinion of the House, the government should designate August 1st of every year as Emancipation Day in Canada. Debate. The Honourable Member for Richmond Hill.
Thank you, colleagues. Thank you, Mr. Speaker. Mr. Speaker, I'm pleased to rise today in the House to speak to my motion M36, which would have the House formally recognize August 1st as Emancipation Day, and in turn maintain our government's commitment to highlight the contributions people of African descent have made to Canadian society and continue to combat anti-Black racism today. This motion builds on the incredible work done by Senator Wanda Thomas Bernard with Bill S-255 in the last session of the Parliament. Motion 36 on Emancipation Day, Mr. Speaker, as you mentioned, when passed, would have Parliament officially recognize the abolition of slavery on August 1st, 1834 in the British Empire, including British North America, what we know as present-day Canada. The role of British colonies, including our nation, in participating in the transatlantic slave trade. The abolitionists who laid the groundwork for change and defied the norms of the time. The history of Emancipation Day, including the many untold stories and unsung achievements of Black Canadians in Canadian society. And finally, to address anti-Black racism in the context of United Nations International Decade for People of African Descent and for the purpose of achieving our goal of justice, inclusive, and equal society. Mr. Speaker, in 1807, the British Parliament voted to end transatlantic slave trade. And on August 1st, 1834, chattel slavery was abolished across the British Empire and all its Commonwealth territories, including Canada. This was a landmark victory for Black community across British Empire, and especially for Black Canadians who organized, rallied, and fought for this legislation. The day has come once of celebration amongst Black Canadians who expressed their joy at being able to live freely and independently, though it also stood as an important occasion to reflect on the struggle it took to achieve that freedom. Emancipation Day allows for Canadians of African and Caribbean descent to connect through shared experiences and gives an opportunity to pass on the stories of their enslaved ancestors whose names and experiences would otherwise not be recounted or honored in any history book of that time. While recognition of Emancipation Day is at the heart of this motion, one of the primary pillars in education and awareness should be highlighted. Mr. Speaker, this summer, in the weeks leading up to Emancipation Day, I had the opportunity to consult with various advocacy groups regarding this motion. I want to highlight an Emancipation Day panel I attended with notable Black scholars in Canada, including Honorable Jean Augustine, the first female Black Canadian Member of Parliament. One of the key highlights I took from this event was the importance of education. This motion's primary purpose is to continue to educate our community on Canada's history and culture, as well as shed light on part of our history that we have not always acknowledged. It also presents us with a unique opportunity to learn about important Canadian Black historical figures, community leaders, and trailblazers. Mr. Speaker, the history of Emancipation Day goes beyond the abolition of slave trade. It should highlight the work of numerous Black scholars, activists, and change makers. We specifically want to acknowledge the historic event like the Underground Railroad, where tens of thousands of African Canadians, African Americans bravely escaped slavery in the South and sought refuge in Canada from 1850 to 1860. And we want to recognize influential Black Canadian abolitionists and cultural leaders like Mary Ann Shadd, the first female newspaper publisher in Canada and the first Black female publisher in North America. Shadd founded and ran the Provincial Freedom from 1853 to 1860 and was a fierce anti-slavery activist. She used her platform to showcase Black culture and explore political and human rights issues, such as abolition, women's rights, and the right to vote. She later went on to establish a non-segregated school in the town of Windsor. Or we should probably recognize Viola Desmond, a Nova Scotian businesswoman who was arrested in 1946 for sitting in whites-only section of a theater. She was later charged with tax fraud. This incident became a catalyst for change as she refused to succumb to the racist policies of her time. Her case sparked the civil rights movement in Nova Scotia and inspired a generation of Black Nova Scotians and Canadians to fight for justice and human rights. We must also acknowledge the Black Canadians who played a pivotal role in Canada's effort during World War I. Despite facing discrimination and barrier to entry into the armed forces, a significant group of Black men dedicated themselves to the war effort and served in multiple combat and support roles. For example, we should honor the number 2 Construction Battalion, an all-Black military unit that dug trenches, defused landmines, stocked ammunition, and removed wounded soldiers from the battlefield. The contribution of the number 2 Battalion were not recognized until much later at the war. In the words of Senator Bernard, Emancipation Day served as an instrument to pass on the history and the memory of those who went before them, and as a beacon for taking up the responsibility to carry on from where their ancestor left off. Mr. Speaker, since immigrating to Canada, I've been lucky to live in many diverse and multicultural ridings like Richmond Hill. However, I have seen and experienced the effect of racism, prejudice, and discrimination in my own daily life. I know that I can never know the struggle of Black Canadians in our society today, but I believe it is our duty as allies to emphasize and to continue to educate ourselves on issues that continue to impact Black communities across the world and in our country, Canada. Throughout the month of July, my office created a social media campaign entitled We Remember. This online campaign highlighted the stories of Black Canadians throughout history who have made important contribution to our society. Canadians whose stories were not told in our history books and our school classrooms. Mr. Speaker, my hope is that this motion be the first step in acknowledging the gaps in our education system. It can encourage a greater focus on Black history and the inclusion of Black Canadian stories in history and social studies classes. Emancipation Day today is a time for all Canadians to look inward and unlearn the biases and behaviors associated with the history of slavery that have resulted in the underrepresentation of Black Canadians in history books, school curriculums, in elected positions, and public service. It also serves as an opportunity for us to dismantle the remnants of institutionalized racism, discrimination, and the overrepresentation of Black Canadians in correctional facilities. Recognizing Emancipation Day gives Canadians the opportunity to confront this reality and to advocate for greater diversity, inclusion, and opportunity. Mr. Speaker, I want to acknowledge the support that this motion has received from my colleague, Senator Wanda Thomas Bernard. Senator Bernard's guidance has been essential in allowing me to approach this motion with the care and the nuance it requires. Senator Bernard has been advocating extensively for this cause and continues to be a fierce advocate for Black communities across our country. I also want to thank the member from Hull Aylmer, the chair of the Parliamentary Black Caucus, and members of all party Parliamentary Black Caucus for their support on this cause. I want to commend the valuable insight from community voices like Rosemary Sadler from Royal Commonwealth Society, the Ontario Black History Society, and the Canadian Association of Social Workers. Mr. Speaker, their guidance and assistance were key to bringing visibility to this issue. In the honor of Emancipation Day and the United Nations International Decade for People of African Descent, I'm calling all Canadians to come together to confront our nation's history with racism, as well as emancipation, so that we can achieve better outcomes and representation for people who are marginalized, a label which disproportionately includes Black Canadians, as well as First Nation, Métis, and Inuit people. Mr. Speaker, as for myself, I continue to advocate for a more inclusive, culturally aware, and diverse society in which Emancipation Day and its history are represented and embodied in our schools and our institutions. In closing, Mr. Speaker, it is my sincere hope that all Canadians, and especially the members of this House, will join me in exploring our nation's history, and next August take part in their community's Emancipation Day celebration. Please support M36. Thank you, Mr. Speaker.
Question commentaire. The honourable member for Hamilton Centre.
Thank you very much, Mr. Speaker, and what indeed a historic moment it is. I want to begin by thanking the honourable member from Richmond Hill for lifting up the important work of the always honourable Senator Wanda Bernard Thomas. And we heard in his remarks that this is indeed a first step, a symbolic one, but a first step in dismantling anti-Black racism. So through you, Mr. Speaker, to the honourable member, what would he prioritise with the opportunity that his government has on second steps in order to dismantle anti-Black racism?
Member for Richmond Hill.
Thank you, Mr. Chair, and through you to the honourable member. It's always a pleasure to receive questions from the honourable member. We have the opportunity to work together in OGO committee. But most importantly today, as the honourable member mentioned, this is the first step. This is the first step in a journey. And this journey is no different than any other journeys that our country is embarking on. I believe acknowledgement is the first step, and I'm hoping that when passed, this acknowledgement is behind us. Now, as I said, it is upon us and upon the government to make sure that we take the next step, and the next steps could be investment and generating awareness in other programs, whether social program or educational programs, that would be able to support this motion. Thank you.
Question commentaire. La députée de Lac-Saint-Jean.
The member for Lac-Saint-Jean. Thank you, Mr. Speaker. I listened to my honourable colleague's speech closely, and I would like to congratulate him on this motion. I think that there's consensus about the motion. And I was frankly touched by the personal experiences that he shared where he himself faced racism. He's obviously very much aware of the cause, and my question is very simple. Could our honourable colleague tell us what, according to him, the benefits of this motion would be if it were adopted? Member for Richmond Hill.
Thank you, Mr. Speaker, and through you to the Honourable, thank you for the question. I think the answer is obvious. I think the first step in any journey of reconciliation and acknowledgement is the acknowledgement and acceptance. And the benefit is it is now behind us, and we can take the next step. And as I said, my focus remains on filling one of the gaps that I see, and those gaps are about education and making sure that the depth of the contribution of the African Canadians, especially to our country, is properly reflected. And it also brings an understanding within our country and makes our country much safer and allows for minorities, visible minorities, to grow and find their rightful place in this community.
Questions and comments? The Honourable Member for Saanich Gulf Islands.
Thank you, Mr. Speaker. It's an honor to rise just to ask a question of the honourable member and thank him for bringing this motion forward and put on the record that the Green Party of Canada supports unequivocally recognition of Emancipation Day. It's recognized in many countries around the world, and I'm particularly pleased to note our historic breakthrough this year that our new leader, Annamie Paul, is the first Black woman leader of any federal political party in Canada. And I ask the honourable member what more we can do as individual members of Parliament. We know that private members' bills and motions can take their time to wend their way through the House. How do we make sure this becomes law before the end of this Parliament?
Honourable Member for Richmond Hill.
Mr. Speaker, through you to the Honourable Member, thank you very much, and it's good to hear that we're getting unanimous support across the House for this motion. It talks about the significance of this motion, and what we can do as individuals is make sure that we become the champion for the cause of anti-racism, and also reach out to the organization that there are in our community, reach out to those who are vulnerable and are struggling, and support them. And as well as what we could do in the House, we could make sure that we vote in support of the motion, pass the second reading. Thank you, Mr. Speaker.
Nous avons le temps pour un bref.
We have time for one brief question or comment.
Yes, thank you, Mr. Speaker. I just wanted to compliment my colleague for the fantastic work he's already accomplished by getting the resolution to the floor. And if he can just add some further thought in terms of just how important it is for education to be a part of this going forward.
Member for Richmond Hill.
Thank you, Mr. Speaker, and thanks to my colleagues for the question. I believe when it becomes part of our education curriculum, then it's actually documented, it's in the books, and it could be used as a base for us to be able to pass that knowledge in a very structured way. And to that effect, this is why I picked education and awareness as what I believe the next step for us in this journey should be. Thank you.
Resuming debate, the Honourable Member for Bruce Grey, Owen Sound.
Thank you, Mr. Speaker. I'm going to start my remarks off a little bit maybe different. I'm going to try to tell a little bit of a story. Picture yourself as my 7-year-old daughter. You live in the United States, southern United States. It's in the 1830s. Life is not good. And you make your way. You utilize what was then known as the Underground Railway. You make your way up. It's not a simple journey where you just grab a ticket, hop on the train, and off you go. It's done at night. It's done quite frequently by foot. You need to use code words. You need to travel constantly in fear that you may be recaptured and put back into slavery. Eventually, though, you make it to the Canadian border, or Upper Canada, as it was known then, and you cross that border. And you feel that inspiration of hope. You know you're somewhere safer. You don't stop quite yet. You keep on going. You travel to the most northern terminal of the Underground Railway, the village of Sydenham, now known as Owen Sound, which I'm proud to say is in my riding of Bruce Grey, Owen Sound. The only reason my daughter's having to make that escape is because she happens to be of background she's of color. It's sad, but I'm so glad that Canada has such rich history, and my riding has such rich history in abolishing slavery. That Underground Railway helped free 30 to 40,000 slaves during its time of operations. It offered that beacon of hope. It gave people of black descent an opportunity to settle, raise their families, and find work. And again, as I said, Mr. Speaker, it makes me so proud to come from the right. I want to thank the member from Richmond Hill for bringing forth this motion, M36, and continue, actually not what Senator Bernard started, but actually what the Honourable Deepak O'Brien brought forward in this House in 1999, 21 years ago, as a private member's bill, Bill C-282. Then it was brought forward a couple years ago by the good senator within the Senate. She tried to get it passed, but unfortunately the bill was not passed before Parliament broke. But fortunately, the member from Richmond Hill has brought it forward, and I do agree with his earlier comments, Mr. Speaker. I'm confident this motion will pass with unanimous consent in the House when we get there. My riding has some unique contributions, but it speaks to the motion as well of what people of black or African descent have made to this great country. In the southernmost part of my riding, I have the town of Priceville. I didn't know until I was actually preparing for this speech that it's named after Colonel Price. Colonel Price happened to be of black descent, something I didn't know. And it just speaks to, again, to the rich contributions black people have made to Canada throughout our history. As well, my own riding, a former MP, you got to go back to 1993 to 2004, was Ovid Jackson. Ovid Jackson made national news at the time because I come from a riding which is not as ethnically diverse as some of our ridings in our more urban centers. But Ovid was elected as a black man. And I think that speaks not only to the constituents of my great riding and how fair and balanced they are, but to what a nice and intelligent and competent individual that Ovid himself was. Fortunately, in my viewpoint, he ran for the wrong party, but we'll deal with that on another day. But what's unique, too, about my riding, and specifically Owen Sound, or the village of Sydenham as it was known then, is the Owen Sound Emancipation Festival. It's the longest ongoing festival in North America. It started in 1862. I say again, Mr. Speaker, 1862, 5 years before Canada was officially a country. The Owen Sound, or village of Sydenham, was recognizing the importance of the abolishment of the British Commonwealth Slavery Abolition Act of 1833, which took effect the 1st of August, 1834. And they started with a picnic back then with the early settlers, and they've been celebrating it nonstop ever since. That act itself freed more than 800,000 slaves across the British colonies. And that festival that kept going, in 2004, there was a commemorative cairn that I challenge any of the members of Parliament, if you're ever up in my riding, come visit it. It's in Harrison Park, right in the downtown part of Owen Sound. And it's a beautiful cairn that allows people of all backgrounds to go and visit, meditate for a while, think about the importance and the contributions that black people have made to our country, and remember the challenges that they faced in our history. And it recognizes those early settlers to my area, the Millers, the Johnsons, the Scotts, the Greens, and the Courtneys. And their descendants come back. They're not just in the area. They actually come back from all across our great country, but I dare say across the world every year to be part of that annual celebration, which is actually turned into a 3-day event. The unique connection I have to Blaine Courtney, who's a past chair of the Owen Sound Emancipation Festival, he was actually my track and field coach as a young teenager. And, Blaine and I, we got along great. He never stopped pushing me all the time, to be something, to be the best that I could be. And I actually think I owe him and all my coaches a lot of gratitude for making me into the person that I am today. I think they were instrumental in helping me be successful in my military career, and hopefully it will lead to success here in my political career. Just a couple years ago, or a year and a half ago, I guess now, the 2019 festival, my daughter and I were in attendance, and I was so proud as she was selected by the town crier to be part of the festival. She got to ring the bell. She actually rang the bell with the granddaughters of Senator Bernard, and it was a unique experience. Now, the one thing that I guess maybe I was a little bit envious of, my daughter made the front page of the local paper, the Owen Sound Sun-Times, which is the biggest paper in my riding, and here at the same time I'd just been elected as the Conservative candidate just a couple months prior, and here my daughter's making the front page of the newspaper, and I'm not mentioned at all. But I mean, she maybe has a future in politics if she wants to. This year, of course, was slightly different. 2020 was done virtually, but I dare say it was impressive to see everybody still gather together and be instrumental as part of that festival. A key part as well in our riding is the Grey Roots Museum. That museum is a wealth of knowledge, not only to educate people, which this act or this motion speaks to, the importance of it, and I really think that is the root advantage of bringing this motion forward, is to make sure we never forget and at the same time that we educate it. Mr. Speaker, I've traveled the world in my military career. I've been in countries all over the world, some of the worst parts of the world. But one thing I've always said is I've yet to meet a single person in any other nation around the world at that sort of grassroots level that's any different than the average Canadian. Most people just want to live in peace, have their children grow up healthy, well-fed, and an opportunity to have more. I've served with people of all descents and backgrounds. I mean, one of my best friends, or I wouldn't say best friends, the best friend I made at basic training out in Chilliwack, unfortunately, I can't remember his last name, Derek. Him and I were sort of like two peas in the pod. He was from Montreal. We did basic training together in Chilliwack, sort of tried to stay out of trouble. Unfortunately, he didn't make it through basic training, and I haven't seen him since. And then I got to the Royal Military College. I served with, had great to make friends like Scott Morrow and Austin Douglas, Austin that I served with in the Royal Canadian Regiment as well. And then Master Corporal Raymond Farmer, who I'll never forget. I don't know where Raymond is now, but he was sort of like my close protection bodyguard in my first tour in Afghanistan. All these gentlemen, Mr. Speaker, are of people of black descent. I can't imagine living in any other country in the world other than Canada. We're so fortunate, and I'm so glad that we have played such an instrumental part in helping slaves escape from the United States back in the 1800s, and I'm so glad to see this motion being brought forward by the member of Richmond Hill. It's a way to recognize the contributions the people of African descent have made to this great country. It's a way to educate and recognize what they're still contributing to this day. This is the Canada I want my daughter to grow up and be proud of. Thank you, Mr. Speaker.
Reprise de débat.
Resuming debate, the Honourable Member for Laurentides-Labelle. Thank you, Mr. Speaker. First of all, I would like to thank the Honourable colleague for his speech and for the friendship that we can clearly confirm today. So, of course, I will talk to motion M36 on Emancipation Day and on what my colleague mentioned, the question of education and awareness. I will take the opportunity to go back to the past because it's important to know where we come from to figure out where we're going. A few historic facts. First of all, the Canadian Encyclopedia has an article about abolishing slavery. It starts with a decree that abolishes slavery in British colonies for the development of work of emancipated slaves and to compensate those who used these slaves in the past. I have new glasses. I'm going to take them off, Mr. Speaker. It's late. And we look forward to recharging our batteries. This was on August 28, 1833, and it came into effect in 1834. This act abolishes slavery in most British colonies and frees the 800,000 African slaves that were in the Caribbean, in Africa, in South Africa, and in Canada. But the colony of Lower Canada, Quebec, Nova Scotia, and New Brunswick, and the abolitionist efforts in those areas continued to fail. It's only in 1893 that the MP, Pierre-Louis Panet, tabled a bill at the Assemblée nationale to abolish slavery in Lower Canada, but this bill is punted incessantly to the future and is therefore never voted upon. This ends up in individual court cases raised for the first time near the end of the 18th century. This shakes slavery to its very core. An important case happens in 1798 when Charlotte, a slave, is arrested in Montreal and refuses to go back to her owner. She is brought before a justice of the King's Bench Court, James Monk, who is sympathetic to the abolitionist movement. He had her freed because of a judicial formality. Indeed, pursuant to British statutes, slaves cannot be detained or can only be detained in correctional houses and not in common prisons. As there were no correctional houses in Montreal, Charlotte could not be detained. Her and another slave, Judith, are therefore freed. The judgment states that this interpretation of the law will be used for all similar cases. Nouvelle-France was not sheltered from slavery. Marcel Trudel, the great historian, gave us the information we have today on slavery in Quebec. He mentioned a total of 4,185 from the 17th century to 1834. Of those, 3/4 were indigenous slaves. Slavery had therefore a different facet, a different proportion. The proportion of the Pani, the indigenous slaves, was higher than that of Afro-descendant slaves. In the 1700s, it's a lot of dates, but in 1759, more specifically, there were 1,100 black slaves in Canada near the end of the 7-Year War. That's shocking, Mr. Speaker. Of course, we would be remiss to not mention Marie-Joseph Angélique, a young woman born in 1710, who was hanged in 1834. In the house, in the book, Ils ont fait l'Amérique, they told the story of Marie-Joseph Angélique, and many people read that book. Her story is the first case of resistance to slavery in Quebec and in Canada. Of course, in 2020, we agree that slavery is an abhorrent practice. Unfortunately, that has not always been our opinion over history. It's only in the 19th century that slavery was abolished bit by bit. The Bloc Québécois is for this motion, but it would have perhaps been judicious for this motion to also highlight the slaves' participation in abolishing slavery. What does this mean? It means that historical actors, the oppressed in this case, had the opportunity to act. transforming the world, influencing the world, rather than just being subject to other people's decisions. This motion gives an omnipotent power to the British Parliament when it comes to abolishing slavery, as if the British Parliament gave a present to everyone, a present to slaves from all four corners of the empire. The historical truth of the matter is far more nuanced. We must remember in which context slavery was abolished. This was just the end of a long historical process in which slaves themselves took great part. Our history only talks about liberal abolitionists that put an end to this unjust system. But in a recent book called Plus jamais esclaves, it talks about emancipation from A to Z. The Russian historian Alin Helk says that slaves took part in this abolition process. They were the very forgers of their own freedom. To support their position, this historian writes about history, analyzing different revolts and emancipation strategies adopted by slaves in the Americas. How were slaves agents of their own liberation? Well, through marronage, legal enfranchisement, military revolt, and revolt in general. Let us not forget this. This motion also comes in the wake of the International Decade of African Descendants. This term is for awareness and justice. By declaring this decade, this House of Commons will distinguish itself as being at the forefront of recognizing justice and recognizing the development of people of African descendancy as people who have rights that must be protected and promoted. We must say it very clearly here in this House, in our democratic institutions. That is why, Mr. Speaker, reading this motion that talks of historical fact, that comes into the wake of this international decade, the contribution of these African descendants commemorates the existence. This motion would commemorate abolishing slavery. The Bloc Québécois will vote for this motion. I would like to take a couple of seconds to commend our black mayor in my riding, Laurenti de Labelle, who was in power for 14 years. There were only 2 in the whole of Quebec. So I'd like to commend her for her 14 years, Miss Michèle Adrien. Inaudible for the interpreter. Ulrich Cherubin, of course, in Amos, in my honourable colleague's riding. To finish, your history is our history. Thank you, Mr. Speaker.
Resuming debate, the honourable member for Hamilton Centre.
Mr. Speaker, I have had the privilege of rising in this House on many occasions, but perhaps none with the deepest privilege for which I rise here today. I should begin by noting that 10 minutes is not nearly enough to capture the collective lives and times of descendants of the African slave trade, nor is it mine. I do want to restate the gratitude that I have to the honourable member from Richmond Hill, who with passion and justice and rightful recognition has reintroduced this critically important motion in lifting up the work of the always honourable Senator Dr. Wanda Bernard Thomas, who indeed would rank among the most learned and exalted members of Canadians of African descent. Mr. Speaker, like many black and racialized Canadians, I am often asked the question, where are you from? And when I share with them that I am Canadian, the next answer for them, the next question
that they ask is, but what about your parents? And I tell them, I'm Canadian. They're like, what about your grandparents? And I share with them, I'm Canadian. Mr. Speaker, my people go back here 6 generations. And as the rules of the House would allow, in fact, in the previous speaker's comment, he inadvertently gave me a shout out when recognizing the founding families and the settlements that have become Owen Sound. Indeed, I am my ancestors' wildest dreams. Some of my earliest memories of family would come from our annual trip to Owen Sound, to the Harrison Park that was shared by the honourable member from that riding. And this would be an extended family picnic, and this would be a place where I would be rooted in the celebration of Emancipation Day. And yes, this commemorates a history that goes back to 1862, Mr. Speaker, 1862, before the Confederation of this country. I am here in the spirit of the Black Moses, Harriet Tubman, who in escaping the wretched and brutal conditions of slavery in the South risked her life to follow that North Star, to follow the footpaths of the Underground Railroad searching for the Promised Land. An exceptional woman, a military mind, a leader of the likes any people would be proud to claim. Indeed, my people followed that very North Star from what is likely Maryland and traveled for days along those back footpaths. We have heard here today, and I want to go on the record to correct the record, the framing of slaves. And it is true that in our education system, as a young person, I grew up and I would have shared with you that I am the son of runaway slaves. But of course, Mr. Speaker, that is false. That context is very problematic because these were not slaves. These were people who were enslaved. These were a people who survived the transatlantic slave trade, who found themselves in one of the most wretched conditions of humanity, the deepest evil of the United States of America at that time in those settlements, and yet survived. They were the ones, in fact, who risked everything in following those footpaths to get to freedom. And they are the ones who will teach us about emancipation today. Our history books will teach us that we were given freedom, Mr. Speaker. And I will share with you, as taught by the Black Moses Harriet Tubman, in her grave warnings, that if you hear the dogs, keep going. If you see the torches in the woods, keep going. If there's someone shouting after you, keep going. Don't ever stop. Keep going. If you want a taste of freedom, keep going. And these history books, they hide a painful truth in our collective past. Things that I would become to have to find for myself. And he's quite right that we have to change our education system. And there was a book by Daniel Hill Sr., where I learned that I am actually the descendants of freedom seekers, Mr. Speaker. And I'd be remiss if I said that in this motion it is laid very clear the historical truths of Canada, that the British Parliament abolished slavery in the British Empire on August 1st, 1834. And it also acknowledges and recognizes that slavery existed in British North America prior to abolition in 1834, which is a clear acknowledgement of the British Crown's active participation and indeed profiteering from the human trafficking and enslavement of stolen African diaspora. So where is the acknowledgement and indeed the solemn apology to all descendants of African slavery from this government? We have heard before in Section C about abolitionists and others who struggled, and I will share with you that it is true. In that time, men of faith, people of faith, we had Quakers, we had people who risked everything to give refuge to people seeking freedom. My people were the first refugees of these lands. And it begs the question, what are you willing to sacrifice in order that others may be free? free from discrimination, free from police brutality, free from the systemic barriers. Mr. Speaker, this government is facing a class action lawsuit from the public sector today. We have to contextualize exactly what emancipation means. I think a lot about the refugees seeking safety at Roxham Road, Mr. Speaker. And so, when this government of Canada announces the United Nations International Decade for People of African Descent, to highlight the important contributions, but to provide a platform in confronting the anti-Black racism, this would be a perfect time for this Prime Minister to make clear the recognition and acknowledgement in the form of reparations for the displacement of the historic Black settlements, from Africville to Hogan's Alley, and every settlement in between. And yes, it is true that we get together in the deep beauty of my people to celebrate our freedom and our liberation and the collective struggles of our ancestors. So I will close in calling on the work of our present-day abolitionists of our time, those who rallied around the Black Lives Matter movement in this country, and whose members, the founding members, our present-day abolitionists, wrote in their seminal work the book Until We Are Free by Black Lives Matter Toronto, who dedicated their life's work, and for whom I dedicate mine, Mr. Speaker, to a true and everlasting emancipation. For our ancestors, whose struggle we continue until we are free. For our elders, whose fight we continue until we are free. And I will add, for the future generations that continue the struggle for our collective liberation and our emancipation, for our children and our children's children, until we are free. Mr. Speaker, thank you.
Resuming debate, the honourable member for Toronto Centre.
Monsieur le Président, I rise today to speak about motion M36, which seeks to designate August 1st of every year as Emancipation Day in Canada. Motion M36 acknowledges that the British Parliament abolished slavery in the British Empire as of August 1st, 1834, and that slavery existed in British North America prior to its abolition. In fact, Olivier Lejeune was recorded as the first enslaved African to live in New France in the 1600s. Olivier's birth name is not known, as he was taken from Africa as a young child and eventually given the last name of the priest who purchased him. The Slavery Abolition Act ended slavery in the British Empire on August 1st, 1834, and thus also in Canada. However, the first colony in the British Empire to have anti-slavery legislation was Upper Canada, now Ontario. Unfortunately, the Act Against Slavery of 1793 did not free a single slave. It was superseded by the Slavery Abolition Act. To better understand the anti-slavery legislation of 1793, we have to remember Chloe Cooley. Chloe was a young Black woman who was enslaved in Fort Erie in the late 1700s. Her owner forced her onto a boat across the Niagara River into the United States to sell her. This incident is believed to have led to passage of the legislation of 1793 in Upper Canada that prevented enslaved people from being imported into the province. Although the Slavery Abolition Act stopped slavery in the British colonies, it didn't end in the American southern states. Up to 40,000 African American slaves tried to escape from the American South to freedom in the northern states or to Canada. The Underground Railroad appeared in this context. It wasn't a railroad at all, but a complex, clandestine network of people, including Blacks, fellow enslaved persons, white and indigenous sympathizers, Quakers, Methodists, Baptists, farmers, Americans and Canadians alike, who organized safe houses that helped enslaved men, women, and children in southern plantations reach freedom in the North. Between 1850 and 1860 alone, up to 20,000 slaves reached Upper Canada. It became the main terminus of the Underground Railroad. Black Canadians helped build strong communities and contributed to the development of the provinces where they settled. Some lived in all-Black settlements such as Elgin, Buxton, Queensbush, and the Don settlement near Dresden, Ontario, as well as Birchtown and Africville in Nova Scotia. They cultivated the land, built homes, raised families. Black people established religious, educational, social, cultural institutions, political groups, and community building organizations. 2 newspapers were also founded. The Voice of the Fugitive by Mary and Henry Bibb, and Mary Ann Shadd Cary's The Provincial Freeman, making Cary the first Black woman in North America to edit a newspaper. Through the ages, Black Canadians encountered various forms of discrimination. They were often relegated to certain jobs, denied the right to live in certain places due to their race. Parents were forced to send their children to segregated schools that existed in parts of Ontario and Nova Scotia. This is what historians call residential segregation. People of African descent have shaped Canada's heritage and identity since the arrival of Mathieu de Costa, a navigator and interpreter whose presence in Canada dates back to the early 1600s. However, the vital role of people of African descent has not always been viewed as such. Inspired by these stories of courage and resilience, Black Canadians of a more recent past have made tremendous contributions to our society. Let me recall some notable figures. Alberta's Violent King, Canada's first Black female lawyer. Gloria Bayliss, who in 1965 won the first ever case of employment-related racial discrimination in Canada and founded the Bayliss Medical Company. Chatham, Ontario's Fergie Jenkins, one of the most talented pitchers to ever play in Major League Baseball, winning the Cy Young Award in 1971. He became the first Canadian inducted into the National Baseball Hall of Fame in Cooperstown, New York in 1991. Edouard Anglade, the first Black and for several years the only Black officer on the police force in Montreal. On a very personal note, growing up in Toronto, studying in history class in high school, I didn't see my history. The history books didn't include me. It was almost as if Black history was erased. All these years later, decades later, my 16-year-old daughter still doesn't have what I wanted. She doesn't see herself in the books that she studies. I say to you today, Mr. Speaker, Black history is Canadian history. Merci beaucoup.
Resuming debate, reprise de débat. The Honourable Parliament Secretary to the Government House Leader.
Yes, thank you very much, Mr. Speaker, and what a pleasure it is to rise and speak on such an important motion that my friend and colleague has introduced to the House. I don't think I could compete with the eloquent speeches that have been given in the last hour, Mr. Speaker, because you see it comes from the heart. And in very strong, passionate words. I do have a few thoughts that I would like to share. You know, my Democratic member made reference to the generations. I believe he said 8 generations. I'm not 100% sure in terms of his length of period, in terms of his family root. And the thing that it triggered in my memory was many years ago, probably about 20, 25 years ago. I was at the Victoria Hotel at the time, and there was a Black lady standing beside me. And a individual, Caucasian, walked up between us, and the question that he posed her was, "Oh, how long have you been in Canada for?" And As much as the member meant it to be an innocent comment, I suspect that if the person would have been of a white or a Caucasian background, that question never would have been placed. And it's because I don't believe that we have done well on the education, that cross-cultural awareness. And that's why I put to my good friend the issue of the importance of education. Education, I think, is so critically important in terms of advancing it. And it goes beyond just our classrooms. You can talk about our workforces, how it is that we can incorporate it into our communities. A number of years ago, it was through the Manitoba Intercultural Council, I'm not too sure in terms of its existence today, where they came up with a recommendation that the way in which you deal with issues like this is through cross-cultural education. I think there has been some very interesting stories over the years that Hollywood has actually amplified. I was, and still feel very much touched by watching some of the videos in which I've actually acquired the Roots, for example, series. To watch that, in which I have a copy of, Mr. Speaker, it sets off all sorts of emotions, a lot of them that being anger, because it's hard to imagine how it is society could treat people in such a fashion. William Wilberforce, and the way it was portrayed in the show Amazing Grace, and the abolishment of slavery, and the impact that the British Commonwealth had, was so significant to the debate that we're having today. But as my colleague who spoke just before me, Mr. Speaker, alluded to, the fact that when her daughter is in school, or children or young people are in school today, that there is a major, important aspect of Canadian heritage that has been completely overlooked, that is not getting the attention that it deserves. I'm very proud of the general attitudes that are brought forward from parliamentarians. When we talk, for example, of our Black Caucus and the extending of hands to try to better get more involvement in the issue of systemic racism that is in fact there. It's very real and it's tangible. And it hurts a great deal of Canadians in all regions of our country, Mr. Speaker. The emancipation and the objective of this motion is very much admirable and needs to be put into place. And I suspect that when it does come time for others to be able to contribute to the debate and the ultimate vote on the motion, that it will in fact pass through the House, Mr. Speaker. As I believe that the time for it is long overdue, and I anticipate, Mr. Speaker, that it will be one significant step, but we recognize the need for us to do so much more. And that is something I believe that all members are committed to doing in whatever capacity they can, whether they're in government, opposition, or whatever role that they play in the House of Commons, where there's a great expectation.
For now, but the honourable member for Winnipeg North will have 4.5 minutes remaining in his time when the House next gets back to debate on the question. For now, the time provided for the consideration of this item of private members' business has now expired, and the order is dropped to the bottom of the order of precedence on the order paper. It being 6:30 p.m., pursuant to a standing order 30 7, sub 7, the House will now proceed to the consideration of Bill C-230 under private members' business. Orders of the day.
Orders of the day, private members' business. Second reading of Bill C-230, National Strategy to Redress Environmental Racism Act, standing in the name of Ms. Zan.
Ms. Zan, seconded by Ms. May, Saanich Gulf Islands, moves that Bill C-230, an act respecting the development of a national strategy to redress environmental racism, be now read a second time and referred to the Standing Committee on Environment and Sustainable Development. Debate, the Honourable Member for Cumberland, Colchester.
Thank you, Mr. Speaker. Thank you, Mr. Speaker. The land is our mother. So when we lose value for the land, people lose value for the women. Thus says Vanessa Gray of Aamjiwnaang First Nation, Ontario, and I agree. It's also my firm belief that, like systemic racism, environmental racism is something that's been ignored for far too many years. And the time has come for us to act to redress the problems of the past and make sure they don't continue. Surely it should be enshrined as a human right for all Canadians to have clean air, water, and earth. I first became aware of the issue of environmental racism 5 years ago when I first met Dr. Ingrid Waldron, a professor at Dalhousie University in Halifax in the School of Nursing, at a coffee shop in Halifax near the provincial legislature where I worked as an MLA. At that time, Dr. Waldron explained what her research and data gathering was proving about the reality of environmental racism in Nova Scotia. I suggested that creating a legislative bill to address the issue would be a help at that point in time and bring it to public awareness and to the floor of government in Nova Scotia. Dr. Waldron and I worked together for several weeks on my very first private member's bill, Bill 111, the Environmental Racism Protection Act, which I introduced in Province House in 2015. Later on, Dr. Waldron wrote a book entitled There's Something in the Water, which highlights environmental racism in Black and Indigenous communities across Nova Scotia, and she recently partnered with Nova Scotian actor Elliot Page to create the 2019 documentary based on that book. Upon my arrival in Ottawa as an MP a year ago, my first personal order of business was to introduce a similar bill, but this time as a national strategy in order to address environmental racism across Canada. The scope of Bill C-230 is therefore broader and more comprehensive than my original provincial bill. Bill C-230 would collect data including socioeconomic circumstances, physical and mental effects of communities affected by environmental racism across this land. These effects are wide-ranging, from skin rashes and upset stomachs to more serious ailments like respiratory illness, including asthma, cardiovascular disease, reproductive morbidity, including preterm births, and babies born with Down syndrome, as well as cancers that disproportionately impact women. There is evidence that many chronic diseases in Indigenous communities, for instance, are not primarily due to genetics or internal factors, but instead to external factors, what is in the air, in the water, in our environment. I'd like to personally thank the member of Saanich Gulf Islands at this time for seconding Bill C-230, and I suggest that this is an example of what Canadians truly want to see in their government, especially in these dangerous times. Parliamentarians working together. I'd like to thank Dr. David Suzuki and the Suzuki Foundation, the Blue Dot Movement, and the Enrich Project for their endorsement and support for this vital bill. And I'd also like to acknowledge and thank Dr. Ingrid Waldron for her passion, dedication, research, assiduous study, and for sharing her notes for me this evening, because environmental racism and its effects on racialized communities needs to be heard by everybody. So, Mr. Speaker, as MP for Cumberland Colchester, I would like to explain what environmental racism is. It refers to the disproportionate location and greater exposure of Indigenous, Black, and other racialized communities to polluting industries and other environmental hazards. These toxic burdens have been linked to high rates of cancer, as I've said, and other health problems in these communities. From the decision approximately 60 years ago to offload pulp mill effluent into Pictou Landing First Nations' once pristine boat harbor, and toxic landfills and dumps placed in the African Nova Scotian communities of Shelburne, Lincolnville, and Africville, to mercury contamination in Grassy Narrows First Nation, petrochemical facilities in Chemical Valley in Ontario and in British Columbia, and the legacy of environmental racism really can no longer be ignored. Bill C-230 is asking the Minister of Environment and Climate Change to develop a strategy that must include measures to examine the link between race, socioeconomic status, and environmental risk, collect by environmental racism, assess the administration and enforcement of environmental laws in each province, and address environmental racism, including in relation to possible amendments to federal laws, policies, and programs, the involvement of community groups in environmental policymaking, compensation for individuals or communities, ongoing funding for affected communities, and access of affected communities to clean air and water. Mr. Speaker, I would contend that Indigenous and Black women have been building grassroots environmental and social justice movements for decades to challenge the legal, political, and corporate agendas that sanction and enable environmental racism and other forms of colonial violence in their communities. Colonial gendered violence continues today and includes the crisis of missing and murdered Indigenous women, the displacement of Indigenous people from their lands by corporate resource extraction projects, anti-Black and anti-Indigenous police violence, and other forms of state-sanctioned violence that make it difficult for Indigenous and Black peoples and women to meet their basic needs with respect to employment, income, healthcare, and other resources. Colonialization and genocide are tied to the intersections of Indigenous lands and bodies. Women experience violence because they are the ones that are responsible for taking care of the land and holding it for future generations. Therefore, gendered violence that harms women specifically also harms nations, which makes it easier to take possession of the land. For Indigenous women specifically, production and reproduction, land and life, resistance and survival are all intimately connected. There is no separation. Therefore, the Indigenous role in fighting against environmental racism by defending their land and territory and protecting their water are acts of resistance against gendered oppression. So, what is environmental racism exactly? How do we define it? Environmental racism is racial discrimination in the disproportionate location and greater exposure of Indigenous and racialized communities to contamination and pollution from polluting industries and other environmentally hazardous activities, as I said, but also in the lack of political power these communities have for resisting the placement of industrial polluters in their communities. In the implementation of policies that sanction the harmful and in many cases life-threatening presence of poisons in these communities. in the disproportionate negative impacts of environmental policies that result in differential rates of cleanup of environmental contaminants in these communities, and in the history of excluding Indigenous and racialized communities from mainstream environmental groups, decision-making boards, commissions, and regulatory bodies. And I would also say in the feminist movement. The health effects of environmental racism in Canada. Wow, the health risks associated include, as I've said, all of these various different types of serious illnesses. And studies provide evidence that health effects of environmental racism are both gendered and racialized and impact Indigenous women in specific ways, most notably the impacts on reproductive health. One of the most significant ways that environmental racism impacts Indigenous women specifically is through the detrimental health effects of toxic contaminants that include high levels of toxins in breast milk, placenta cord blood, blood serum, body fat, as well as infertility, miscarriages, premature births, premature menopause, reproductive system cancers, and an inability to produce healthy children due to compromised endocrine and immune systems while in utero. This bill, Bill C-230, is important, Mr. Speaker. Why is it important? It would play a significant role in addressing the legacy of environmental racism in Canada and ensure that these communities have access to clean air and water, which all Canadians have a right to. It would also help address environmental health inequities in Indigenous and Black communities that are outcomes of these communities' proximity to environmental contamination and pollution. It's up to those with power and not the people impacted by environmental racism to address the problem. Those who have the most influence and the strongest voice need to be part of the solution. It's important that all communities have the power to control their environment, Mr. Speaker. Currently, Indigenous, Black, and other racialized communities, non-white communities, don't have that power. And when they don't have a say in what happens in their communities, we all suffer. Bill C-230 addresses this imbalance of power and benefits everyone. It's good for all of us. It's good for Canada. It would provide an opportunity for the communities most affected by environmental racism to be involved in environmental policymaking. Mr. Speaker, according to a Lincolnville resident in Nova Scotia, who is mentioned in Dr. Waldron's book, There's Something in the Water, they say community members have experienced worsening health since the first generation landfill that was placed in their community in 1974, including increased rates of cancer and diabetes. This person says, if you look at the health of the community prior to 1974, before the landfill site was located in our community seemed to be healthier. From 1974 on till the present day, we noticed our people's health seems to be going downhill. Our people seem to be passing on at a younger age. They're contracting different types of cancer that we never heard of prior to 1974. Stomach cancer seems to be on the rise. Our people end up with tumors in their bodies. And we're at a loss of, what's causing it. The municipality says there's no way that it's the landfill that's affecting us, but if the landfill site located in other areas is having an effect on people's health, shouldn't it be the landfill site located next to our community that's having an impact on our health too? Mr. Speaker, perhaps no other African Canadian community has served as more of a classic example and symbol of both gentrification and environmental racism than Africville, the former Black community on the shores of the Bedford Basin. By 1965, the city of Halifax embarked on an urban renewal campaign resulting in the forcible displacement of its residents, resulting in the area becoming the host for a number of environmental and social hazards, such as a fertilizer plant, a slaughterhouse, a tar factory, a stone and coal crushing plant, a cotton factory, a prison, 3 systems of railway tracks, and an open dump. Mr. Speaker, I ask that all members of the House support this bill. Let's be a first. Let's make this something we can all be proud of, and let's do this for the people of Canada. Thank you, Mr. Speaker.
I see that there's a lot of interest in questions and comments, so I'm going to ask honourable members to keep their interventions to no more than 45 seconds. Same for the honourable member who's responding. And we'll now go to questions and comments. The honourable member for Central Okanagan, Similkameen Nicola.
Thank you, Mr. Speaker, and I certainly appreciate that the members brought in a bill to this place and a debate that she's very passionate about. In this bill, she's actually tasking the Minister of Environment, but many of the issues she has talked about are regarding to Indigenous reconciliation, etc. Why only the Minister of the Environment? Why does the member believe that the minister may criticize many of the failures this government has had in reconciliation? Many of these are also historic wrongs dating back to the last century, Mr. Speaker. So I'd like to hear what the member has to say in regards to those, and I look forward to the rest of the debate.
The honourable member for Cumberland, Colchester.
Well, first of all, Mr. Speaker, I'd really like to thank the member for his question. You know, I believe that when I first started down this road researching it, I just thought of it as a provincial issue. A lot of things that are provincial, and municipal, like dumps, waste sites, toxic landfills, things like this. But as I started to look into it more, I started to notice that it is stretched right across Canada. In fact, there are many corporate polluters, which is part of the reason why many Indigenous communities don't have clean drinking water today, and why children have rashes, and why they're having all kinds of illnesses, and why our government is now tasked with cleaning that up. So, yes, I think it will stretch across all kinds of departments, but it lands at the Department of Environment to begin with.
Okay. Questions or comments? Questions et commentaires par conférence virtuelle.
Virtually, the member for Victoria.
Thank you, Mr. Speaker, and I want to thank the member from Cumberland Colchester for bringing forward this really important bill. I just applaud her work on it. And I'm curious about reparations. This bill speaks about the impacts on Indigenous communities, on racialized communities, and we were just debating a bill on Emancipation Day, and I think the conversation around how to compensate communities who have been impacted is an important one. I'm curious how the member sees her bill fitting into a conversation around reparations.
Member for Cumberland Colchester.
Thank you very much, Mr. Speaker. And again, thank you so much to the member opposite. And I know that you have also she has also studied environmental racism and actually taught about it in university. You know, I think that this is an important part of this bill. We are talking about this now in Nova Scotia, the Black community. It's a very big deal here, and the dialogue has just started. But this bill is meant to be able to get people to make references and tell the government what they think that we should do. And I would hope that the government will then follow suit and take note of that and follow up with it. I think it's very important at this.
Questions and comments, again by video conference. The honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker, and I do want to thank the honourable member for Cumberland Colchester for bringing forward Bill C-230. It's an honour for me to second it, and of course, she and I originally, my home was originally in Nova Scotia, and it was my first experience of understanding environmental racism was the horrors of the Sydney tar ponds in industrial Cape Breton. They're now sort of cleaned up; they're at least buried, but flagging that was what was called the tar ponds was originally an estuary of a Mi'kmaq fishing grounds where they were forced off that land and put in Membertou in order to build a steel mill and a coke oven, and the only African Black community in Cape Breton was between the coke ovens and the steel mill. So the population had huge levels of cancer. It was the biggest toxic waste site in Canada. And I wish we'd had that bill, the bill here. I wish we had it in place then. And I just ask the honourable member if she has any reflections on that, and thank her again.
Honourable member for Cumberland Colchester.
Well, thank you, Mr. Speaker, and thank you so much again for seconding my bill. You know, it's a perfect example, and so was Boat Harbor. It was a beautiful, pristine lagoon where First Nations communities came to picnic for thousands of years, thousands. And I went there and I saw the degradation and smelt the stink and saw what it was doing to the people. And many of the people that I stood in a barricade with against the mill at that time are no longer here. They died of cancer. So it is a bill whose time has come, and I think it's up to us to make sure that this happens. And I thank you again.
We are out of time, but I'm going to just take some liberties here and take one more question. The honourable member for Sydney, Victoria.
I'd like to start off by thanking the honourable member for her comments, and I'd like to thank the member for her strong leadership and commitment to social justice on this file. As a Mi'kmaq from Nova Scotia, you know, I learned numerous times during my research where Indigenous people were displaced from their traditional lands, often close to their resources in lucrative areas, and centralized onto small reserves in areas that led them to be vulnerable and open to exploitation. My question is, how do you see your bill being able to create the important awareness around these injustices? And do you feel education is an important part of this bill moving forward? Thank you.
Honourable member for Cumberland Colchester.
Well, thank you again, Mr. Speaker, and I want to thank my honourable colleague because he has done a lot with treaty education in Nova Scotia, and I believe that is something we need to roll out right across this country. People don't seem to understand that the First Nations people were here for, 13,000 years before we ever got here. And sometimes when I hear people say, go back to where you came from, pick up your tents and go back to where you came from, it just breaks my heart. And I feel that this kind of bill starts the dialogue and opens people's eyes and hearts to what has been going on for far too long. And I believe it's up to us to fix it. Thank you.
Resuming debate, the honourable member for Central Okanagan, Similkameen Nicola.
Thank you, Mr. Speaker, and it's always a pleasure to rise in this place to participate, especially in private members' business. Now, I'm certain that I'm not alone in my appreciation of recognizing the passion and the ideas of colleagues from all parties in this place. Generally speaking, we either oppose a private member's bill or we support it. On rare occasions, from my perspective at least, a private member's bill may come along that I will oppose despite being supportive of the principle being raised. This is one of those rare occasions for me. I'd like to share with this place my thoughts on this bill. First, I'd like to commend and recognize the member for Cumberland Colchester for raising this very important concern. The member refers to this concern as environmental racism and ultimately proposes to create a national strategy to promote efforts across this great country to redress the harms caused by environmental racism. Now, what does the member for Cumberland Colchester define as environmental racism? One part of the bill reads as follows, and I quote, whereas the establishing of environmentally hazardous sites, including landfills and polluting industries, in areas inhabited primarily by members of those communities could be considered a form of racial discrimination, end quote. As
it happens, Mr. Speaker, I actually have a few local examples that speak directly to this issue. I will share those examples with this place to illustrate why I said in my introduction that I support the principle raised in this bill. My first local example involves a company called Appleton Waste. Appleton Waste was paid by many citizens of Penticton and the area to properly pick up and collect garbage that would be transported and dumped at the local landfill. The company did not pay its bills to the landfill operator, which was in another local government, the Regional District of Okanagan-Similkameen, or RDOS, as we call it in the region. Because the bills had not been paid, the RDOS had to suspend service for Appleton Waste Unfortunately, this did not stop the company from continuing to collect waste and bill their customers for it. Instead, the company reached an agreement that eventually resulted in 5,000 tons of waste being dumped on the Penticton Indian Band land. The arrangement was that this waste would be transferred or would be in a transfer station before it was transported elsewhere. How did it end, though? Well, the company disappeared. But a massive pile of waste became a serious problem for the Penticton Indian Band members to deal with, and it wasn't even their own waste. The waste came from the citizens of the city of Penticton.
And ended up with a landfill, to quote from the bill, and I quote, in areas inhabited primarily by members of those communities, end quote. As the bill states, and I quote again directly, and I quote, could be considered a form of racial discrimination, end quote. That is the first example that, in my view, speaks to the challenge that's referred to in this bill. Now, I'll provide a second local example. Many will know the Okanagan region that I come from is famous for its excellent wines, but many years ago, it was for fruit growing. As a result, there is a significant fruit industry infrastructure in many small communities, much of it aging. In Naramata, there was an old fruit packing warehouse that was scheduled for demolition and removal. Now, ultimately, the successful salvage bidder hauled the demolished wood waste away. And where did it end up? On Penticton Indian Band land, where ultimately it was burned. Maintenant, dans ce cas, des accusations environnementales.
Now, in this case, provincial environmental charges had been laid against the parties involved. Finally, this case has made its way through the courts. The defendants argued that this activity took place on the Penticton Indian Reserve, which does not fall under provincial jurisdiction in such environmental matters. They argued that they had complied with all local government requirements, in this case, the directives of the Penticton Indian Band. Ultimately, an application was made challenging these charges on constitutional grounds. The judge ultimately rendered a non-guilty verdict and declared the application moot, as there would be no further court proceedings. Having shared these two examples with Canada, you can probably understand why I support the challenge raised in this bill. However, I will now explain why, while I recognize the challenges, I will oppose this bill.
Situation, there was one common denominator. The Penticton Indian Band lands that were adversely environmentally impacted by these situations were what is called locatee lands. As many are unaware that on some First Nations, not all land is band land. Some lands are locatee lands. These lands are very similar to privately held land where locatees can make land use decisions independent of locally elected band chiefs and their respective councils. In both of these cases, local non-Indigenous business owners made financial deals with band members who control these locatee lands. We all know that the federal government, more specifically Indigenous Services Canada, is supposed to safeguard the interest of Aboriginal communities to prevent these types of situations from occurring. Here in Ottawa, we seldom hear how some of these situations are actually caused. This also raises a question, Mr. Speaker, that has to be asked. Is it the role of Indigenous Services Canada to tell a locatee family what they can or what they cannot do on their lands? Or is that up to a locally elected band chief and council? Et une autre question, le député de projet de loi a-t-il...
And there's another question. Has the bill proponent been approached by the Indigenous community in the riding itself? Or is this yet another example of Ottawa knows best, where we here in Ottawa have undertaken another series of studies so that we can create a one-size-fits-all strategy? That is what we've been doing for decades. I don't know the answer to that question, Mr. Speaker. In this bill, I see two challenges. As I mentioned earlier, I would like to be able to support this bill. However, that would put me in a situation where I would be voting for something that could have repercussions on a number of First Nation communities in my region. Without hearing any contribution from them about what they think about this bill, I simply cannot do that in good faith. I think that the time when we take decisions like this here in Ottawa without first sitting with local chiefs and band councils and hearing directly what they think about a bill should come to an end. It is clear that environmental factors have repercussions on First Nations. Grassy Narrows comes to mind, and the Prime Minister's words on these issues. Thank you for your donation. It is important to study these impacts, but the use of the term racism implies that Canadians are racist and responsible for this, and that it's not the Liberal government's long-term failure that's responsible.
They would not meet their clean drinking water promise, another failure. Canadians are warm and caring people and would support finding ways to better ensure everyone is healthy and thriving. But what is not right is implying the fault lies at the feet of a racist country. Canada is not a racist country, and to imply that is just disgraceful. Now, I appreciate the member from Cumberland-Colchester is well-intentioned. However, I have many Aboriginal communities in my riding that I must be accountable to. It's for this reason that I cannot support this bill. I do thank the member for raising this concern, and I also would like to thank members of this place for taking the time to hear my comments today. Mr. Speaker, thank you, and again, it's a pleasure serving on behalf of the communities in my region. Thank you.
Resuming debate, the Honourable Member for Repentigny. Thank you, Mr. Speaker. Before I explain the reasons for which the Bloc is not for this bill, I will highlight a number of points. First of all, we recognise the existence of issues linked to geographical disparities when it comes to the quality and the level of life and access to quality environmental ecosystems. And then we're also concerned by the fact that immigrants and Indigenous peoples are more directly affected by these disparities. Finally, we are for government actions that seek to fighting inequality for all communities when it comes to the environment. But in C230, there is a high number of issues linked to its provisions. There is a direct attack against Quebec and provincial environmental sovereignty. So, Mr. Speaker, you won't be surprised to hear that the Bloc Québécois will vote against anything that casts doubt on Quebec legislation and Quebec jurisdiction. With regards to the subject matter, the federal government would have the constitutional jurisdiction to implement these measures, but here there's more. There's also the absence of a definition, and my colleague just mentioned this. The definition of there's no definition of environmental racism when one tables a new concept in a bill, especially when the concept comes from a very specific theory. We would have to have a specific definition in society and in academia. Definitions evolve over time, but a statute must be clear, well-known, and recognized. Indeed, in C230, there is an abundant use of the word race, and we understand that the Honourable Member wants to fight against racism and discrimination. We don't want to cast doubt on that. But there is still a certain malaise. the sociological rehabilitation of race in this perspective isn't a process that is subject to scientific or social consensus. This concept, born in the United States, is based on the analysis of the relationship between the social, including the criteria of class, gender, or race, and nature. Some people will remember Erin Brockovich, the film, who was fighting against an industry, but she talked about financial precarity. She's always spoken about poverty. Professor Waldron, a professor and author who inspired and holds great hope for C230, brings a real and important issue of environmental discrimination to the forefront in terms of race or colour. Now, we don't want to contradict Professor Waldron, but it must be recognised that environmental injustice, which disproportionately affects minority communities, is more akin to a fundamentally anti-capitalist ideological stance. Indeed, she posits her research with the conditions that fuel environmental racism, explaining that the socio-political factors that together fuel environmental racism include poverty, lack of political power and representation, lack of protection and enforcement of laws, and neoliberal political reforms. And so, she recognized that we are in presence of a number of factors of vulnerability. So why would we talk about racism? Mr. Speaker, the term systemic racism is loaded at the theoretical and political levels. In order to debate it from an open perspective, we must not be engaged in overly constraining theoretical premises dominated by sociological approaches that are resolutely situated and militant. And you know, I was a teacher, I was the head of a union. I know how to be militant, I know how to do this, so I recognize it's important. But when we have a bill like this, a legislator must be guided in a different way. Professor Waldron cites the unequal relationship between minority languages, including Aboriginal and Indigenous languages, and the English majority language as being one of the factors contributing to the environmental burden. I quote, "Some provinces and territories have an environmental Bill of Rights and a legal framework governing environmental rights, yet gaps remain in areas of federal jurisdiction." And yes, there are gaps, let us be clear. Last week, I spoke to C225, tabled by my colleague for Jonquière, Citizen Mobilization, and I mentioned it in social movements that lead political struggles have a desirable impact on government action for the environment, and these fights are often distinct based on people's different realities. But for the legislator, the challenge is completely different. The challenge is quite different. Their responsibility is to make laws that serve justice, yes, but that must also apply to all citizens. Good policy is universal policy. It is at the service of the common good and is aimed at the whole population. More importantly, universal public policies also have the effect of dismantling unequal structures and discriminatory practices. So, choosing the parameter or the conceptual lens of race to observe an intersectoral phenomenon such as environmental discrimination seems to us to be ill-chosen, particularly in the legislative context. In Quebec, the Quebec Human Rights and Youth Commission has, moreover, given its opinion on the issue. I quote, "The idea that socio-economic, cultural and political differences between human groups can be based in whole or in part on biological and genetic disparities has been largely rejected by the majority of social science researchers." The Commission adds that measuring and operationalizing race in order to better understand the dynamics of racial categorization and exclusion is not a risk-free endeavor. Canada needs to examine its conscience in the face of the reality described in Ingrid Waldron's work, if only with respect to Indigenous peoples and the unacceptable conditions that prevail in far too many communities across Canada. So, how does C230 include a provision that puts in the hands of the federal government, and I quote, "the enforcement and monitoring of environmental laws in each province"? when we have several very eloquent examples where the federal government shows its indifference to the legislative mechanisms already in place in other jurisdictions. I return once again to C225 from last week, and the sad reality of the undue precedence of federal legislation over environmental concerns and provincial laws. What Canada has is a series of bills that are more permissive than Quebec bills, but they have precedence. So we shouldn't give even more precedence to the federal government. Canada needs to examine its priorities in protecting its population from climate change, pollution issues, its impact on health, and the overall inequities that characterize its environmental action. Yes, the federal government must correct the deficiencies to which Ms. Waldron refers. Just like her, I call on members to reflect on the sad legacy that follows the application of neoliberal policies, those that undermine the welfare state. We must be firm in our legislative intentions, and we must fight discrimination, but we must do so in a collective way, not in a divisive way. For example, pay equity, equality between men and women, universal access to the resources necessary for life, drinking water for Indigenous communities, for example, access to justice. In short, we must fight again and again to ensure that the gap stops widening. Let us remember that the right to live in a healthy environment has been enshrined in a multitude of national constitutions and charters. The member mentioned it from the get-go, so why can we consider the same here in Canada? The obligation of working in a healthy environment with others, as well as other fundamental benefits, disregarding our biology, our community of belonging, our socioeconomic status, or the geographic location in which we live. Would we have another argument to make when discussing the Constitution, Mr. Speaker? We're ready.
Resuming debate, the honourable member for Victoria.
Thank you, Mr. Speaker. And I want to thank again the member for Cumberland Colchester for bringing forward this important issue in the House. Environmental racism is a huge but often ignored problem. In fact, many people are unfamiliar with the concept. And as she mentioned, before becoming an MP, I taught a course that focused on environmental racism. And I had my students actually reading the provincial bill that the member from Cumberland Colchester put forward when she was a New Democrat member in the provincial legislature. And it is such an important topic, such an important bill. I was disappointed that it never passed provincially, but I'm hopeful that we can move forward with this federally. And across Canada, toxic dumps, polluting projects, risky pipelines, tainted drinking water, and the effects of the climate crisis disproportionately hurt Indigenous, Black, and racialized communities. And systemic discrimination has been embedded into environmental policymaking, and also the uneven enforcement of regulations and laws. The targeting of Indigenous, Black, and racialized communities for toxic waste facilities, the official sanctioning of the life-threatening presence of poisons and pollutants, and the exclusion of these communities from the decision-making process. I think we also need to think about this in the context of the fact that we export our waste to countries predominantly in the global south, and it's often racialized communities who are experiencing the impacts of this toxic pollution. I support the bill, and I believe we need to take urgent action on environmental justice. I would also like to see the right to a healthy environment enshrined in law through an environmental bill of rights. Now, environmental racism in Canada is well documented. It's a direct result of the historic and ongoing impacts of colonization. Many have seen the documentary, There's Something in the Water, that was referenced. And it is based on the report to the Canadian Commission for UNESCO by Dr. Ingrid Waldron. And in that documentary, the highlights the highlighting of the stories of Indigenous and Black communities in Nova Scotia fighting for environmental justice are poignant and powerful. And after visiting Canada in 2019, the UN Special Rapporteur on Human Rights and Hazardous Substances and Waste wrote, and I quote, "I observe a pervasive trend of inaction of the Canadian government in the face of existing health threats from decades of historical and current environmental injustices." And a report submitted to the Human Rights Council just this September stated that pollution and exposure to toxic chemicals threaten the right to life and a life with dignity, and that the invisible violence inflicted by toxins is an insidious burden disproportionately borne by Indigenous people in Canada. It is so clear that we have a problem of systemic racism that our government is doing little to nothing to address. And in the absence of government action or legislation, and often excluded from the leadership of mainstream environmental movements, Indigenous and racialized communities and their allies have been demanding environmental justice, demanding their rights, demanding to be heard. They've recently had some success in the halting of environmentally hazardous projects in their communities through community organizing, petition signing, civil disobedience, but they shouldn't have to fight not to be poisoned by the air that they breathe or the water they drink. Negative health impacts caused by toxic exposures compound other existing inequalities, and the challenges that Indigenous and other racialized groups face, low income, poverty, underemployment, unemployment, food insecurity, and poor access to health care. All of these things, in addition to more direct impacts on human health, impact environmental racism. And environmental racism destroys natural environments, causing the loss of access to traditional food sources and cultural practices. And this disproportionate exposure to toxic substances also contributes to Indigenous and racialized people in Canada being locked into a vicious intergenerational cycle of poverty. The manifestation of illness due to exposure to heavy metals in turn leads to reduced income and reduced earning potential. Lower incomes and poverty are significant factors in why households from racialized communities are less likely than white households to be able to leave environmentally hazardous communities or neighborhoods. Many of us recognize the names of communities that have been devastated by toxic pollution. But what could have been done to stop it? So Chemical Valley, where 62 large industrial facilities, about 40% of Canada's petrochemical industry operates within a few kilometers of Sarnia and the Aamjiwnayn First Nation, exposing community members to a range of harmful pollutants, causing increased rates of asthma, reproductive effects, learning disabilities, and cancer. Then there's Grassy Narrows, where ongoing mercury poisoning, first discovered in 1970, has had devastating health effects and contaminated the water and the fish the community relied on. Boat Harbor, where an effluent treatment facility for Northern Pulp Mill was built and operated by the provincial government near Pictou Landing First Nation in Nova Scotia. And it turned a quiet estuary and fertile hunting and fishing ground into a highly toxic site. And that's not even to mention maybe the most famous when we're talking about environmental racism, Africville. And it's not just about communities that have become infamous sites for toxic pollution. In urban areas across Canada, 25% of the lowest socioeconomic status neighborhoods disproportionately home to racialized people are within 1 kilometer of a major polluting industrial facility, compared to just 7% of the wealthiest neighborhoods where white families are more likely to live, resulting in elevated risks of hospitalization for respiratory and cardiovascular illnesses. Climate change is taking a disproportionate toll on Indigenous peoples. Canada is warming at twice the global rate, and Northern Canada at about 3 times the global rate, depleting traditional food sources, driving up the cost of imported alternatives, and contributing to a growing problem of food insecurity and related negative health impacts. But Indigenous communities have been fighting back. They have been resilient in the face of this injustice. And Canada is not adequately supporting Indigenous peoples' efforts to adapt to the climate crisis, and it is failing to do its part to reduce greenhouse gas emissions. The United Nations Declaration on the Rights of Indigenous Peoples needs to be enshrined in law. I'm glad to see the government finally tabling the piece of legislation on UNDRIP, but I'm concerned that their bill is watered down compared to what many Indigenous organizers and people across Canada have been fighting for. We need to take into account Indigenous science and knowledge in relation to the environment and its protection. I also want to talk about the right to a healthy environment. The top recommendation in the UN Human Rights Council in September 2020 is that Canada recognizes the right to a healthy environment in law. Over 150 countries have had legal obligations to protect the human right to a healthy environment. And although there are environmental bills of rights in Ontario, Quebec, the Yukon, the Northwest Territories, and Nunavut, as well as provincial and territorial laws that address environmental rights, there's no federal law that explicitly recognizes the right to a healthy environment in Canada. CEPA, the Canadian Environmental Protection Act, doesn't include any reference to environmental justice, human rights, or vulnerable populations, and it's been 20 years. It's 20 years out of date. Badly needs updating. So the NDP and my New Democrat colleagues for many years have been advocating for an environmental Bill of Rights. I want to recognize former NDP MP Linda Duncan, who put forward the bill, and my NDP colleague and member from Winnipeg Centre, who introduced Bill C-232, that calls for the recognition of the right of all Canadians to a safe, clean, and healthy environment, grounded in a commitment to upholding the United Nations Declaration on the Rights of Indigenous Peoples. And we remain committed to implementing an environmental Bill of Rights and strengthening CEPA to better protect Canadians from toxic substances. We broadly support this bill and the need to take urgent action towards environmental justice and to address the disproportionate environmental impacts felt by Indigenous, Black, and racialized communities. The bill stipulates that the strategy must include measures to address environmental racism, including compensation for individuals or communities, and ongoing funding for affected communities.
I'm afraid we're out of time, so we've got to the end of the 10 minutes, and we'll now go to resuming debate. And I'll let the Honourable Parliamentary Secretary know before we get underway. There are only about 6 minutes remaining in the time for private members' business this afternoon in this segment, but I'll give him the usual signal as we get close to that time. The Honourable Parliamentary Secretary to the Minister of Environment and Climate Change.
Merci beaucoup, Monsieur le Président. Thank you, Mr. Speaker. I'm very pleased to be able to speak to this bill presented by the Honourable Member for Cumberland Colchester, the National Strategy to Redress Environmental Racism. The purpose of this bill, Mr. Speaker, is to promote the efforts made across Canada to prevent and redress the situation in which Indigenous and racialized communities find themselves disproportionately speaking, and the deterioration of the climate and other forms of environmental damage.
It resonates particularly in the current context of COVID-19, where impacts of the pandemic have been disproportionately borne by disadvantaged groups. Numerous Statistics Canada studies point to the unequal impacts of the pandemic on various groups, and one study, for example, found that immigrants and visible minorities from larger proportion of frontline workers, including nurse aides, orderlies, and patient service associates. This suggests that some groups of Canadians likely have been at greater risk of exposure to virus than others. And additional evidence, Mr. Speaker, from Public Health Ontario suggests that people living in ethnically diverse neighbourhoods have been more likely to get sick from the virus than other Canadians. Various analyses have also shown that particularly groups like Indigenous Canadians and so forth are much more vulnerable, and this is a signal that we have to take action. Ce projet de loi arrive à un moment où
This bill comes at a time when many Canadians are thinking very attentively about all aspects of racism, including its environmental dimension. Canadians are very concerned by systemic racism that Black people, Indigenous, and persons of color experience because of political and institutional practices. In the throne speech, our government committed to continue the fight against systemic racism thanks to concerted and concrete efforts. Major measures have already been taken with the publication of the Canadian Strategy to Fight Racism 2019-2022, with an investment of $45 million that will allow immediate measures to be taken to fight racism and discrimination.
Through the Anti-Racism Action Program, the Government of Canada is investing $15 million to fund 85 anti-racism projects that aim to remove systemic barriers faced by racialized communities, religious minorities, as well as Indigenous Canadians. And we've committed to also furthering transformative change by taking action on online hate, going further on economic empowerment for specific communities, implementing an action plan to increase representation in hiring and appointments and leadership development within the public service, and taking new steps to support the artistic and economic contributions of Black Canadians' culture and heritage. We also know that this bill highlights the efforts to combat systemic racism can intersect with environmental and health concerns, and we're taking action in this regard as well. The Government of Canada is also committed to continuously improving how vulnerable populations are considered in the assessment and management of chemicals and other substances under the Canadian Environmental Protection Act and other federal statutes. Chemicals are an integral part of everyday life, essential to our health and well-being, the economy, our communities, and our homes. While chemical substances may provide benefits, some may also have harmful effects on human health. And some Canadians may be more vulnerable, Mr. Speaker, than others to those harmful effects. And where there's information available, departments consider this both in conducting risk assessments and in designing risk management measures. This includes consideration of individuals living in the vicinity of industrial or commercial facilities and First Nation and Inuit populations. To build on our commitment to address the unequal burden of exposure to certain groups to harmful substances, in late 2018 and early 2019, the government undertook consultations on defining vulnerable populations, a first step towards a policy framework on vulnerable populations. Feedback received through this consultation process is helping to inform the activities related to chemical assessment and management, including the development of policy framework to address vulnerable populations under CEPA, Mr. Speaker. Also of note, work under the Federal Air Quality Program is exploring how to address air pollution in specific areas that are particularly stressed, so-called hotspots, Mr. Speaker. This work is important as vulnerable populations can be disproportionately impacted by the pollution in those areas. So, Mr. Speaker, Monsieur le Président.
Mr. Speaker, the government has pledged to tackle systemic racism, and we also pledge to do it in a way that is based on people who are racialized and those who are Indigenous. We must make this a cooperative and collaborative effort. Our first step will be to listen to as much as possible of those people whose experiences should guide our approach. This bill is the beginning of a conversation, and we're happy to pursue it with the goal of addressing this very major issue. And once again, I would like to thank the member for Cumberland Colchester for having presented this bill. Thank you.
Alors, la période prévue pour le...
The time provided for the consideration of private members' business has now expired. Pursuant to Standing Order 996-1, this order is dropped to the bottom of the order paper.
A motion to adjourn the House is deemed to have been made and seconded at this time. Therefore, the question is that this House do now adjourn. And we'll go by video conference to the Honourable Member for Vancouver East.
Thank you, Mr. Speaker. The pandemic has only amplified existing vulnerabilities of the homeless and those who are precariously housed. People continue to face skyrocketing rents, ballooning home prices, demo evictions, and have increasingly resorted to living in encampments. Vancouver East continues to have the largest encampment in the country as the cold, wet weather is upon us, and we're now grappling with the highest rate of COVID-19 in the city as well. The urgency for action is more acute than ever. The last time the importance of housing was backed up with serious action federally was after the Second World War, when hundreds of thousands of affordable and supportive housing units were built by the government to make sure returning soldiers from the war had a place to live. Now, veterans who served our country increasingly find themselves without a roof over their heads. Clearly, the Liberals do not feel the sense of urgency to act that housing providers and housing advocates do. While the Liberals have declared that adequate housing is a basic human right, their actions do not come close to match their words. It took 6 months into the pandemic for the Liberals to announce the Rapid Housing Initiative, and their promise will only bring 3,000 new units to addressing the homelessness crisis. When over 235,000 Canadians experience homelessness every year, even before the pandemic made things worse, 3,000 units simply isn't going to cut it. The Canadian Housing and Rental and Renewal Association, the Canadian Alliance to End Homelessness, housing providers and advocates are all saying that this is not good enough. In fact, CHRA is calling for the federal government to increase the Rapid Housing Initiative funding by at least $5 billion. They also want to see the duration of the program to be extended to at least 2028. Communities also noted that the Rapid Housing Initiative announcement does not include any resources for wraparound social supports and services. For those suffering from chronic homelessness, supportive services are essential for their success. They're calling on the federal government to include additional resources to fund wraparound supports so that proper care can be provided to ensure their success. In Canada, 80% of the Indigenous peoples live in urban, rural, and northern communities, and they're severely overrepresented in the homeless communities. The fact that the announcement did not include a dedicated rapid housing stream for urban, rural, and northern Indigenous peoples highlights once again how their needs continue to be neglected by the Liberal government. Canadian Alliance to End Homelessness and CHRA know that when the National Housing Strategy was announced in 2017, there was nothing included for urban, rural, and northern Indigenous peoples, even though the Minister of Housing was explicitly told to create an urban, rural, and northern Indigenous housing strategy in his 2019 mandate letter. A year later, there is still no strategy. The time to act is long overdue. The Indigenous caucus of the CHRA are demanding the federal government to develop a for Indigenous, by Indigenous national housing center. They want to see an increase in the supply of stable, safe, and affordable Indigenous housing by 73,000 units. They want accelerated action on Indigenous homelessness along with wraparound services to support Indigenous tenants' well-being and long-term success. And they want to see accelerated action on the elimination of Indigenous homelessness and a focus on northern housing. No more excuses, no more delays. The time to act is now.
Parliament Secretary to the Government House Leader.
Mr. Speaker, I want to thank my colleague from Vancouver East for giving me the opportunity to speak about the Rapid Housing Initiative, which the Prime Minister launched on October the 27th. This is an important new program that will quickly give more vulnerable Canadians a place to call home at a time when it is needed most. Some of those hit hardest by COVID-19 are those who also find themselves in a precarious housing. This includes seniors, women, and children fleeing violence and people experiencing homelessness. For example, it's impossible to safely shelter in place when you don't have a place to call home. Our government has recognized this and mobilized quickly to offer a number of supports to address these urgent housing needs. This includes additional funding of more than $236 million for Reaching Home. Canada's homeless strategy, these funds will help communities to extend and expand the emergency measures put in place at the onset of the COVID-19 pandemic, as well as provide them with the flexibility to deliver housing solutions. Now, Mr. Speaker, many parts of the country are now in the second wave of the pandemic. As my colleague has noted, temperatures are dropping. It's clear that we need more affordable housing. We need it urgently, and our government is committed to helping make this happen. That's where our government's Rapid Housing Initiative comes in. This program represents $1 billion in federal investments. It will create 3,000 new permanent affordable housing units across the country. All units will be completed within 12 months from the signing of the funding agreement. It will focus on creating housing for Canadians in severe need. people who are experiencing homelessness or living in temporary shelters as a result of the COVID-19 pandemic. At the same time, the program will stimulate the economy, creating good jobs when they're needed most. The Rapid Housing Initiative will be delivered through Canada's National Housing Strategy, a 10-year, $55 billion plus plan, but it will be delivered on a much more accelerated timeline. One half of the program's funds will be delivered directly to cities with the highest levels of housing needs needed and homelessness. The other half will fund projects led by provinces, territories, municipalities, Indigenous organizations, and nonprofit organizations. All projects funded through this initiative must be completed within 1 year. The funding can be used to build modular housing, buy land, or convert existing buildings to affordable housing. I've spoken to our partners in the cities, provinces, and territories in the housing sector. They advised us that the design of the program, and they are quickly mobilizing the seizing of this opportunity. Mr. Speaker, our government is proud to be working hand in hand with these dedicated partners to ensure that our most vulnerable people can be safely housed now and can thrive in the years to come. Mr. Speaker, I know it's the Parliamentary Secretary for Housing, who I would ultimately argue is one of the most ably-minded individuals in Canada when it comes to nonprofit housing. Proud to have him as a member of this caucus, who I know has on numerous occasions stated these type of words, in fact assisted me in this particular speech, to say to the member opposite that at the end of the day we have a caring, compassionate government that has really materialized like no other government before it in terms of investment in the future development of a truly national housing strategy. So with those few words, Mr. Speaker, I'll leave it at that and wait for the next question from the member.
Member for Vancouver East.
3,000 units of the Rapid Housing Initiative just doesn't cut it. The fall economic statement failed to indicate that action will be taken to ensure acquisition fund will be in place to support affordable housing providers in the purchase of distressed housing, while large for-profit capital funds have been buying up distressed housing. This was called for as early as March from the former UN Housing Rapporteur, Ms. Lalani Farah. She wrote to the government back on April 19th about this, and it's now December, and the government still hadn't even have the courtesy to respond to her. Her suggestion is further supported by many other housing advocates, including the Canadian Association to End Homelessness. The Globe and Mail wrote an article indicating that private buyers are lining up to try and get their hands on rental towers, especially the older buildings, which tend to have lower rents. If we wait to act, it will be too late. No more excuses. Time to act, Mr. Speaker.
Parliament Secretary.
Mr. Speaker, too many Canadians are in a housing need. The COVID-19 pandemic has made a difficult situation even worse, but our government is taking action and delivering strong results for Canadians. The Rapid Housing Initiative is the latest major program we've developed to help Canadians to get through these difficult times and would build back better. Now I ask my colleague and members on all sides of the House to do their part. I urge them to work with their local government and housing sector partners to help their constituents through this difficult time by making the most of this and other national housing strategy programs, Mr. Speaker. I would really encourage the member to do just that.
The Honourable Member for Regina Leuven.
Thank you very much, Mr. Speaker, and I'm happy to be here to have a conversation about a question I asked around NAV Canada and possibly the fact that the air control tower in the Regina International Airport may cease to exist in the not too distant future. And that is a very important conversation for the people of Saskatchewan, of Southwest Saskatchewan and Regina. And I look forward to having the answer from the member from Winnipeg North, and I hope he doesn't just read speaking points, but we can actually have a dialogue and have a conversation between two parliamentarians about something that's very important for not only Saskatchewan but Western Canadians. And I've been able to have a conversation with not only the member from Winnipeg North, but also the Minister of Transport. I asked a question, and the response I got wasn't really favorable on behalf of the people of Regina Leuven. the International Airport in Regina is in the heart of Regina Louvain, and it's something that is very important for us to ensure that when we do come out of COVID-19, that we do have the ability to have flights coming in and out safely, and to ensure that it is a big part of our economic recovery when we do see, as they said, the light at the end of the tunnel. So I have had conversations with NAV Canada, and they talk about the complexity of flights that do come into the air zone. And one thing that we need to take into account when it comes to having an air traffic control tower is the fact that 15-wing Moose Jaw is in the same air zone as Regina. So when we're talking about complex flight, so that's the training base for RCAF, and it's the fact that we want to keep our pilots safe. We want to keep our military pilots safe. So they have flights coming into that air zone that go 600 kilometers per hour, 900 kilometers per hour. So it's a very complex situation where we need professional people at the air control towers to make sure that our military personnel is safe. And not only that, and I'm sure the member from Winnipeg will know, we also have the world famous snowbirds at 15-wing Moose Jaw that fly out of Moose Jaw. They could take in the same airspace as the international airport in Regina. So I think the safety of all of these complex flights should be taken into account when we're having this conversation. Not only that is, I think when it comes down to it, Regina is also a provincial capital. And if we didn't have an air traffic control tower in Regina, it would be the only provincial capital in the country that didn't have these safety measures put into place. And I think that sends a signal to people, not only in Regina and Saskatchewan, but Western Canada. And I believe that to have a provincial capital that doesn't have air traffic control towers and someone there sends the wrong signal. And I think this government has said, and I remember this, Mr. Speaker, as clear as day on election night, that the Prime Minister said, I hear Western Canadians, I hear what they're saying, and I'm going to be there to make sure that their concerns are heard. We haven't seen that in the last year, Mr. Speaker, and for this one reason, I think it's time for this Liberal government to step up and ensure that Western Canadians, the safety and complexity of all these flights going on in the Regina International Airport airspace are taken into consideration. And for once, I hope this government is listening and they can ensure me, and I'm hoping the member from Winnipeg can ensure me they're listening to Western Canadians and they're going to take the safety, complexity, and the safety of our snowbirds, our Royal Canadian Air Force, all the pilots at F-15 Wing and Moose Jaw into consideration when they make these decisions.
Parliament Secretary to the Government House Leader.
Thank you, Mr. Speaker. And I will put the notes to the side and make it a discussion, more so as a speech, and assure the member that I will take the time to raise the issue with the minister. And I do that, and I don't say that lightly. Actually, I spent a few years in Saskatchewan, my younger days. In fact, very familiar with the snowbirds as I went to the show in Moose Jaw, the air show. I'm very much familiar with air traffic control because I was actually a member of the Canadian Forces and I was an air traffic control assistant. I worked out of the tower in Lancaster Park. We had the longest runway, 14,000 feet. You could land the space shuttle there, something in which I've reminded the current minister of. So I have some knowledge. I have family that live in Regina. Go the Riders. We all love the Riders. And I can tell you that we understand the importance that airports play in our communities. Whether they are the smaller airports that we see scattered throughout the prairies, to the larger centers like Regina, to our international, the Calgary Airport, and I'm sure my friend's been to the Calgary. It's a massive, growing airport. We have a fairly significant different types of airports that provide all sorts of services. I understand the importance of towers. I also understand the importance of issues, having worked on radar, air zones, and so forth. Safety is important. NAV Canada has a high level of expertise that I don't have, and I suspect that the member opposite might not necessarily have. And that's why I think it's important that we get that good understanding. And if there is something that can be done that's practical, I can assure the member that we are listening and very much interested in what it is that we can do to further the cause. You know, one of the nice things that just came out in the budget presentation, the mini budget, was the idea that we need to have a prairie investment fund. So it's the prairies. And I see that as a sign to the prairies that the government is very much concerned in terms of those beautiful 3 prairie provinces, in which I've lived in all 3, get the attention that's needed. And I understand personally the importance of our airports and our towers. And I will take the comments and at some point have that discussion. I don't know when, but I will have that discussion with the minister. Thank you.
Honourable Member for Regina Lewvan.
Thank you very much, and I very much appreciate the comments made from the member opposite. So he will know, as working in an air traffic control tower, that there is a difference between what they do and what flight information services do and the service they provide. And I would ask him to make sure, when he does have that conversation with the Minister from Transport, that he make sure he knows the complexity of the flights going on at the Regina International Airport, and that I believe, and I hope the member opposite would agree, that flight information services provide a valuable service, but not quite the same service as an air traffic control tower, in the fact where there is a few different words where you may land, you could land, or you are cleared for takeoff, which he will understand the conversation I'm having, and the difference between the services that are provided by the different entities. And I hope he will help me in making sure that Regina International Airport has an air traffic control tower going forward, based on the complexity of the flights, based on the snowbirds, based on the 15-wing Air Force Base in Moose Jaw, and the serious in ensuring that the brave men and women that serve there have the safety and the services they deserve.
The Honourable Parliament Secretary.
Mr. Speaker, when I was in Edmonton, I would work in 2 capacities. One with the search and rescue, which is, by the way, is in Winnipeg right now, but search and rescue, which is planning the flights that would ultimately go onto radar, different airspaces. And then, so if I wasn't working there, I would then be in the tower. And my responsibility was to take the planes from the terminal or from the tarmac and put them onto just prior to the runway, so that they could ultimately get the air traffic controller that would say you are cleared for takeoff. Or, so that's the one aspect. I have a fairly good understanding. I would invite my friend, if he's prepared to make the call to NavCan and try to set up maybe a Zoom discussion sometime after the session has come to an end, I'd be very much interested in taking part of that Zoom call with someone from NavCam, and maybe we can come up with something that we can jointly send to the minister.
And we'll go back to a video conference. The Honourable Member for Leeds, Grenville, Thousand Islands, and Rideau Lakes.
Well, thanks very much, Mr. Speaker. It's a pleasure to take part in adjournment proceedings. And my question goes back to remarks that I made in question period. And while it was a question, I'm not sure that we got a real answer. Of course, this goes back to the WE scandal. This summer, we saw the Canada Student Service Grant, the now infamous Canada Student Service Grant, presented to Canadians, worth $912 million. Excuse me. And before the program was able to launch, it was canceled. We had the Prime Minister apologize for failing to recuse himself. The then Finance Minister apologized for failing to recuse himself. And this organization, the WE organization, right at the center of it. And the reason the recusals would have been necessary for the Prime Minister and for the former Finance Minister were, of course, that members of the Prime Minister's family had been paid nearly $500,000 by the We organization. And then, of course, he turned around and gave approval for Canadian tax dollars for this organization to administer $500 million. Now, the finance minister's challenges came out of him, of course, having his daughter directly employed by this organization, him having accepted $40,000 in free vacation from this organization, and both the then finance minister and the prime minister at the cabinet table when this was approved. Mr. Speaker, we look back into very recent history, and this is the prime minister, the first prime minister in Canadian history found guilty of breaking ethics laws. We've seen that detailed in the Trudeau Report 1 and the Trudeau Report 2. Of course, that was in the first instance, the prime minister's trip to Billionaire Island, and in the second instance, his interference in the criminal prosecution for his friends at SNC Lavalin. Now we have an issue that will be the subject of the Trudeau Report 3, coming from the ethics commissioner, where we have this situation where his family, the prime minister's family, received $500,000, and he turned around to give that organization $500 million. So what happened when the committee investigations got too hot for the prime minister on the eve of documents to be disclosed to the finance committee, documents to be released to the ethics committee? The prime minister shut down parliament. Now, we don't have to remember too far back into history when this prime minister said that sunlight was the best disinfectant. And when the prime minister prorogued, he said, there'll be lots of time for questions when the House resumes. Then the House resumed, and what did we have? A 40-plus hour filibuster from the Liberals at committee. So we're going to hear from the parliamentary secretary about Conservatives looking for scandals under every rock. But the question to the parliamentary secretary is very clear. If there's nothing to hide, and if this government has the courage of its convictions, why not just let these matters come to a vote? Why filibuster? Why give rise to the appearance of corruption if, as he will tell us, there is none? But we've seen them obstruct and filibuster and look to block rightful questions by the official opposition, by parliamentarians, into the conduct of this government, and it's unbecoming of a prime minister. It's shaking the confidence Canadians have in their parliamentarians and in Parliament. So we need to get back to good, ethical government. And while I look for Canadians to have that opportunity after the next election, electing a Conservative government with a prime minister from the riding of Durham, in the meantime, we need the current occupant, the temporary occupant of the prime minister's office, to do his part and to let the sun shine in.
Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker. I'm sure you wouldn't be surprised to hear we already have good, ethical government. A government that understands and appreciates the importance of accountability and transparency. Just because you have opposition parties that say this is a scandal doesn't make it a scandal, Mr. Speaker. I, unfortunately, didn't have the opportunity to participate in a lot of the discussions that were going around it because of other commitments, primarily, Mr. Speaker. But I would not concede to the official opposition that it is this huge scandal that they talk about. And, you know, it's interesting. My friend makes reference. He says, well, and he did it today in his 3 or 4 minutes. He said, you know, we have the first prime minister that's been held in violation of the ethics commissioner, or something of that nature. It was Stephen Harper that brought it in. So it's not like it was there for other prime ministers. But the member tries to give the impression that, whoa, this is a real bad prime minister because, after all, the ethics commissioner found a couple of examples where the prime minister had made some mistakes, of which the prime minister owned up to it, apologized where he needed to apologize, Mr. Speaker. The Conservatives in opposition, their focus has always been, since day one, to what I've classified as character assassination. Who cares what the policies are? Just go after the prime minister or the minister of finance, any minister, and just talk scandal, whether it's there or not. That's what they want to talk about. So then he makes reference to this filibuster. Oh, the Liberals, they're bad because we've been doing 40 hours of filibuster, as the Conservatives try to be somewhat mischievous and look under every rock to find scandal, where they are calling for civil servant after civil servant to be able to come before the committee. Well, I think my colleagues did a good job in terms of ensuring that this government continues, even though the opposition continues to want to look for things, Mr. Speaker, dealing with made up in some cases areas or conspiracies. We continue to be focused on the coronavirus. And that is something that's been clearly demonstrated, as they would rather see the civil servants working at trying to answer questions about conspiracy. We prefer to see the civil servants doing what they do best, and that is servicing Canadians by minimizing the negative damage caused by the coronavirus, Mr. Speaker. That has been our priority. And I think it's demonstrated with the many different programs that we have introduced. You know, we've been talking a lot about vaccinations lately, Mr. Speaker, justifiably so. And I asked the opposition just the other day and during the debate, where was the opposition during the summer when they had thousands of questions in July and August talking about the vaccination issue? But no. They wanted to fan this whole notion that there's this huge scandal that's out there, Mr. Speaker. There was no huge wee scandal, Mr. Speaker. Yes, there were some mistakes. And those mistakes are very well established, Mr. Speaker. But the government continues to focus its attention. As much as the Conservatives want to try to divert it, we are continuing to focus our attention on the coronavirus. I would encourage my friend to try to influence his caucus colleagues to do likewise. Thank you, Mr. Speaker.
The honourable member for Leeds, Grenville, Thousand Islands and Rideau Lakes.
Well, thanks very much, Mr. Speaker. While the member opposite never fails to disappoint in his responses to my comments and questions, but look, of course, the Conservatives brought in these accountability measures. And of course, Conservatives weren't found guilty of breaking any of them because we didn't. But then Canadians elect a Liberal government, and they immediately fall into the trap that Conservatives set for them. And that what was the trap? Don't break the law. Don't break the rules. It proved impossible for the Liberals. There's nothing needed to be fabricated and no conspiracies that need to be formed. We've seen it time and time again with these Liberals. They just can't help. The only thing they want to do other than help themselves is help their well-connected insiders. So the member opposite needs to implore his colleagues to do the right thing, let the sun shine in, and guess what? The opposition can hold them to account on financial matters, the pandemic response, but also on their ethical transgressions.
The Honourable Parliament Secretary.
Yes. Thank you, Mr. Speaker. And I can assure the member we are doing the right things. When there have been mistakes that have been made, and it's not to say that we have been an absolute perfect government, Mr. Speaker. There has been areas in which we have made some mistakes. And when that has occurred, we've owned up to those mistakes, and where necessary, we've apologized for that, Mr. Speaker. We continue to work cooperatively with the Ethics Commissioner and other independent offices of Parliament. But let there be no doubt, we are going to continue our focus on combating the negative impacts of the pandemic and supporting Canada's middle class and those aspiring to be a part of it, Mr. Speaker. Those are the priorities of this government, and that will continue to be the priority of the government. Thank you, Mr. Speaker.
Alors, la motion portant que la Chambre.
So now the motion to adjourn the House is now deemed to have been adopted. Accordingly, this House stands until tomorrow at 2 p.m. pursuant to Standing Order 24-1.